the level of data on that text message conversation alone dwarfs everything else on the shooter's phone. You'll hear evidence that there were over 22,000 text messages in just 1 year between the shooter and his friend. Those two shared quite a bit with each other. This is the friend that the shooter confided in when he asked his father for help. That friend was taken from the shooter at the end of October of 21. He didn't just move schools and go to another town. He was taken out of state without warning, without notice, and without a way to communicate. The impact on the defendant's son was severe. His entire social connection was severed, and James was there to know about it. You see, he wasn't working at that time. From November the 1st to November 9th, he didn't have a job. And when he did work before that, it was from home. When he did get a job on November the 10th, it was for DoorDash, where he could set his own schedule and decide when he did work and when he didn't work. It was also during this month of November that the defendant's son began to write an adjournment. Some of that is going to be permitted to be shown to you, and Judge Matthews decides what you see and what you don't see. The portions you'll see is that the defendant's son wrote about how he was begging his parents for help, how he's begging for a more powerful 9mm handgun to commit the school shooting, and how he was able to obtain access to the murder weapon. Again, this evidence is important for you as background to what happened on November the 30th, but it also gives you a glimpse into the level of knowledge possessed by James Crumbley when he made the decision to buy that 6-hour 9mm handgun for his son on November the 26th, and then, just as importantly, what he decided not to do the morning of the shooting. You see, James Crumbley was afforded what might have been the easiest and most glaring opportunity to prevent the shooting, a full 3.5 hours on November 30th before the first shot was ever fired. Because he was shown this. This is a math worksheet. These are drawings and writings from the defendant's son, November 30th, 2021. One of his teachers saw him doing this, took a picture of that, and sent it to the shooter's counselor. The counselor came down and took the shooter out of class, brought him to his office to find out what was going on. You will learn it took that counselor all of 20 minutes to decide that immediate parental intervention was required. He made that decision even though he had about a fraction of the knowledge possessed by James Crumbley. You see, this drawing, as well as an altered version created by the shooter, were both sent from that counselor to Jennifer Crumbley, who shared it immediately with James Crumbley before they arrived at the school. The severity of the situation wasn't lost on James or Jennifer Crumbley either. They expressed their concern about what they see here, the words "help me," blood everywhere, a picture drawing of a gun, of a person with 2 bullet holes in blood. They expressed their concern about that drawing to themselves in Facebook messages. This is Jennifer Crumbley, she's in blue. "Call now," all caps, emergency. This is November the 30th, 2021 at 9:33 in the morning. Followed simply with emergency. Then she sends her husband James, the defendant, both the original drawing as well as the altered version of it that the shooter created. That's at 9:38 in the morning. James Crumbley's response, "My God, WTF." And then he says what he was actually doing that morning. "Vet not here. It's McElmurray's Procura's horse. Still waiting on the vet." You see, James and Jennifer Crumbley spent quite a bit of time away from the home, tending to their horses. That's what he was doing the morning of the shooting. Jennifer Crumbley, he said he was distraught about last night. "James, we talked about it this morning." "You talked to him?" "Jennifer, can you call?" Then heading to his school, "I'm very concerned." That was at 10:04 in the morning. Unfortunately for everyone, they kept that private concern to themselves. They didn't share it with the school counselor. Despite what they knew, despite what they thought, James Crumbley and his wife, neither one of them, mentioned anything about the gun being purchased for him 4 days before the shooting. James Crumbley didn't say a word about how that picture of the gun that his son drew looked identical, that you will see, of the 6 Sauer 9mm. They didn't say anything about the prior request for help. James Crumbley didn't mention anything about the severity, the real circumstances of the shooter's friend being taken from him. They didn't just fail to inform in that meeting note. They also failed to act. It was recommended at that meeting that James and Jennifer Crumbley get help for their son then, immediately, that day. And they were provided with a list of resources with mental health providers that would fit any budget, any insurance plan, or even no insurance at all. But they didn't. James Crumbley didn't do anything. Jennifer Crumbley didn't do anything. Neither one of them called. They didn't take him home. The reason given to the counselors that they had to work. But James didn't mention that as a DoorDash driver, he set his own schedule. He didn't mention that he hadn't even signed in for the day for DoorDash yet. He was at the vet. Or that as a DoorDash driver, he was able to just put his son next to him in the car. It was one of the most glaringly missed opportunities. But instead of seizing that incredible opportunity that was before him, James Crumbley spent the next 2 hours driving around town making deliveries. Never once bothering to stop by his house, which was just a mile away, to check on the whereabouts of the gun that his son drew. Even when he drove by the house to do so. Never once. The gun that he knew was kept unsecured. That is until after the Oxford School District sent out an email blast to all district parents of an active shooter situation. You'll learn that that email reached James Crumbley about 1:10 p.m. And by pure happenstance, James Crumbley was at the exact location that parents of Oxford high school students were told to go in case of emergencies. Their reunification point was the mire on Ray Road next to the high school, directly adjacent to it. By pure coincidence, he happened to be at the exact location where hundreds of people were scrambling to get to. But he didn't stay. That's when he went home. That's when he went home to look for the gun. And that's because he knew. You will hear that there was one and only one person who called the police that day to identify their kid as a suspected shooter. It was James Crumbley. This nightmare, these murders, were preventable by him, foreseeable by him. During this trial, you're going to hear from between 15 and 20 witnesses. I do need to tell you that you won't hear from the shooter. Neither side is entitled to call him to the stand. You won't hear from Jennifer Crumbley. Again, neither side is entitled to call her to the stand. But you will hear a lot about what happened in the days, the weeks, the months before the shooting, specifically November the 26th and November the 30th. Again, those were the critical days. What happened from the 30th, from the time of the meeting to the time that first shot was fired. You're going to learn that throughout the investigation, investigators obtained information from social media accounts, from cell phone forensic analysis. They obtained banking records. They obtained GPS pings. So you're going to be able to put together a bit of a digital footprint of the Crumbley life. You're also going to learn what James and Jennifer Crumbley did after the shooting. Evidence will be presented to you to show that the defendant and his wife withdrew as much cash as they could, and they tried to liquidate their assets. They were found hiding from the police in the city of Detroit in an art studio on December the 4th, 2021. That's after they were charged with these crimes. Which you will never hear, and I want to make sure this is clear, you will never hear any allegation that James Crumbley knew what his son was going to do on November the 5th. That he bought the gun knowing what his son was going to do. If he bought a gun knowing his son was going to commit mass murder, then he'd be charged with murder. There is no claim that James Crumbley gave his son that firearm hoping he would murder 4 students. So then the question becomes, how is it that a father can be held responsible for the intentional acts of a teenage son? And the answer to that question is twofold. There's two reasons. First, it's important to remember that James Crumbley is not charged with murder. He's charged with involuntary manslaughter. Murder, or aiding and abetting murder, is an intentional crime. Involuntary manslaughter is rooted in negligence. It is by definition, causation, an unintentional killing. Second, it's because it takes a rare and specific set of circumstances to rise to the level of involuntary manslaughter when there are multiple causes of death. A rare set of circumstances. Those rare circumstances you will find present in this case. It takes gross negligence. It takes causation of death. And it takes that other person's acts to be reasonably foreseeable. Those are the three elements that must be proved. And that's what Judge Matthews is going to tell you. You will learn that the law says that in this situation, there are actually two different ways to find this defendant guilty of involuntary manslaughter. You are able to pick either, because the law allows you to do so. Involuntary manslaughter is committed when someone's actions or inactions are grossly negligent, or their failure to perform their legal duty as a parent was grossly negligent. Negligence caused death, and not the cause. It was a cause of death. And that's important, because the judge is going to tell you that there may be more than one cause of death, such as this situation, as long as that other cause was reasonably foreseeable to him, to the defendant. Not to everyone else in the world, but to him. The father who bought the gun, the father who raised the shooter, the father who knew what was going on in his life, the father who suspected him as a school shooter, well before his name was made public, well before anyone from the police department told him it was his son. The law allows multiple people to be held responsible in this case. And that's going to come to you from Judge Matthews. Gross negligence is the failure to use ordinary care to avoid a known danger, even though it was apparent to a reasonable person that serious injury would result. It's the willful disregard of danger. And that, ladies and gentlemen, is why we were here. James Crumbley's willful disregard of danger and his failure to use just ordinary care, when he was the one who knew the background, he was the one that knew the origins of this drawing. Him sitting in that counselor's office, looking at this drawing, and then not only staying silent, but then his failure to act. Right there is his willful disregard of danger. Right there. You're going to hear a lot of evidence and arguments in this case. It's important that we all understand that you're not here to decide on parenting. This case isn't about parenting. It's not illegal to be a bad parent. It's not kids doing kids' things. We're here to talk about a preventable mass murder. No one will ever suggest to you that every parent can or should be held responsible for everything their teenager does. That's not the law. No one will ever suggest that to you. But in a situation where the father was in a position to reasonably foresee what the son was going to do, because the father armed him 4 days before and was shown a clear statement of intent of what the son was going to do, that is when that rare set of circumstances is present in the specific set of facts. James Crumbley is in charge with what his son did on November the 30th. James Crumbley is charged with what he did and what he didn't do on November the 30th. That is a very important distinction. That is what the law allows. That is what we were asking you to do. This case is not about guns. It's not about even how all guns should be stored in the home. It's not about gun laws. This case is about this gun for this kid with these issues not secured when shown this picture. That's what this case is about. When this kid was begging for a more deadly weapon, that's why we're here. I ask that you listen to the testimony, you review the evidence, and you follow the law. If you do that, you will undoubtedly reach a fair and just verdict. If you do that, you will find that James Crumbley was one of the 3 people in this world criminally responsible for what happened on November the 30th, 2021. And you will find him guilty as charged. Thank you.
Thank you, please. Ms. Lehman, would you like to make an opening statement at this time?
Yes, Your Honor. Thank you.
Go ahead.
The events of November 30th of 2021 undeniably changed people's lives in ways that most people could never imagine. 4 children lost their lives. Families were destroyed, and a community was terrorized. But this case is not about what happened inside of Oxford High School. This case is about what happened outside of Oxford High School. The prosecution alleges that James Crumbley was aware that his son was a danger to others, and that he failed to protect other people from his son. The prosecution alleges that James Crumbley had knowledge that his son could and would hurt other people, and that he failed to protect those people, that he failed to take steps to protect others. And ladies and gentlemen, that simply is not true. You will hear evidence in this case of what occurred inside of Oxford High School. You will hear the prosecution's version of what they claim James Crumbley may have known. You will hear that a gun was purchased on November 26th of 2021 by James Crumbley. You will hear what kind of a gun it was. It was a handgun. You will hear how it was stored. You may hear where it was stored. You will hear whether or not Mr. Crumbley's son knew where that firearm was. Pay attention also to what you don't hear. Pay attention to that you won't hear that James Crumbley knew that his son knew where that firearm was. Ladies and gentlemen, James Crumbley was not aware that his son had access to that firearm. You will hear testimony that access was not allowed in James Crumbley's mind. Ladies and gentlemen, you will not hear that James Crumbley knew what his son was going to do. You will not hear that James Crumbley even suspected that his son was a danger. That math homework that the prosecution is putting up on the screen, you're going to hear about that. You're going to hear about what other people thought about that. People at the school, including James Crumbley. There's going to be probably quite a bit of discussion about that piece of math homework, ladies and gentlemen, and you're going to hear all about it. Ladies and gentlemen, James Crumbley did not know what his son was going to do. He did not know that his son could potentially harm other people. He did not know what his son was planning. He did not purchase that gun with the knowledge that his son may use it against other people. You will not hear that he did that. The prosecution told you that. The prosecution just told you you're not going to hear that. You're not going to hear that James Crumbley purchased that gun with the knowledge that his son was going to go harm other people. But what the prosecution wants you to believe, the part that's not true, is that James Crumbley knew what his son was going to do and knew that he had a duty to protect other people from his son. Ladies and gentlemen, that's not true. He didn't know. You're going to hear about James Crumbley's relationship with his son. There may be other witnesses who testify about that, about how James interacted with his son, including on the day when that math homework was shown. You're going to hear from other people. They're going to tell you, in their own words, what they observed about James Crumbley and his son, about what they observed about his son about any concerns they may have had. Other people, not just James Crumbley, but other people with additional education, additional training to evaluate situations like this and evaluate individuals. You're going to hear from those people probably. And they're going to tell you in their own words what they thought about the math homework, about Mr. Crumbley's son, about Mr. Crumbley's interactions with his son. Yes, James Crumbley was a DoorDash driver. We all know that. It's been said multiple times. Ladies and gentlemen, being a DoorDash driver doesn't mean that your job is any less important to you or other people than any other job. It doesn't mean that you don't feel that you have a duty to go to work. And ladies and gentlemen, when you're not aware of an immediate, imminent danger, why would you do anything different than what you normally do? You wouldn't, because you don't have any reason to think you need to. So ladies and gentlemen, you're going to hear the evidence. You've heard a lot of questions in the last couple of days from both the prosecution and myself. You probably have an idea where each side lands on these issues. But you're going to hear the evidence. You're going to hear from people other than us. And you're going to be able to hear in their words what they thought about those days from November 26th to November 30th of 2021. And their feelings, what they observed, any concerns that they may or may not have had. The prosecution has asked you repeatedly to follow the law. I'm going to ask you to do the same thing. Please do follow the law. And I'm confident, we are confident, that if you do that, if you follow the law, that you will find James Crumbley not guilty. Thank you.
Thank you, Ms. Lehman. Should I give you a little break?
We had a little break.
I'm going to give you a little break, so you might have to do a little bit of setup in the courtroom, and then you're going to hear the first witness, okay? So for about 10 minutes, about 5 of your time.
All rise for the jury.
May counsel have Kai from briefly when the jury's out.
Mic off, Your Honor.
Yeah, can you turn the microphone off?
All right, lawyers are approaching the bench right now, so audio has been cut, but this is the trial now, day one, for James Crumbley, the father of the Oxford school shooter.
And we want to bring in our legal experts now to weigh in on the trial thus far. Attorneys Arnold Reed and Rick Convertino are here with us and will be here throughout the day. Thank you so much for being here. So Rick, what were your impressions of opening statements?
Very different from the first trial. It seems we have a competent defense attorney in this case, and she made very relevant points. Looks like it's going to be a battle. Some of the things that came to mind during the prosecution's opening that were different than the first trial that I think are important. And remember, after the first trial, the prosecutors got the opportunity to debrief the jury who rendered the verdict on Jennifer Crumbley. And so they made some changes. They tweaked the case a little. One of the things that was important, I think, was that they said there are three people responsible: the shooter, the mother, and the father. And the shooter's case is done, and the mother's case is done. So the jurors who are aware, and there are, I think, the majority of them, all but two, are aware of the first trial, are aware that the mother was convicted. And so that puts in their minds that they may want to follow suit. In other words, I think it's predetermined nuance that was planted in this jury, that the three people that are responsible too are already convicted, and you have the third. One of the things that was important, I think, regarding this, the first trial, the defense was, among other things, this is a slippery slope. In other words, you know, an average person, an average mother and father, could be convicted of this if we go down this, you know, involuntary manslaughter for the actions of a son or a daughter. And one of the things that the prosecutor said, I think, to front that was that there are two things that are important One of them is that this is involuntary manslaughter, and then went through the elements of that. But the second one that I thought was critical was he said, this is a rare set of circumstances that you're going to hear, a rare set of circumstances. And so I think that alleviates in the minds of a juror, potentially, that they're not going to make this precedent-setting case law by convicting someone of an act of a attenuated child, because this is a very rare set of circumstances, and he emphasized that, which wasn't emphasized in the first case. Remember, in the first case, pardon me, what was emphasized, this was just ordinary care that he could have easily prevented this, and he went through that in the second case, but he didn't talk about this case being rare and very, very unusual and unique in the set of facts that are going to be presented to the jury, which may allow the jurors to have an ease of mind in coming to a guilty verdict. At least I think that's what the purpose of that was.
All right. In setting the stage, clear arguments there on what James knew and didn't know. Arnold, what are your takeaways?
Well, what you saw from the prosecution, from my perspective, was really a closing argument disguised as an opening argument. There's no question about it. The prosecution did three things: hook, setting, imagery. Hook, setting, imagery. His hook was 32 times shots were fired. In 9 minutes, he had him. That's the hook. And so then he leads into the setting. He's going in, setting the stage about what they were doing, how they were running, how they were scrambling. So he's continuing to keep the jury's attention. Should have, in my opinion, went a little bit more with that. And then the imagery. The imagery. He's trying to make the dad look bad, trying to look like a deadbeat dad. He was unconcerned. He knew what this kid was going to do. He took him to the range. So he's painting a picture to the jury of the imagery. He went a little bit too long, and sometimes when you have exhibits up behind you, it takes the focus from the jury on what you're saying, right? So I would have had a little bit less use of the imagery. Give it to them in the case. Pop it on them in the case. Leave something for them to be on the edge of their seats, right? And sometimes it can distract the jury from what you're trying to tell them. So overall, one other thing he did I thought was good. Easily preventable, easily preventable. That was very powerful. He had all these opportunities and he missed them. I give him B+.
All right, if you're watching with us over the air, we do have to wrap things up here, but we're going to continue this conversation on the stream. That's our website, cbsdetroit.com, Pluto TV, and the CBS News app. We're going to have gavel-to-gavel coverage for you as this trial continues. Day one for James Crumbley, the father of the Oxford school shooting.
All right, welcome back to CBS News on the stream, where we continue our coverage of the James Crumbley trial today. Still with us are Rick Convertino and Arnold Reed. Arnold, before we came off air, you were giving your take on the opening statements. What did you make of the defense?
Much better, as Rick said, than the last go-round. This is a seasoned attorney. She's been practicing about 11, 12 years out of Shelby Township. She's had previous murder trial experience. This is a tough case. And I don't want to be too overly critical, but I thought she could have done a much better job. She repeated a lot of things to the jury that the prosecution said, right? So under the theory of primacy, it's what a jury hears first and what you continue to repeat. So under the theory of primacy, the jury's heard about the guns, heard about the dad doing something that he wasn't supposed to do. Everything she said was prefaced by you'll hear. And it was just a repetition of what the prosecution said. So if I'm sitting there, I'm thinking that this jury's got in their mind definitely what dad should have done and what he should not have done. Again, it was better than the first. This is a tough case, don't get me wrong. But she's saying things like, dad didn't purchase the gun. You won't hear he purchased the gun with knowledge his son will hurt someone. This is not an element even of the case. You don't have to have proved that he purchased the gun with knowledge that he's going to hurt somebody. That's not even an element of the case, right? And so her saying that kind of was wasted airspace, in my opinion. I would have liked to see her get up there, be aggressive, and say he did all these things, but it doesn't amount to gross negligence. This was a perfect opportunity for her to use the elements of the crime and show that her client's behavior didn't fit. Gross negligence is just under intentional conduct. I would have argued to the jury that there's no evidence in this case that shows that her client intended for this to happen. That's what gross negligence is. When you got a tough case like this, you got to walk the jury instructions line. You got to tell them what the law is, show them how your client didn't do it. Just don't stand up there and repeat what the prosecution said. She gets a C.
This is a tactic we saw in the first trial of Jennifer. We saw Shannon Smith repeating a lot of what the prosecution was saying. It seemed like with really no direction. I mean, even the opening sentence was almost identical to the prosecution's in this case. I mean, I understand admitting that it is a horrific case, acknowledging the terror he caused, but yeah, but still, I agree, better than what we saw before.
And one other opportunity too is not to cut you off, but this is very important. When there is a plethora, a dearth of evidence, the gun, the notes, in front of that jury, if I was the defense attorney, I would have walked right over to that prosecution table and grabbed one of those notes and had them in my hand. Get them desensitized to what the prosecution is going to come out and surprise them with on their direct case. I've even sometimes in opening statement took the gun. Sometimes the prosecutions will have the gun in an envelope. And when they're in front of the jury, they're taking and unwrapping and you hear tearing sounds and the jury's on the edge of their seat and they pull out the gun. Well, I'll do it for them. You go get their evidence, put it in front of the jury, say it's not a big deal, it doesn't prove the elements of the crime. He could have bought that kid 15 guns. It doesn't mean that the dad knew that the kid was going to go shoot somebody. So I thought it was a squandered opportunity to diffuse some of the power and impact of these salacious facts that are on the side of the prosecution that she missed. That's why I give her a C.
All right. If you are just watching with us right now, court is in a break. We're told it'll be about 10 minutes. At this point, though, we want to take a look back at how we got to this point. Check this out.
We find the defendant guilty of involuntary manslaughter.
Last month, Jennifer Crumbley was convicted on 4 charges of involuntary manslaughter, and now it's her husband James Crumbley's turn in court.
I have done terrible things that no one should ever do.
Their son Ethan is serving a life sentence for shooting and killing 4 students at Oxford High School in 2021. He was 15 years old. Days before the shooting, James Crumbley gifted their son the 9mm handgun used in the attack. During her trial, Jennifer tried to argue that securing the weapon was her husband's responsibility.
It was more his thing, so I let him handle that. I didn't feel comfortable putting the lock thing on it.
Crumbley and his wife are accused of ignoring the shooter's mental health issues in the months prior. The morning of the shooting, the Crumbleys were called to their son's school to discuss a drawing he made showing a person bleeding from bullet holes with the written phrases, "Help me, and my life is useless." The parents left after the meeting. Less than 2 hours later, Ethan Crumbley opened fire.
Not only did he not take him out of school that day, he did not tell the school that he had recently purchased the gun. Very difficult case for the defense.
Jennifer Crumbley now faces up to a 60-year sentence. If convicted, James Crumbley faces the same penalty.
Could we see James Crumbley potentially take the stand in this trial?
James Crumbley almost has to take the stand to differentiate his behavior, his actions, from that of his wife.
For CBS Mornings, I'm Elaine Quijano.
So, Rick, is this an easier case for the prosecution, do you think? I mean, right off the bat, they said James purchased this gun.
I think it is. I think the facts favor the prosecution more so than in Jennifer's case. I agree with a lot of what Arnold said about the closings, about the opening statements of both, and the primacy recency theories of how to present your case. I think the defense did a better job than Arnold did. I mean, primarily because I'm comparing it directly with the opening of the previous attorney in Jennifer's case. It was kind of like the opening statement in, you know, My Cousin Vinny. If you remember that movie, the prosecutor went, and then Vinny gets up, and basically his opening statement was everything that guy just said was bullshit. That's kind of what it was like. Although she made some good points at the end. You know, she said that that professionals, people who were trained in this area, viewed the same things that James and Jennifer viewed, and were totally unconcerned. She said that she was fronting off some of the issues that the prosecution made about the DoorDash. I think that was good. That why would he do anything differently if he didn't believe that there were any imminent danger? Certainly anyone who believed that there was some concern, even a small amount of concern, would have acted at that point. Now that's her defense. She didn't use any notes, which I always like. I think an attorney who's wedded to notes and PowerPoints and that kind of thing, I think that's very ineffective. It was a practiced and rehearsed opening statement. She didn't falter at all. She didn't pause. She was direct in what she did. She went from A to B to C to D in a quick and orderly manner. I think that was good. I think she had the jury's attention. I would give her a better grade than a C. And I think the prosecution, for all its good points, did a very good job in presenting its case in a structured, orderly manner. I think that they made all the points that they have to, and I think it was powerful.
Now, considering that James is the one that bought the gun, excuse me, Arnold, what do you think they're going to have to do as far as the defense goes to have a stronger argument in his defense?
Ladies and gentlemen, who can read my mind? Nobody can. What the prosecution is asking you to do is read my client's mind when he purchased that gun. Read his mind to say that he knew what his kid was going to do, and requires him to read his child's mind.
But here's the thing.
See what I'm saying?
Excellent.
See what I'm saying?
Yes.
That would have given her, I think, stronger legs. I agree with everything my colleague is saying. But you got to come hard.
But here's what the prosecutor said, Arnold, on that very point. You can't obviously read the mind. It's an excellent point and a good technique. But the prosecution said he was begging for a more powerful gun. Begging for a more powerful gun, action taken. He got a more powerful gun. Begging for help, begging for mental help, begging for wanted to go to see somebody for his mental health. The child, he was aware that he was in turmoil and downward spiral, begging for that, no action taken. So those are the ways that I think that the prosecution is going to get at the mind of James Crumbley.
Right, excellent point. Let's juxtapose that for a minute in the counselor's office, right? Where the counselor's looking at the notes. The counselor sees all these things. This is an excellent opportunity for the defense to say, if the counselor didn't see it, how do you expect dad to see it? Why didn't the counselor call the police? Why didn't the counselor say, hey, you've got to take him right now. We're going to call somebody, get a court order. We're going to do something, right? So that's an excellent point, but I think what the defense has to do is show that dad is not the only one who was in a position to know. The counselors were, and if they didn't know, how should the dad know?
Right, but here's what the prosecution will say on that. The counselors thought that was a random gun drawing on that sheet of paper. Dad knew it was the very gun that he purchased 3 days before. Mom knew it was the very gun they purchased 3 days before. The dad also knew that the day before, the kid was in some kind of some kind of crisis. The night before, you remember from the first trial, the night before, the evidence was that he was kicked out of the house, wasn't allowed back in. So great points all, but I think the prosecution is going to come back with that to show, these people were, as they pointed out, uniquely situated to know the whole picture, the totality of the circumstances were in the hands of two people, the mother and father. Going back, the unique circumstances that they were pointed out, that it has to be gross negligence, and these set of facts are unique, I think circumvents and alleviates the jurors from that slippery slope concern that I think jurors will have. Well, if we convict this person, and that was the part of the defense in the first case in the closing, You remember the attorney was saying, you know, hey, I'm guilty. You know, you remember she bringing in her own family and her own personal circumstances and saying, if my client's guilty, I'm also guilty. I think that the prosecution was aware of that, in this case, keenly aware of that, and therefore, you know, said, no, this is not the ordinary parent. This is not even a bad parent. This is somebody who is in this unique set of circumstances and ignores obvious and ordinary facts that can be prevented.
You could tell the reset. You could tell the reset. Well, I think the general consensus is maybe Rick and I need to step in that courtroom and handle a little business.
Yeah. I'd love to.
I'd tune in. So, you know, just to draw another contrast between this case and Jennifer's is in the opening statements for the defense, she did not allude to the fact that the defendant will take the stand. Whereas in the first trial, she pretty much said Jennifer will take the stand, which was stunning, right? It was stunning to everybody. So what can we expect at this point, Arnold? It's open-ended.
I think, you know, as I've said before during the first trial, jurors sit there and they think that guilty people don't testify, right? I think she didn't say it in this particular case. Maybe A, she doesn't think that's going to get her any mileage, but B, maybe she is not sure right now in this moment whether he's going to take the witness stand or not, and maybe she just didn't want to put it out there. So we'll have to see as this trial unfolds what she does, but it could be she just hadn't made up her mind.
Do you think he should?
There's no question about it. He should get up there, of course, and I'm hope, other than what we saw last time, that he is well prepared, that they have met, they've talked, they've conferred, and that he comes off as a parent who was sympathetic, but just didn't know that his kid was going to take this ultimate act. Yeah, he bought the guns. I know plenty of parents that go to the gun range with their children. Does that equate to him knowing that this kid was going to do what he did? So he's got to come off to the jury as extremely credible, because it's always a danger in putting your client up there.
Yeah, the other thing that, I'm sorry, Terrence, just to pick up on your point, Meredith, the other thing and the more and very important thing that was not included in this opening statement was that this parent, this defendant, was not a hyper-vigilant parent. Yeah, that was stressed. And so when you promise a jury that, and then you show evidence that she's meeting her paramour behind the dumpster at the Costco's, you know, instead of going to work like she said she had to do, and all of these, you know, outrageous personal conduct acts, yeah, that's not a hyper-vigilant parent. Somebody who tells their child, suck it up, cupcake, and is more concerned about their horse than they are about their child. When you're telling a jury this is a hyper-vigilant parent, I mean, there's not a person on there who believed for 1 millisecond that this was a hyper-vigilant or a vigilant or a good parent. And so that detracts from the credibility of not only the attorney, and then when the client testified, her credibility was lost very soon into her testimony, I thought, by showing that she lied, lying a little thing, lying a big thing. And I think it was, you know, just a terrible strategy to tell the jury the two things that she did. One, my client will testify, and two, she is a hyper-vigilant parent, and you'll hear evidence of that, which we didn't.
And we know how important first witnesses are in these cases. What do you think we can expect today? Will it be a copy-paste of Jennifer's trial?
I think in part and parcel it will be. I mean, if it's not broke, don't fix it, right? I think you're going to see some of the similar things with maybe a few twists, but I think the prosecution team is smart enough to understand you're putting the witnesses on that are going to support what you just told the jury in opening statement, right? And that's important because one of the things that I wrote down is when the defense said, you're not going to hear any evidence that James Crumbley knew his son knew where the gun was. Come on now. That was a 2-bedroom house. That's not a house in the Hamptons. Come on. 2 bedrooms. Wait till they see the pictures. It's not necessarily what he knew, but it's what he should have known. So you got to be careful in opening statement not to go out there and say things you can't back up. So what I'm expecting to see is that the prosecution is going to put on witness after witness after witness that backs up their theory.
There's an argument that the parents both have shared responsibility for what happened here. Do either of you think it's more damaging for James that he purchased the gun versus Jennifer?
I think the facts of this case are stronger for the prosecution than they were in the first case. I think that was a more difficult case because of the hands-on effect of the things like purchasing the gun, being responsible for securing the gun. As Arnold said, it was a small house. Jennifer said that they hid the key in a beer stein and they were unaware, but then the evidence in the first trial was that the lock was never used, that it was in the same condition. And to Arnold's point, there will be additional evidence in this case that we know of that was not presented in the first case, and most notably about the lock in the gun, and that is by the person who first purchased this gun, the 9mm Sig Sauer, and then returned it to the gun store in the same condition, that the lock was in the same condition that it was found in by the ATF agent in the search. So unused, unopened in the bottom. You remember in the gun case under the foam was where the lock was. So so that testimony will be new, that the first owner of the gun. The second thing that's going to be new that we know of is the prosecution wanted to admit 2 students who were shot in that hallway, 200 hallway. And they wanted to admit those students, as the prosecution said, because there's no other witnesses to testify because the other ones in that hallway were killed. And the judge this morning, we heard, allowed one of the 2 witnesses, and she's going to allow the prosecution to pick that witness, whichever witness he or she, the prosecutor wants. And that will be very, very powerful evidence. You know, one of the students who was actually shot in that hallway 200.
Mm-hmm. And it's really, you know, as you said, sort of proving the point of the prosecution, driving that home and the imagery, bringing you into the scene. No one can tell that story like these students.
Mm-hmm. No question. And the stage is set here. The stage was set by the prosecution. And the jury is expecting to hear from witnesses. I think that they are really anticipating hearing what these witnesses have to say. And when this child comes on and testifies as to what he saw in that hallway, the struggle, the fear, the emotion, the turmoil, that is going to strike a major chord with one or all of those jurors. That could be the Waterloo for the defense right there. That one witness could be the Waterloo.
And only a fool would cross-examine that witness, right, Arnold?
Exactly. Well, I mean, what would you say to the witness? Yeah. Do you know what I'm saying? I mean, what possibly could you ask that witness?
Well, in the first trial, it seemed like she was unable to stay seated, had to cross-examine every witness, you know.
Yeah.
And in a situation like that, you'd never want to cross-examine a child who was shot. Yeah.
Never, never.
Mm-hmm. And in the first trial, even saw tears, emotion from the defense attorney after seeing video from the shooting, claiming she'd never seen it before. It was.
She'd never seen it before because she didn't access the evidence that was available.
Mm-hmm.
Exactly, and we had a big discussion about that last time. Remember, the day of trial, you're arguing all these motions that should have been argued months ago. It's no question that this trial has a different complexion in terms of the preparedness, the readiness of the defense lawyer. She was ready. She had a short closing argument, short, sweet, to the point. So I'm anticipating that she's going to be able to diffuse some of the arguments about her client's knowledge as this trial goes on. Now, the question, we come back to whether he should get on the witness stand or not. Yes, he should, because there's no one that can tell the story about his knowledge and what he should have known or didn't know but him. Who else is going to do it? They've got this mountain of evidence out there suggesting that he should have known. What else do you have as a defense attorney other than your client to come on and say, hey, I didn't know, and here's why I didn't know?
Mm-hmm. Yeah, it'll be interesting to see how it plays out. So we do know, just looking in the monitor over there, we do see activity in the courtroom, but we don't have any audio there yet. Once it starts, they were supposed to take a 10-minute break. It went a little bit longer, as it does sometimes in court, but it will be interesting to see how this plays out differently, particularly from the defense's perspective. So, just repeat again, Rick, is this case being presented differently than Jennifer's from the prosecution? It did seem like they did tweak a few things.
I think they did. I think they used the advantage of speaking to the jury after after the first verdict and getting information that would help them in the second case and in this case. And I think they also tweaked the witness list a little bit by excluding some and then adding a couple more witnesses. And I think you'll see some kind of trying to freshen up the case, but keeping the powerful underbelly, in the face of the jury throughout the case. So I think it'll be the same case. Meredith, you handed Arnold and I a copy of the juror questionnaire. And so if we have time, I'd like to talk about that and get Arnold's perspective on this too, because I think this is, worthless. It's not even worth copying the paper and handing it out to the jurors.
1,000%.
The first several questions, were you or anyone aware of the shooting? Are you anyone associated with any of the witnesses? Are you aware that there was another trial involving James Crumbley's wife? I mean, these are all questions that could be handled by the judge, momentarily in the courtroom. There's nothing on here. There's not one question about guns.
Right.
There's not one question about a person's position on guns, which is important in this case. And so I don't know what this was for. I don't know why, this is.
Yeah, I don't know. Listen,
it's not
to
worth the
question
paper it's on.
Number 5, if you answer yes to question 4, do you believe that you can be fair and impartial?
Yeah,
Who's going to say no?
Yeah.
You know what I'm saying? I mean, this should go on file 13.
Right.
I don't know who did this or why they even put this up here, but this is absolutely useless. But I want to go back and maybe say a brief word about the judge and her demeanor. I've been impressed by the judge and her demeanor at this point, trying to move this trial along, being even-tempered, and just trying to do the best that she possibly can to ensure that Mr. Crumbley gets a fair trial, as fair as he can, and that the laws are followed and the rules are upheld. The spotlight is on this case. America's watching, right? And this has been, I think, a good exercise in judicial temperament that has really been on display here in the Oakland County Circuit Court there. So yeah. I just wanted to say a word about that. I hope that continues. The lawyers are seemingly, she's in control of this case, for lack of a better term, and that's what you want. You don't want a judge letting the trial get out of control, things happening that you could have prevented or you should have anticipated. So I think it's important just to give the kudos where they're due here. And Judge Matthews is really, as they say, she's holding it down.
Yeah, I agree.
All right, they're swearing in the first witness. I'm trying to see who this is. It looks like it could be one of the educators who was shot that day. She's appeared several times. Yes.
It is.
Yes, we heard her also in the Miller hearing.
Yes. She was shot in the Molly Darnell, correct. Molly Darnell. She was shot during the attack on Oxford High School, survived, extremely traumatized, provides very compelling testimony. So let's listen in, and we do want to warn you of images and language that may be disturbing.
Okay. Can you tell the jury what you do for a living?
I'm an educator.
Okay. And where are you employed?
I'm employed at Oxford Community Schools. I've been there since the fall of '98.
So that would be your whole teaching career?
That's correct.
Okay. What is your role now?
My role now is I am a virtual teacher with Oxford Virtual Academy. I'm a mentor teacher for middle schoolers.
All right, so do you go to the high school now?
I do not, no.
All right. Can you tell the jury what your role was and which building you worked at on November 30th of 2021?
On November of 2021, I was the International Baccalaureate Coordinator for the Middle Years program, which was a 610 program, as well as the English Language Arts coach, which was a 612 position.
Okay, so you didn't have, did you have instructional contact with students, or was it more teachers?
No, I worked with teachers, predominantly the English Language Arts department, but I worked with many other teachers throughout the 612 curriculum. It was it's a coaching job, so instructional curriculum, that type of what's happening in the classroom at that point in time.
When was the last time you had a traditional teaching schedule?
A traditional teaching schedule. might have been 2015. I'd have to really go back and look at my resume to know that.
Okay.
But in the fall of 2020, I did have a classroom. We went back face to face, and so we pulled all of our instructional coaches out to teach a few hours of the day so that we could spread students throughout the building and get students back instructionally.
Okay, so after COVID, the coaching faculty
We moved back into our,
started
yeah.
to take more teaching assignments so that you could spread kids out.
Correct.
Do I have it right?
Correct.
Okay. On November of 2021, were there kids in the school that you knew? And if so, how did you have contact with them?
There were kids that I knew from the class that I had had the previous year. There might have been, having been in the district for a long time, there were a lot of teachers who had children that were in that building. So I knew a lot of them too.
Okay. I'm glad you brought that up. Does Oxford have a lot of faculty who send their children to the district?
Yeah, I would say many of our faculty send their students through Oxford schools, yes.
Okay. And the kids that you knew in that building that day, did you also know them from middle school with this, or you just knew them?
Yeah, just knew them from knowing their parents, and or if I had them in class the year before. There might have been a kid in passing that I met here or there, but for the most part on that year I had no contact with students other than, if like a kid wanted to stop in and see me, or if we met in the hallway, or.
Okay, but did you have a traditional classroom on?
I did not. I shared an office. It was like a half classroom.
So was the classroom turned into two offices or an office?
Correct. It was a classroom turned into two offices. It was in one of the instructional halls, the math science instructional hall. And I shared it with two other coaches in the district.
Okay. You're the first witness.
Mm-hmm.
So the jury's not seen a map of the school.
Mm-hmm.
So I'm going to put that up in a minute.
Okay.
It's already been admitted. There's no objection to that. But before I do, can you just generally describe how the school is laid out? It's a fairly new building, correct?
It is fairly new. The main part of the building was opened, I think, in the fall of '98, the year that I started with Oxford Schools. And then I think it was the fall of '04 that we started, that it became the high school. So it's a fairly new building. There is like one main hallway that kind of runs up the center and it hugs into the courtyard. It almost reminds me like if you opened it in a map, you would see it almost mirrors itself in many ways, especially the area that I was in.
Okay, and your hallway were the hallways organized by subject matter?
Yes, we had like our foreign language hallway, our English language arts hallway, we had our math section, social studies, and then science wrapped around the side. Our electives were on the outskirts of the high school.
And how did the students and the faculty refer to bathrooms and exits? How did they describe them from one to the other?
It might have been like the exit by the staff parking lot. That's how I knew them.
Okay.
I know that there are numbers on all the doors. Numbers are not my thing.
You're an English teacher. Where is this? Is there a senior?
There is a
leisure
senior
area
yes.
at Oxford.
Yes. So right up that main corridor, which is like if you folded it, there's like this one main hallway. Right in the center of the building is considered the senior window, and that is right in front of our courtyard, one of our courtyards.
And the hallways go subject matter. Did you typically find upperclassmen, lowerclassmen, or it was all mixed in all throughout the building?
Well, many of the seniors did hang out in that area, or kids throughout the building. There was no area specific for like freshmen, sophomores, juniors, or seniors.
All right, I'm going to show you now and the jury what's been admitted and marked as People's Exhibit 9.
Can I get this to turn?
Yes, it should.
Can I just?
Usually it takes 6 minutes.
Yeah. Oh, okay.
That was on last. It'll take a second.
Okay. Perfect.
See it?
Thank you. Yep.
Okay. Can you tell the jury what we're looking at?
This is a map of the high school. And so you see where that, it says media center in the middle and then court right below it. When we were talking about that senior window.
Right there?
Correct. So that senior window is just south of court. Like that's the senior window, that window that is on the south end of court. No, go back. Yeah, right on like the south end of court. Sorry, south.
Okay.
Maybe I'm directionally challenged.
I think
I'm sorry, I am. I'm going to want to go north.
Okay, so what,
I guess it would be east.
what was the number for your classroom?
My number is 222.
Okay, and we'll, right there?
Correct.
Okay. And then what's in the middle area right there to,
Actually, sorry, I'm not 222, I'm 224.
okay.
I was right next door to 222.
Do you see 224?
You can't see the number, but you can see between 226 and 222.
222.
Yeah,
Okay.
there's a bunch of names written in that. That was all the coaches, myself and the other
And
coaches.
to the left of that, what is that area?
The other room on the other side.
That, can you go to that little, the bridge? Yeah, down. What is this area? What's in there?
That area on the lower end is the science labs. On the upper end, there is I can see a bathroom to the right, a student bathroom.
Mm-hmm.
And
the senior area is up?
It's up
in the
top.
middle?
Yep, it's right there.
Okay.
Yep.
All right. So I want to draw your attention to around 12:50 on November 30th, 2021. Do you remember that day?
I do.
Okay. Did you have any kind of teaching assignment on that day?
I did not have a teaching assignment on that day. It was a Tuesday after Thanksgiving.
Okay. Can you tell the jury about the Oxford lunchtime schedule? Because it's a little confusing.
We run a 7-period rotating schedule, which means that kids meet for 6 class periods a day. The lunches have a split hour, so they have an A, B, and a C lunch. If they're A lunch, they go to their class the second half. If they're a B lunch, they go to class, have lunch, go back to class. And if there's a C lunch, they go to class, then they go to lunch.
Okay, and about how many minutes is passing time, generally?
I want to say it was 8 minutes.
And what did you typically do during passing time?
During passing time, I might have gone out in the hall and chatted with a colleague or two, checked in on something. That is also a time it's like the time that teachers need to get things done. So there might be a quick interaction. I might, see a kid in the hallway passing by. But pretty often, like it was just standing guard outside my room or standing outside my room.
Okay. At around 12:50 that day, do you remember what you were doing?
A student that I had in the fall of 2020 wanted to chat, and so she came in and we chatted for a few minutes, and then she left.
Do your as a general rule, do you keep your door open or closed?
Open. All
right. And your classroom, as we see in the map, was smaller. What was the layout of the classroom? Were there traditional student desks in there, or can you explain to the jury what the classroom was?
If you walked in straight ahead, you would have seen my desk. To the left of that, you would have seen one of my colleagues' desks, and then just on the wall, like closest to the hallway, there was another coach's desk.
What is at the back of the classroom when you go in the front? The wall you're facing, what is that?
There's a large window that leads out to the courtyard.
Okay. Once the student left, what did you do?
There was a few minutes left during passing, and so I walked around to my desk and opened up my laptop.
All right, and we're going to
and check some emails.
Okay. Yep. And are you facing the door, or?
I'm facing the door. Correct.
All right. And What happened next, Melanie?
I'm sitting on my laptop, reading through an email. The door's open, and I notice a group of kids running by. It was a movement that I had never really seen before. They were moving, like there was a hyperness to the voices, and it was almost like they were pushing forward, like trying to move as fast as possible.
And that seemed unusual to you?
That was very unusual to me, yes.
Okay, why was it unusual?
I have never seen a group of students move like that before.
Because of their speed or the way that they're...
I think it was all of it. There was a speed to it, the tone of voice. There wasn't any like, my first instinct was that it was a fight, but a fight, because it was the only thing that, was the closest to what students would be moving quickly or swiftly to, especially in that large group of kids.
Did you stay seated or did you get up?
I got up. I exited the classroom or the office and moved about
in the hallway?
Into the hallway. I moved into the hallway to see what's going on.
Okay, if you look at the map, which direction did you turn? Did you turn towards
I
door 4?
turned towards door 4.
Okay.
So I turned towards door 4.
What did you see in the hallway?
I see, so the hallway kind of bends. So I come out of my office and I'm closer to that 221, but not fully there, right? I'm closer to 221, and I'm looking and I can see all these kids rushing out of door 4, which didn't make sense to me because, again, I had never seen this happen.
That's what you saw.
Mm-hmm.
Did you hear anything at that point?
It was silent. There was no noise.
Was that unusual?
Absolutely unusual.
Okay.
At that time, yes, absolutely.
And what did you do next?
I moved back into my classroom, trying to understand what's happening. And I walk back into the classroom and I'm thinking, okay, could there be a prank? I doubt there would be, and so it's probably 10 seconds, if 10 seconds. And I hear 3 things really close together.
Okay. What did those 3 things sound like?
One was an announcement, the bells chiming, an announcement of our principal coming over the PA and saying, we're moving into lockdown. This is not a drill.
Okay. When you, as a faculty member for this many years, what is lockdown? What have you been trained to know about that? What does that mean?
So we're trained in the ALICE protocol, which means we have to use our senses to figure out what's happening. But with all of those students and with what I was hearing, the 2 additional things that I was hearing was like a loud pop, 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 and then multiple doors slamming. I moved to shut my door.
Okay.
And lock myself in.
I want to stop for a minute.
Mm-hmm.
What is your experience with firearms up until this point?
Up until this point, my experience with firearms is limited. I have, however, shot a weapon. I have in my life shot a weapon.
Okay. Have you been to a range before? Is this a hobby that you have?
It is not a hobby. I have been to a range.
Okay. When you heard the pop, 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 what did you think?
I thought in my head I could have mistaken them for lockers slamming easily. They did not sound like gunshots to me, but I'm not really, I've been to a range once. I've not. I don't really know what a gun sounds like.
Okay, so what you said the three things: the announcement,
The pop, pop, pop of a weapon that I now know, and doors slamming.
Okay, and what did you do?
I moved to shut my classroom door because when I had come back in, I had not shut it. So I shut that classroom door, and we have a night lock next to all the doors.
Can you tell the jury what a night lock is?
A night lock is a device that slides into the door.
Where do you slide it?
You slide it in the bottom of the door, and it keeps the door. So on my office and all of the rooms in the building have glass partitions on the side. So if someone were to shoot out that and try to get in, it would keep that door from being opened.
Okay, I'm going to show you what's been admitted as Exhibit 10. Molly, what is that?
That's the office that I had.
Okay, so that's your door open.
Yep.
All right. And where is your... This is not a pic... Is this a picture that adequately reflects the normal...
No.
Okay.
This was...
we're going to get to why that's like that, but where is the desk that you were sitting at?
Straight ahead, there's that tall lamp. My desk was the other way.
The other way?
Yep.
Right there. Okay. So you said you approached the door, you shut it?
I did. I shut it.
And then where was the night lock?
It is in this photograph. You can see that bag that's mounted to the wall. That's a blood bag that we keep in all the classrooms. And then, or like a medical bag or whatever. And then just in front of that, you can't even see it. It's so close to the door.
Okay.
Was the night lock.
Okay. And I think I might have interrupted you. What is significant about the night lock, and why is it used in a lockdown?
It's a measure. It's an additional measure of barricading yourself into a room if need be.
Can you open the door if the night lock is installed?
You cannot.
What about if you had a key to the door?
Wouldn't matter. You cannot open. It's like it keeps that door from being opened. You would have to remove that metal frame in order to get that door off.
Okay. And how do you? So the person from the inside has to disengage the night lock. Is that?
Yes.
Do I have it right?
Yes.
Okay. So you close the door and you get the night lock, and then what happens? Did you see anything in the hallway as you approached your door?
No, I didn't. I shut the door. I can hear that door shutting. It's completely silent. And I grab the night lock. And I look down at it because depending on which way your door opens, depends on how it goes into the door. And I see in my peripheral vision some movement, and so I look up, and in that moment, I see someone wearing dark, baggy clothes.
And are you seeing him through that window right there?
Yes, it's through.
Can you describe the person?
The individual is wearing a hoodie, baggy clothes, a mask, and there was a skull cap on, or like a.
So were any parts of this individual's face visible?
I did not see any part. I mean, only his eyes, and he was wearing glasses.
Okay. Had you ever seen this person before?
No.
All right. And when you looked through the door, where was this person? How was he faced? Was he facing you? Was he to the side?
At the moment that I locked eyes with him, we were standing square to one another.
Okay. Tell the jury about locking eyes with him and what you saw.
So I lock eyes with this person, and I see some movement coming from the side of him, and I realize that he's raising a gun to me. I remember thinking in my head, There's no orange tip on that gun.
What does that mean?
I had heard somewhere in my past that BB guns have an orange tip. And my body reacted, and I jumped to the side.
You're
Yes.
motioning that you jumped to the right.
I jumped to the right, so I'm jumping this way in the room.
And at this point, the door's closed?
The door is closed, yes.
Is there a window on the other side of this door, or just what
No,
we see?
just
Okay.
what you see.
All right, you jump to the right, and then what
I
happened?
jump. I'm turning and I'm jumping to the right, and then I feel my shoulder move back. It feels like I've been stung by hot water.
Okay, you're pointing to something. Where-
Yeah, on my arm.
On your left arm.
Yes.
Okay. At this point, did you manage to get the night lock in already?
No, the night lock's in my hand.
So he could have just opened the door.
The door was locked.
Okay.
Like the lock was
Okay.
on it, right? I look behind me and I see, you can see the bullet hole in the glass leading out to the courtyard. And in my head, I remember thinking, a BB gun can't do that. The instinct in my body was that I had to barricade this door. But I'm afraid to go back to the door to put the night lock in.
Okay, I'm sorry, Ma, I have to stop you for a second. When you, after you locked eyes and you see a gun, do you hear anything?
Nothing.
Okay.
Oh, well, there were, sorry.
That's okay.
There were, it's totally silent in the hallway, but I do hear 3 loud pops. They were, you could feel the force like coming, like the way the door hit. It was very forceful, but the sound did not match the force.
What do you mean by that?
It was like higher pitched than the power of what was happening through that door.
When you jumped to the side, you said then you looked and saw the bullet hole, and then what did you do next?
There was a filing cabinet over on this side of the door against the wall, and so it's like a longer one, and so I grab it and I'm trying to move it, and I'm realizing I can't move it, but I know I have to get back and barricade that door.
Okay. You were shot that day.
I was.
Okay. And can you tell the jury and show the jury where you were shot?
Yeah. I'm gonna remove this.
That's
Is that okay?
You can step down if you want to. It's
Okay. So you can see it's kind of like on the back side of the arm. It's not straightforward. Like you can't see the scar when I'm standing straight forward. So he caught me when I'm jumping on this side. He catches me.
And are there
There's
two?
an entrance and an exit wound, and the line in the middle is where the bullet cauterized my flesh.
When you were trying to move the filing cabinet, at this point, did you,
I'm okay.
did you know you were shot?
I did not, no.
Okay. Were you feeling anything physically?
No. There was nothing physical. I was so focused on, I have to barricade this door. And when I realized I couldn't move that filing cabinet, I still had the night lock in my hand. And so I got down on my hands and knees, and I crawled the length of the door, and I dropped the night lock in. And it made like ting sound when it hit the ground. And then I went.
Talk to me about why do you say that it made a sound? Was that significant to you?
The only thing that I have to go on right now is what's happening in my space and what are my senses telling me. It just sticks.
Was there anything Could you see, smell, or hear anything else outside of your door?
There was a smell of a cap, like a cap gun might have smelled like, or, but I'm not going back towards the window, right? I'm just dropping that in. And then I grab the rolling cart, which is also against that back wall, and I push it, and that's what you see in front of the door.
So that piece of furniture is a rolling cart?
Yes.
Okay, and you could move that?
Yeah, it was really easy to move. It was just a push.
Okay. At this point, did you know you were shot?
No.
Okay, what happens next?
I'm concerned that he's gonna come back around to those windows. So I know that I need to hide in that room.
When you say those windows, the front ones or the back ones?
The back ones.
Okay.
In the back. So I'm trying to, I've barricaded the door. I'm trying to make myself invisible in that space. So I go back to that large filing cabinet. I move it just enough so that I can crawl behind it.
And we can't see that here because it's to the left. So would you be able to see, would somebody looking in the window next to the door be able to see you?
No, the cabinet was quite large and it was wide. They would not have been able to see me behind that cabinet.
Okay. At this point, did you realize you had been shot?
I knew I could start to feel blood rolling down my arm. And I don't think I was admitting that I was shot, right? It's not some, it was so far out of what I knew to be what happens. And so I just knew that if I was bleeding, I had to put a tourniquet on. But I can't get back to that bag that has medical supplies in it. So I removed my cardigan that I was wearing that day. And I used one of the sleeves to tie around my arm. I put part of it in my mouth and the other part in my hand, and I just tightened it around my upper arm.
Were you feeling any pain at this point?
No.
Okay. The person that you saw raise the gun and shoot at you, did you, looking back then now, what was your impression of his use of the firearm, if anything?
Your Honor, I'm going to object to that question. She's already testified she's not very familiar with firearms. I think that she would be speculating about his use of this one.
Your Honor, I do want to acknowledge she's testified twice before, so I do know, I'm trying to, this is difficult. Even though it's her third time, it's very hard for her, and so I'm trying to get her to answer my questions.
We'll describe what you noticed about him.
His feet were about hip distance apart. His shoulders were square. And he raised that gun right up. It was probably a second from the moment that I locked eyes with him.
Okay, just for the record, you're raising your arm at shoulder level. Was it 2 arms or 1?
I don't know. I just remember seeing the one arm and my body instinctually moved.
Okay. So after you tied the tourniquet, what did you do? Were you hearing any announcements? Did you have a phone with you? Did you have a way of communicating with anyone?
I had my cell phone. The thing that I know to do is to barricade and listen. So I'm trying to figure out what to do next. I know that if we're in lockdown, 911's been called. There's a phone on that desk, but if I reach for it and he's there, he'll see me. And then I'm worried about what's happening in the front office. So I don't want to call up there. And I text my husband, I love you, active shooter. Within a few...
Did you let anyone know that you had been shot?
No, not at that point. Within a few minutes, I received a text message from my daughter, who went to school in a neighboring district. Through social media, she had heard that there was an active shooter at Oxford High School. She said, "Mom, are you okay?" And I said, "I'm sheltered in place. I'm safe. And I love you." And I'm just listening to what's happening outside, trying to distinguish what's my next move.
What are you hearing?
Absolute silence. I'm hearing nothing.
Were there any announcements?
There was another announcement that came on at one point, and it was to remain in lockdown. There's a hallway text thread that we have. That there's no one texting on that, but
You
there.
mean the teachers
Yes,
in that
in the
hallway
hallway.
have a group text?
Yes.
Okay.
No one's texting on that, but in the other part of the building, my language arts team says, I'm hearing there's an active shooter, and I said I saw one.
Do you say, "and I've been shot"?
I did not say that I was shot.
Okay, is there a reason you're not telling anybody that you've been shot? Is that because you didn't want to really understand it, or?
I think that there's definitely a part of me that was in denial about what was happening in that moment. I also think that what I know is that building has to be secured to save the most amount of lives. And telling anyone that I'm shot when I'm not, when I do not need help, is not beneficial.
So you didn't want anyone to help you?
I did not need emergency medical attention at that moment. Or at least that's what I felt.
Okay. How long do you think you were in that classroom behind that cabinet?
I'm in there for about, I would say, 20 minutes. And I'm sitting on my bum. And at one point I hear footsteps in the hallway because my back's facing that hallway. And I think they're starting to evacuate those rooms. That was the decision, that was the moment I decided to text the teacher next door to me. She's in room 222. And I just said, no one knows right now, but I've been, I think I used the word hit. I've been hit in the arm. And then I did say, I hope there's no one else. She then alerted. I believe she called 911, and there was another teacher in the room with her, and he alerted the front office.
So at some point, did somebody come to try to help you?
It was pretty quickly after I sent a text message to them that Kurt Noose, who was our assistant principal at the time, that he shows up at my door knocking, Molly, are you in there? And from behind that filing cabinet, I said, yes. I've known Kurt since I started in Oxford, but I didn't trust that was Kurt in that moment.
So you didn't want to open the door?
I did not want to open the door. It felt safer to stay in there. And then a few seconds after, there's police officers at the door, and they're like, are you injured? And I said yes. And so they asked me to, I think I said, do you want me to, I kind of like crawled out from behind, and I was like, do you want me to take the night lock out? And they said yes. Do you want me to open the door? And they said yes. And I'm still on my hands and knees at this point. And I reach up for the handle. And that door swings open. and they grab me from under my arms. And they pull me up and out of the classroom. And I can see Kurt standing on the lockers, like against the lockers.
Okay. I'm going to show you what's been admitted as Exhibit 11. What is that, Molly?
That's them at my door. And that's them walking me out. You can see that there were multiple police that were around that door when they pulled me out. And then the two escort me out door 4. We get outside of door 4 and the one says, I'm going to put a real tourniquet on you now. It might hurt a bit. And then...
Is that what's happening right through the window? You can see in the
yes.
video? Okay.
And then they said, we're going to call and see if there's an ambulance available for you. We need to know if someone needs it more than you.
Okay, when you came out, we see somebody there, an officer with a weapon.
Mm-hmm.
Was there anybody else in the hallway? Were there any students?
There was no one in the hallway. It was completely silent with the exception of a walkie or two that was going off.
And what information did you have at that point about the shooter, or did you know if somebody, if they're still in the building? Did you know if there were victims? What did you know?
I have no idea about anything, but when he says, we're going to see if there's someone else, I think it was the moment that I knew that there was someone else.
When you got outside, what did you see or hear?
There's a helicopter flying above the building. There's a couple snowbanks.
Did you see any students?
There were a smattering of people throughout the parking lot. I honestly couldn't tell you if they were students or parents.
Okay. Eventually, did you get into an ambulance?
I did.
And where were you taken?
I was taken to Lapeer Hospital, or the hospital in Lapeer.
Okay. And what happened when you got there?
We get to Lapeer, and I asked to walk in. I felt like if I could walk, I wanted to walk. And so they supported me to walk me into the hospital. And as I'm walking in, the hallways are lined with doctors and nurses. Like they were prepared for a disaster.
Okay. What did you learn about your injury that day?
It was through and through. It was clean. They ended up doing a chest x-ray on me in the hospital to make sure that no debris from the bullet came in. And that was probably the first moment that I cried, because I felt like I had made a mistake in the classroom and that I had actually put my life in danger. I didn't know if I was hit somewhere else.
What do you mean you thought you made a mistake?
I didn't know if I was hit somewhere else. I couldn't understand why they were doing a chest x-ray on me.
Okay. Were you released that day?
I was. My husband came up to the hospital to come get me. We went home that night.
Okay. At some point, were you informed or shown where those shots landed?
Yeah. He was aiming to kill me. Those shots were intended.
Okay. I want to back up. When did you learn where those shots landed, other than you knew it hit your arm?
My husband was my nurse at home, taking care, cleaning my wound. And at some point, when, you know, I'm holding him out, I realize that's at heart level. And he was aiming to kill me.
Okay. How many inches was it from your heart, Molly?
I would say about 6.
Okay. At some point were you shown the picture of your door that depicted, okay,
Yeah.
do you remember when that was?
Yeah, I saw that photo in your office.
Okay, when you came in months ago to talk about the testimony. All right, Molly, I'm showing you what's been in as Exhibit 12. Is that the classroom, your classroom door?
It is.
Okay, and the pink rods, do you know what those indicate?
The bullets that came through the door.
Okay, and when you saw that in my office, what did you say?
He was aiming to kill me. That's a shot to the head and 2 to the chest.
Nothing further.
Can I ask you to tell the jury what Alice is?
Oh, thank you. Alice is a protocol that we follow. If I could remember the entire acronym, I would tell you, but it's like we have to listen and make alert. We have to make a decision. Are we going to lock down in place? Are we going to flee the scene? Or are we going to have to go on the attack that like someone would come in the room? So it's just kind of dependent upon the situation and what decision we choose to make in a situation like that.
Thank you. Cross, Ms. Lehman?
Nothing wrong. May she be excused, Your Honor?
Yes, you can step
Thank
down
you.
when you're excused.
Our next witness involves the exhibits that we spoke about earlier today.
Okay. So we have a little setup here. We are ahead of schedule, believe me. There are certain things that need to be set up for your review. So we're going to take another break, okay?
All rise for the jury. All right, well, we just heard testimony from the first witness in this trial on day 1, Molly Darnell, an educator who was shot during that attack. Extremely compelling, very emotional, chilling testimony, and we saw emotion out of James there just now. So we understand, does it seem like the jury is going out for a break, Arnold?
Yeah, they may be going out for a quick pause before the next witness is called.
Okay.
This is the 3rd time, I believe, that we've seen this same witness take the stand. I can only imagine the emotional toll that it takes on her to have to keep recounting this day over and over again.
Just incredible testimony as to the human condition, what was going on inside that building, real time. And she's probably going to be one of the most compelling witnesses this call. But it goes back again to what we talked about a little bit earlier, the imagery involved in the case like this. The prosecution putting a witness on that backs up in part what they promised to show the jury in opening statement. Just a very, very powerful witness, and the defense is going to have their work cut out, for them throughout this entire trial. I mean, if it's more witnesses like that, which we know it will be, the defense has got an uphill battle here. Plus, you heard her say that she talked to the prosecutor. She was in the prosecutor's office talking to the prosecutor, so they are prepared. The defense attorney does not have that luxury of going to talk to witnesses like the prosecution does. The prosecution has help of law enforcement, has help of a lot of resources that a defense attorney does not. So it would be hard for the defense attorney in that situation to even try to prepare to cross-examine a witness like that, even if you could even do that.
Yeah. Speaking of imagery, Meredith, you mentioned that emotion we saw out of James. That's not something that we saw from Jennifer the entire time. Do you think that that could help with at least the jury seeing that he's remorseful?
I think that he's more sympathetic than she. We saw that in the videotapes that were admitted in the first trial. Although she did get emotional, Jennifer did. I think it was this witness and one of the second or third witnesses as well. So early on in the trial, I think she got emotional. That was when both she and the defense attorney were both tearing up. Something that was brought to my attention when I was watching the feed. The ATF, I saw the ATF agent as the camera scrolled by. He testified in the first trial. So evidently there's no sequestration order in this case, and a sequestration order is important for the defense to file. So the witnesses don't hear what a witness before he or she is testifying is hearing, so they can't prepare or customize their testimony to the previous witness's statement. But I don't know how effective that would be in the second case, because in the first case there was daily copy. We know that transcripts were contemporaneously made. Each and every witness, their transcripts were made on a daily basis of their testimony and turned over to both the defense and the prosecution. So that's a big advantage for the defense in this case. They have a map or road map of what each witness will testify to, both in the Miller hearing, as Ms. Darnell testified, and also in the first trial. So there are not going to be many surprises to the defense attorney in this case, other than maybe the new witnesses.
Mm-hmm. But just watching this type of testimony, knowing that we have more ahead of us, and then knowing that one student will be allowed, who was shot, will be allowed to testify, how does the defense effectively undo just all this raw emotion, and how do you even begin to approach that?
Well, I mean, there's no way you can undo it. They're humans. You win or lose cases on emotion. She's just got to ride the wave here, so to speak, and figure out when she can counterpunch here and there. I mean, when you heard that she was texting her husband, telling him, "I love you," right? Active shooter. I mean, think about it. That evokes images of 9/11, where people on the plane were texting their loved ones for the last time. And it's just raw emotion that you got to figure out how to ride that wave, ride it out, and kind of counterpunch where you can and make the points that, hey, this is an emotional trial. We all know this, right? But that still does not mean the prosecution has proved their elements to you in terms of my client being grossly negligent, knowing that this was going to happen. So pick and choose where you're going to make your counterpunches, do it wisely, otherwise you'll upset the jury. But that's all you can do in a situation like this, is just let it ride and try to get on top of it when you can.
And Mrs. Darnell does a really compelling job of bringing you into that imagery, describing just the visceral elements of her experience, that she felt this hot, stinging feeling, like she thought she was burned by water. It took her a long time to understand she was shot, to then feeling the blood flowing down, to hearing the ping of the lock of the door, of the, what's it called? The lock, the special lock for these types of situations.
Yeah,
But it's a special lock that's installed in many schools across Michigan, and it's for the situation. And she just describes hearing that almost as if it was, she understood she might be okay in that moment. She did it, and we were talking here, just listening to her testimony. How do you react like that? You said fight or flight. I mean, you just
right. I mean, it was what we saw here on the witness stand was fight, flight at the same time, right? And she was behind that door, and she heard a knock or something at the door, and she had to make a decision. Do I stay? Do I open the door? And it turned out, I believe it was one of her colleagues, and I'm sure she probably felt really, really bad inside when the police came and opened the door, and her colleague that was knocking on the door was standing across the hall. I mean, the jurors are sitting there, and the jurors are saying, what a brave soul, what a brave woman, for her to be instinctively trying to protect herself, protect the children at the same time. I mean, that was definitely riveting testimony. And again, the defense attorney, she's been practicing over 11 years. She's had a few murder trials. I've done a little research on her. I would expect her to be able to try to counter some of what is going to come forward. But you got to pick and choose your witnesses wisely. You got to choose less sympathetic witnesses, witnesses that the prosecution is going to put on the witness stand to testify to Mr. Crumbley's knowledge. That's when I expect her to pounce and try to discredit witnesses who are going to say that he knew or should have known what his child was going to do. Now is not the time. Yep. You know, you're on the ropes now. You're going to be on the ropes for a while, but there's going to come a point in time where you got to get off those ropes and start swinging. And I'm anxious to see what she's going to do when that time comes.
And that in itself would also be a big contrast from what we saw in Jennifer's case, because it seemed that that defense attorney had an insatiable need to cross-examine everyone.
Yeah.
So in this case, though, pretty clear that that would hurt them more than help.
It'd be feckless. One of the things that interesting about her testimony, Mr. Arnell's testimony, was that she very nearly became the fifth murder victim. The door saved her life, if you recall. Her testimony was that the angle of the bullet that struck the door, and then she was centimeters away from having an artery struck as well. So she very nearly died. But during all of that, in the commotion and all of the emotions that she may have felt, she had the presence of mind to protect her daughter, who texted her and asked her, "Mom, are you okay?" And she said, "Yes, I'm safe." She didn't say, "I just had half my arm blown off." She wanted to protect her daughter and not cause her daughter, to be concerned, even though she was laying there, sitting there with, majority of her arm blown away by this 6-hour 9mm. So she is very courageous and she was stoic and of the presence of mind to keep her head about her in order to protect the lives of the students, herself, and even the well-being of her child.
And think about it. She's testifying about how she's standing there, and death is right at her doorstep, and she's staring death down, and it's coming. It's coming. And in that moment, it clicks in. I better jump. I better move. That's very, very powerful. Deliberation. He raised his hand, right? The defense, again, and I keep going back to this, has got to embrace that and not even try to deny it, not try to fight it, but come back to what does that have to do with the knowledge that James Crumbley had. He wasn't there, and in essence, argue to the jury that they're retrying the case of the young boy, the shooter. They're not trying the case of James Crumbley, they're trying the case of the shooter. And that's not what you're here for. It's a monumental task. The question is, will she be up to it, Rick?
Well, there's a case I always like to cite where the community standard was so hot and the passion so heavy as to be almost impossible to get a fair trial. And that was a case in 1752. It was known as the Boston Massacre, where 7 British soldiers shot on an unarmed crowd in Boston, and the soldiers were charged with, among other things, murder for the death of the first African American killed in the Revolutionary War, Crispus Attucks. And the interesting thing about that was they couldn't get a defense attorney. The judge tried to get a defense attorney to defend the British soldiers because the potential jury was the community that wanted the British out of the then pre-United States. And the Revolutionary War hadn't even begun. So what the judge did was he put the strong arm on John Adams, future president of the United States, who agreed to represent the British soldiers. And John Adams did just as Arnold suggests, trying to take the passion away, make the prosecution prove its elements, and the soldiers, the British soldiers, were acquitted by the jurors who knew some of the people who were killed and shot upon by these British soldiers. So it is possible to present a case, and as Arnold suggests, you have to take that passion, that desire to remedy the community wrong, for retribution. You can do that if you're thoughtful and creative in your presentation, and that's what has to be done here. I mean, there's absolutely no need to even acknowledge any of this testimony that's coming in now. It's nothing you can gain from cross-examining any of these witnesses. The defense attorney did front it off and say this is a horrific act, and I agree, and we all agree, but that doesn't mean that my client is guilty of criminal negligence, and that's the key. That's the Kierkegaardian leap of faith that has to be made by the prosecution. We're here, we have to get here, and we want you to take that leap of faith, jury, and determine that my client knew or should have known and could have prevented this horrific act.
If you are just joining us, the jury walked in at 9:02 this morning. Rick, you mentioned that defense coming in with those opening statements. We're now hearing from the first witness. The day is going to continue, but in case you missed it, these are the words spoken by that defense attorney in those opening statements.
But this case is not about what happened inside of Oxford High School. This case is about what happened outside of Oxford High School. The prosecution alleges that James Crumbley was aware that his son was a danger to others, and that he failed to protect other people from his son. The prosecution alleges that James Crumbley had knowledge that his son could and would hurt other people, and that he failed to protect those people, that he failed to take steps to protect others. And ladies and gentlemen, that simply is not true.
It's strong arguments there from the defense attorney. However, the prosecution is arguing that because of the negligence there and not paying attention, it led to what happened today. Do you think that that was a strong opening statement?
I think it was a very strong opening statement, about the best that she could do under the circumstances. Again, I thought there were some other things she could have done. Embrace what happened, embrace the facts of the case, but remind the jury that these are the elements that you have to be shown beyond a reasonable doubt. And that's beyond all doubt that has a reason. And tell the jury that you're not going to hear it. You're going to hear a lot of facts that are horrendous, they're horrific, and tell the jury some of the facts that they're going to hear, but then come back and circle back with them and say, at the end of this case, which one of you is going to believe that this has anything to do with my client knowing that his son would have committed these acts? And you got to get back to home base and stay with that theory, and at the end, wrap it up with your argument. Don't get up cross-examining witnesses that are uncross-examinable. Stick with your game plan, and so far, compared to the last trial, with what she has, she's doing the best that she can.
Mm-hmm. It's a difficult challenge for the defense, no question, because we mentioned this in the last trial. It's hard to believe there's a single juror who doesn't have feelings about what happened at Oxford High School. People here in the state will never forget that day. People around the country, as you said, America's watching this right now. People are paying attention and have feelings, and it almost feels like an impossible challenge. But you mentioned this John Adams defense case from before the Revolutionary War, and it shows if you truly have a masterful defense and you stick to it, it can happen. So do you think, Rick, there is a chance that James could face a different fate than his wife?
Oh, absolutely. No question about it. I think I think it's a difficult case for the prosecution in general, because you have to do, as Arnold said, who knows what this guy was thinking, and you have to impute some kind of knowledge, whether it's negligent, whether it's criminal negligence to the point where he should have known, he should have taken ordinary care. But then again, you have somebody here who the first reaction when he was notified on the all hands on deck alert that there was a shooting at the high school, his first reaction was that was his son. He went home, he checked to see if the gun was there, and then he called 911. In addition, what was his thought pattern when he saw that math worksheet where there was the plea for help, blood everywhere? There was the 6-hour 9mm gun that was depicted, the very one that he purchased, that the school people didn't have any idea he had a gun purchased 3 days ago. I mean, can you imagine if he said to the counselors in that session on the day of the shooting, you know, hey, my kid, I just bought him a gun. I bought him a gun. I don't, you know, let's check his bag. You know, where's the gun, son? Do you have it here? I mean, all of those questions would certainly have been on the forefront of the counselor's mind if they knew that 3 days prior, this kid had a 9mm 6-hour ammunition at his disposal. That, coupled with that math sheet, those school officials would have taken action. They didn't have the information. Only the father and mother had the information. And what did they decide to do? Leave the kid in school and go home. Go on their way.
And did you notice that the defense attorney in her opening statement tried to play down the math sheet? Did you catch that?
Oh yeah.
She said, "You're going to hear all about this math sheet. We're going to talk about it a lot, because it's so damning."
Yeah, it is. And going back to Rick's point, and we'll jump back on that in a second. That is damning evidence. If you're a dad and you get the inclination after hearing the rumblings that this is my kid, how do you explain that you didn't anticipate or could not have anticipated it, right? That is almost an insurmountable hurdle. If the prosecution, and I'm sure they are, aware, smart, whatever you want to say, they're going to be pounding on that. They're going to be beating that drum till the cows come home, because there's no explanation. If you said that, is that my kid, that means you should have known. You should have known, and that's what the law requires, right? Now, going back to what the defense did in trial, it's one thing to say you're going to hear, you're going to hear, you're going to hear, but you got to get up there and tell the jury why this is significant, why that is not significant. I mean, just level with the jury, you know what I'm saying? Come tell the jury, listen, you're going to hear X, Y, and Z, lay it out to them, but tell the jury we got to put things in context, right? And here's the context in which you need to look at this case. You need to be looking at every witness that gets on the witness stand that puts the knowledge on my client's shoulders, puts the gross negligence on my client's shoulders. And I'm telling you, you're not going to find one witness that can put the gross negligence on my client's shoulders. You got to go at it. You got to pull out all the stops. She didn't do that.
The defense is going to focus here on, I think the gravamen of her defense is going to be, you had professionals, trained individuals, a counselor and the dean of students, the prefect of students who were specifically trained, and they determined that this was not a threat. So they saw this math worksheet, and they didn't think it was a big deal or a big enough deal to take affirmative action. They let the parents decide what to do. And it's certainly beyond all peradventure, if either of those two individuals at the date and time that they saw that math worksheet were aware that kid had a gun at his disposal, they would have taken affirmative action or ordinary care to prevent what occurred just hours later.
That's an excellent point. It's going to fall back to that even if the counselors kind of had an inkling, they never saw the 9mm. They never saw, the other gun laying around. They didn't have the context in which to make those judgment calls. Dad did, mom did, and that's why they're showing them at the gun range, right? The counselors and whatnot, to some degree, were not operating under the same information that mom and dad were, and that's what the prosecution has to do to counter that argument that the defense should make.
Yeah, no, it's an interesting point, but also to your point, Rick, they didn't see a threat. They did see a threat, but they thought that he would turn the gun on himself. They didn't want him to be alone. They couldn't imagine, in their words, that he would turn it on others.
The parents.
The school. The school. Remember, one of the counselors said, I didn't want him to be alone. I kept him in my office for over an hour just so he wouldn't be alone to harm himself. It was clear that they didn't believe he had any interest in harming others. Mm-hmm. And the parents, at least in Jennifer's trial, argued that the parents felt the same. It was more, they were concerned he would harm himself. Yeah.
The school clearly didn't have the full tableau. They had just bits and pieces of the puzzle. But again, the key there is what the parents knew, what they knew and were aware of personally, and what the school was aware of. And there was a chasm there. because the parents knew that picture, that drawing on that math worksheet was identical to the weapon that they purchased 3 days ago, including, you recall from the previous case, the ATF agent who said not only was the gun the same, but the ammunition was the same that he drew on that math worksheet. And the parents knew that as well. But they ignored it, and they didn't take, again, the steps to take ordinary care, preventable action to stop this enormous tragedy.
Yeah, the situation seems to have slipped through a lot of hands, especially the day of. We know the school also felt the bag and how heavy it was.
Yes.
No one checked it. The parents also knew the day of that there were some issues there. So there's a lot of accountability that is shared.
There's no question. The brunt of this, though, from the prosecution's perspective, are the parents. It is the portrayal of the parents that are completely lackadaisical, laissez-faire, hands-off. That's why they're going to show the pictures that we saw last time of the beer bottles in the room, the disheveled home, the boarded up windows, because that's going to create a picture in the minds of the jurors that these parents had just checked out. The prosecution knows it has an uphill battle trying to prove knowledge, proof positive. So they're going to use this ancillary evidence, if you will, to tie it all together and put it in the juror's mind. Understand, a picture, we all know this, is worth more than 1,000 words. They're trying to paint an image in the juror's mind. So when they go back in the jury room, the jury's going to be talking about how bad these parents are, how they should have done this and this and this. And I think the prosecution is very adept at doing that, as we saw in the last trial.
Yeah, those pictures are something that we did see in the last trial. Something that's different this time around, though, we saw a lot of text messages with Jennifer as well. Judge Cheryl Matthews actually commented on that earlier today. Let's take a listen.
And the court finds that those texts would not be admissible because they are between the shooter and his mother. There's no information whatsoever, with the exception of the fact that Dad is with his wife, as demonstrated by pictures and texts and GPS and metadata and all those things, all those tools that are being used by the prosecutor's office to track people's movements in this case. So they are together, but there's no evidence whatsoever that Dad was on the receiving end of that text. And in fact, I know that in both 52 and 62, the statement from Jennifer Crumbley appears, "Where's your dad?" So I don't find that there's enough support to believe that Mr. Crumbley was aware of these texts. He could have been aware of these texts. We just don't know. And because of that, those texts will not be admitted. And that also makes, I think, some of the information at the horse barn inadmissible.
Okay, so that was from earlier this morning before the trial began. What Arnold described as housekeeping is pretty typical. We do see this every morning of the trial, where they speak about evidence and whether to admit some or not, and this is all done before the jury comes into the courtroom.
Yeah, I think what we're seeing here, just to kind of break it down, she said that certain text messages were not admissible. It's a difference if Dad is charged under a co-conspirator theory, for example, that he's conspiring with his kid and his wife, and so whatever said can be imputed to him. But this is not that situation. They have had separate trials. The judge believes these messages, these text messages, are not relevant, and I agree with her. This just goes back to how measured she is. She's making the right calls here at this point, and I think Mr. Crumbley is getting the benefit of a fair trial here, which is what we want. But again, the judge has made the right ruling by keeping these text messages out. There's no evidence that Dad even received them. There is no conspiracy, co-conspirator type situation going on here. Right call.
And we know that in Jennifer's trial, the defense moved to omit a lot of evidence, particularly surrounding her affairs. She famously let that in, open the door, while the defendant was on the stand. What do we know about evidence that was requested to be omitted from this case?
I think it's the same type of evidence that was omitted in the first case, and that would be the basis of the same motions that were made. I think it's unusual. I agree with Arnold about that these text messages that the judge ruled today were inadmissible, I agree that was the correct call, but I think it's very late in the game. I mean, you're talking about opening statements, and prior to opening statements, you know, there are several important text messages that the prosecution is learning as they listen right there that, you know, you're going to have to retool your case real quick, at least part of it, because these important text messages to your case that were admitted in the first trial are not going to be admitted in this trial. And it's late in the game. I don't know if there was a late motion filed to exclude that evidence, but typically these things are decided on months in advance of trial, in motions in limine and things that can, so you can prepare your case accordingly, both parties. So it is a late ruling right before opening statement, which is unusual.
Is that perhaps a tactic in some cases?
It's hard to say. I mean, you know, when, for example, in federal cases, I would tend to say probably yes more than no, because in federal cases, the prosecutors can come to you literally the day of trial with a big box of evidence, right? I mean, it doesn't happen that often, but they could. In this case, the state's a little bit different on how it moves. So I wouldn't say that this is a tactic per se with these last-minute text messages. Sometimes things just happen. Sometimes things really just don't come to light until the 11th hour, so to speak. But the point is, you have to be prepared and you have to be ready for anything, and even be ready for the things that are not obvious.
What sort of evidence do you think from Jennifer's trial might we see presented again in James's trial that could just be so damaging for him?
Well, the structures in the, you know, the underpinning in the first trial that allowed the prosecution to meet that burden was clearly the math worksheet was critically important. The 911 call was critically important. The evidence of flight, the consciousness of guilt, was critically important. And so I think that the majority of evidence that was admitted, if not, you know, the overwhelming majority of evidence that was admitted in the first trial, is going to be admitted in this trial as well. The evidence of affairs, because it's apparent that James was also having affairs during the same time. You recall Jennifer saying that she had to know where he was at every second, and she kept tabs on him because he was kind of he checked out, as Arnold says, and he wasn't even responsible enough to keep a job and to be in a certain place at a certain time when he was supposed to. And she said that there were separate reasons that she kept constant tabs on him, and I'm assuming that based on the evidence that we heard before, it was that he had been caught having affairs as well. So I don't think that'll come into evidence unless the defense, like the first case, wants it to. I don't think this defense attorney will want it to come into evidence. But there is a part that I think is notable if James does testify, which I think he will. I think there were hints of it already that we've heard in the opening statement by the defense attorney. Not definitive, but hints. But that James was, as Jennifer testified, he was kind of absent-minded, not somebody to pay a lot of attention to things. Not a very responsible person in general. All of those the things that normally we would think are negatives would be a positive in this case for him, because he's able to lean on that and say, you know, I'm not, that's just me. I'm not a type of person who would search a bag. I'm not the type of person who would think about such a thing. I'm not the type of person who would distrust my own kid. And all of that goes to the imputation of him not having the ability to formulate that should have, could have, would have knowledge that would have prevented this.
Yeah. So he's the opposite of hypervigilant.
Yes, yeah, he is the opposite of it. And I think they're facing that and they're presenting that to the jury, yeah.
But does that make him grossly negligent? That probably supports that claim.
Well, that's the interesting thing. You know, if he's the, you know, that it's a standard that will shift. You know, what somebody is what Terrence may be grossly negligent for, you may not be. And so if his personality, if his makeup, if his mental well-being is such that he was oblivious to this. And a jury can think, well, you know, I sympathize with that, I sympathize with him, and I understand how he could have missed this. Even though I wouldn't have missed it, I understand how he could have missed it. That could go to reasonable doubt.
Yeah, this whole concept of reasonableness is a very interesting term. It's what a reasonable person would or would not have done under like or similar circumstances so as not to expose the public for harm. And so they have to analyze it. I often use the example, if you know that there's a dangerous intersection and there are 50 car accidents a month, you're never going to be able to completely alleviate that danger, but it's about the steps you take. If you build an overpass over that intersection, then you've taken reasonable accident prevention measures to not alleviate, but to cut down the risk of injury. And so the lawyer, I feel, has to explain in some kind of way to the jury that, hey, my client acted reasonably on the information he had and beliefs that he had based on who he is. And like Rick said, what one person may think is reasonable doesn't mean that that governs what another person thinks. So you have to set up some dichotomies here, some distinctions here, and make it seem as if your client's a good person. He didn't check out completely, but he just never thought that something like this would happen. And if he did think that something like this would happen, he would have been the first one to search the bag. He would have been the first one to not buy the gun or take the gun back. So I think there's some ammunition here for the defense to use, and I'm hoping that they'll pull some of that out near the end of the trial, or as this or the witnesses take the witness stand.
And he called 911.
Yeah,
I mean, that's another big part of this.
He called 911 on his son.
Yeah,
Right.
And that's the imputation.
big.
Yeah. He didn't say, hey, you know, he called 911 and said, I think it's my son.
Right.
And you know, I think it's the gun that I bought. That was, and it came to him immediately. Also, if you recall, it came to Jennifer immediately too, and she was in her place of work when she got that text. It's my kid.
Yep.
So, you know, there's not a sentient being in the history of mankind who placed in this fact pattern, knowing that what occurred you know, in the afternoon of November 30th, who would have not taken preventive measures. So there's no way to say that had he known, he's ignored it. He let it happen. That's not what the defense is. You know, the defense is that he just was oblivious to this, and that's a high hurdle to overcome when you have, as the prosecution said, these incidents that occurred seriatim beginning in April, when he's pleading for help and the father says, you know, suck it up, cupcake, you're fine, don't worry about it, and then this progresses to the point where there's this crisis that occurred. The prosecutor said the only social interaction that this boy had was with this lone friend who was then displaced from his acquaintance without any warning or forethought. He was just removed. And
A month before the shooting.
A month before the shooting, which caused an additional downward departure from his mental health. And so the parents and Jennifer was aware of this. She, you know, called the boy's mother who moved. And so they were in communication, and she said, you know, Ethan is having a hard time. And James was aware that Ethan was having a hard time because of this. So all of this, again, the prosecution's case, they cannot, as Arnold said, impute knowledge. They can't. And if they could, it'd be a different charge, it'd be a murder.
Exactly.
But the totality of the circumstances is what this case is about.
I mean, I think it's like I said, a completely different complexion than the first case. I mean, here the defense has some things to work with. I think there's a different perception of James Crumbley, right? That is a lot different. I can see a jury being somewhat empathetic, you know what I'm saying? Not necessarily sympathetic, but empathetic to the fact that he's the kind of dad who just really wasn't with it. But does that mean that he's guilty of involuntary manslaughter? So I think this is setting up, at least at this point, for some things that the defense can raise down the road that may help our client, maybe get one of those jurors, just one. That's all you need to vote that he's not guilty.
Yeah, it'll be interesting to see where things go. James Crumbley just walked back into the courtroom, but things have not started back up yet at this point. As testimony continues, is there anything specific that you were hoping to hear, just in terms of the prosecution or the defense?
Well, from the prosecution, I think we pretty much know what their game plan is. They're going to be consistent and right down the line from what they did the first time. Remember, if it's not broken, why try to fix it, right? They may tweak a few things. So their message is going to be constant. Their message is going to be clear. The defense, on the other hand, I think is going to try to come back, and you're going to probably see her not ask questions of a lot of witnesses. It doesn't mean that she's incompetent, because sometimes people watching this, lay people, why didn't he say anything? Why didn't she say anything to that witness? It is better sometimes not to say a word than to get up and try to cross-examine somebody that's uncross-examinable. So again, I think as this trial progresses, we're going to see her ask less questions and then begin to question the witnesses that she can get some mileage out of. But the themes, the overall themes, are going to be the same from the prosecution, that these were neglectful parents. They're going to show the pictures. That is their theme throughout. The defense's theme, I'm going to assume, based on what we've seen in my knowledge and experience, is going to be that he didn't know that this was going to happen, and if he did, he would have never purchased the gun. He would have never done this. He would have never done that.
So I'm assuming this is the name we're seeing on the screen now of the next witness.
Yes.
I'm believing he's some sort of
He's an agent.
An agent.
Yeah. Mm-hmm.
Okay. And we did see him testify.
Yes.
In the last case as well. Many law enforcement agents testified. Speak to that, Rick. Why so many law enforcement were called in Jennifer's trial?
Well, they were imperative to the admission of certain pieces of evidence. They were authenticating witnesses. One was an expert witness who testified in a cross manner as an expert fact witness, which is improper, which wasn't objected to. Which truncated their case, and it was Mr. Wachowski, this witness here, who was testified as a fact witness and was allowed to testify. I'm sorry, as an expert witness, and was allowed to testify as a fact witness by the defense attorney. So I'm interested to see if this attorney will cut off that fact witness and only allow his expert testimony to come in.
All right, so let's take a listen in. He is a computer crimes expert.
How long have you been working with the United States Secret Service?
2 months now.
And prior to that, where did you work?
I worked with the Oakland County Sheriff's Office.
And what did you do there?
I was in the computer crimes unit.
Okay. So before, I take it you retired from the Sheriff's Office?
Yes, I did.
Okay. Before retiring, how long did you spend there?
My entire time there was 28 years. I was in the computer crimes unit for 10 years.
Now, if you could tell us, please, what a detective with the Oakland County Sheriff's Office Computer Crimes Unit would do on a day-to-day basis.
On a day-to-day basis, our job was electronic evidence, whether it's a cell phone, computer, DVRs from a business, whatever it may be. We were the ones that handled that. We're the ones that had the training on how to get the data from that, or get the video from it, or interpret call detail records.
Okay. So Exhibit 43, it's been admitted, it's your CV. I'm not going to go through the whole thing. But is it fair to say that you've had specific training for your role there?
Yes, sir.
Okay. Tell us about some of that.
The main training that we go to with the Sheriff's Office was, there's an organization called IASIS to become a certified forensic computer examiner. That has a 6-month testing process after 2 weeks of training at their training event once a year. On top of that, for cell phones, there's other agencies. Celebrate has training they do for the tools that we use from them, and other agencies as far as PATCs. Another one.
When you say Celebrate, what's that?
Oh, I'm sorry. Celebrate's a company, and they develop software and have tools to extract data from phones and then interpret that data.
How often in your employment with the Sheriff's Office and with Secret Service would you say that you actually analyze cell phones?
Almost every day. That's what we do.
Okay. So you went through a lot of, just now a very quick rendition of detectives' work with the Computer Crimes Unit. I didn't catch most of that. Can you simplify a little bit of that for me?
I mean, So we get the data from the phones, and then we have to take that data and put it in a format that an officer in charge of a case, an OIC, is able to look at easily. Instead of sitting there scrolling through the phone, potentially changing data, we put it in a format, we take it off of there, and then make it easy.
What do you mean by data?
Everything on the phone, anything. Text messages, call logs, pictures, videos, anything that's on the phone.
So the goal as a detective, when you take somebody's phone, I take it that's via search warrant?
Via search or consent, yes.
Okay, so if there's a judicial authority for you to look inside the phone, then what do you do with it?
Depending on whether the phone is locked or not, we use methods to obtain the passcodes and then extract the data or the call logs and the messages and all that stuff. And then that's, like I said before, we put in a format that is easier to look at.
Okay. And what's the overarching goal of a detective in the computer crimes unit? What's the goal to obtain that information for?
What you want to obtain is all the evidence, if there is any, for prosecution. You want to make sure you get everything that is possibly on that phone to turn over to either the officer in charge of the case, who will turn it over to the prosecutor's office.
Okay. So you're with the Secret Service now.
Yes.
In this field, this specific field, do you work with other agencies as well?
Yes, sir.
Tell us about that, please.
Same as with the sheriff's office. Any agency that reaches out that doesn't have the means to have the tools to get data off of phones, we just help them with it.
Okay. So we started to talk a little bit about your training in computer forensics. Have you been qualified as an expert in the past in this field?
Yes, I have.
How many times?
14 times.
In what areas?
Cell phone forensics, computer forensics, and then call detail record analysis.
Okay. What's call detail record analysis?
Call detail records are what you get from your carrier. If you have AT&T or T-Mobile, via search warrant, you send it off, search warrant off to the carrier to get information from a specific phone number, what towers they used, where the device might have been, stuff like that.
Okay. You mentioned cell sites?
And yeah, cell tower locations.
What's that mean?
The cell sites, the cell tower location is, it's an antenna for your phone, sort of like it is for your car. They're all over the place, wherever, probably within a mile of each other, half mile of each other, depending on the population of the area. But it gives us the exact location where that cell tower is.
Okay. So in your over 10 years of experience working with the digital extraction of data from cell phones, would you say this field has changed?
Yes.
Okay. Is your training continuing?
Yes, sir, it does.
Why is that?
Well, just because the information changes. Where an app might store information within the program itself, the little program, might change on every update. So we have to know where we can go to find it if the tool can't find it for us.
Okay, when you say the tool, what's that mean?
The Celebrate software, either the physical analyzer software or other methods to get the information off the phone.
So then would it be fair to say that as technology has changed and evolved over time, so is the training of computer crimes detective?
Yes, sir.
Okay. And is that training continuing?
Always.
Judge, this time I'm going to move to qualify as witness as an expert in the field of cell phone forensics and historical cell site analysis.
Okay, he said computer forensics, cell phone forensics, car detail analysis. Are those the areas?
That's what he's been qualified in the past, called detail records, but in this particular case, he's going to be qualified as an expert in the field of cell phone forensics and historical cell site analysis, Judge.
Historical cell phone. Listening?
No objection, Your Honor.
You may consider this witness as an expert in the area of historical cell phone analysis and cell phone forensic analysis.
Thank you, Judge. Cell site analysis.
Cell site.
Thank you, Judge. Sir, you mentioned that the overall goal is to extract as much information as possible. Would that be right?
That's correct.
Okay. So in a digital investigation, would you confine yourself to just a cell phone?
No.
Okay, so what else? What other areas would you look for information?
I mean, outside the cell phone, that the call detail record isn't stored in the phone. We have to reach out to the cell carrier. A particular app, whether it's Facebook Messenger or Instagram or whatever, we can search warrant them to get information for somebody's account.
Okay. Now, if you could tell the jury a little bit, please, about what a cell phone does that might not be commonly known.
I mean, when you're not using it, when you're not interacting with it and swiping up and down and stuff like that, it could be updating your email, you know, because you don't always tell the phone to update, it just does it by itself. Or it's talking to a cell tower to know exactly where you might be in case it needs to send you a message, or it knows whether you're not in range or not, so it knows, the carrier knows to hold on to that message. There's a lot going on in the background that people just, you know, don't know the function's happening, but yet it's continually happening.
Is that why while a phone's powered on?
Oh, yes.
Okay, so what happens if the phone's powered off?
Nothing. It can't do anything. It can't receive information, can't send information.
Okay. Now what about Android phones specifically? Have you had the opportunity to be trained in data extraction from Android phones?
Yes, sir.
Okay. Is that the same as Apple phones? iPhones?
Not entirely. How the operating system is written, it's a little different in the process in getting the data off of the phones.
What do you mean?
On Android phones, it's a little bit easier to get the data off of a phone than it is an Apple phone.
You said operating system. What does that mean?
The main function, when you look at the phone, the main screen, that's the like Windows for your computer, right? Or iOS for your Mac or whatever. The operating system is the base of that phone, whether it's Android or an Apple, which uses iOS, an Apple phone. That's the main thing that makes the phone function.
Okay, and I think you said that Android operates differently than Apple?
Yes, it does.
Okay, can you explain that to me again, please?
It operates a little different on how it stores data, how it retains that data, whether it's a file-based encryption, whether it's even encrypted at all, depending on the phone that you have, the manufacturer of that phone, and where it stores that data.
Now, are you able to obtain someone's locations based upon a device?
You can, yes.
Tell me how that works.
The phone's always looking where you are. Obviously, it's talking with towers. The tower tells the phone where it's at. For advertising purposes, let's say Google, for example, they put those little cookies on your phone so it knows where you're at all the time, right? And it knows that you like going to Burger King. So every time your phone knows that it's near Burger King because the map app is being used, it's going to tell you, oh, there's a Burger King nearby, or it'll pop up in your Facebook message feed or whatever. So that's, yeah.
All right, cookies, what's that?
Those are little trackers, I guess, to make it simple. It's a little tracker that's embedded in however the phone interacts with either the internet or an application. It's a little nugget that just sits on your phone, waiting to be activated to tell either Google where you're at, Apple where you're at, and to give the user a better experience with their phone.
So if I'm on my phone, I'm looking at a website, for example, and I get that little bar at the bottom that says this website uses cookies, accept or yes or no.
Yep.
So if I either hit yes or I close out of that box, then it's tracked on my phone.
If you hit yes, correct.
Okay. What if I hit no? What happens?
Then the cookies, they're not installed because you're not given permission for them to be loaded up to your phone, not installed, loaded to your phone.
So in order for me to look at the website, for example, though, I'd have to hit yes.
Not necessarily, no.
Okay.
No.
So this is something that, as an investigator in this field, you're able to use to help understand the location of the device?
Correct, yes.
Okay, and tell me how that works, though.
Well, like I said, one of the main things that we use is what's called location services. Location services is what tracks where your phone is within either an Apple or an Android phone. Google stores that data, again, because it sells that data to Burger King or McDonald's, wherever the heck you might want to, whatever you're interested in. And it keeps track of where you have been, where you like to go to use that information in the future.
Okay. So I want to talk about, specific to this case, I want to talk about some of the evidence that you reviewed in this case. First of all, were cell phones seized in the course of this investigation?
Yes, there was.
Okay. And you were the individual, you and members of your team had the opportunity to review those cell phones?
That's correct.
Okay. What about information from social media outlets?
Yes, we did.
Okay. Now, regarding the cell phones, I'm going to summarize this, and I want you to tell me if this is accurate, okay? So, source of electronic information from the shooter, an Android phone, a T-Mobile phone, last four digits, 1551.
Correct, yep.
That's right?
Yes, sir.
Okay. A Facebook account?
Correct.
An Instagram account?
That's correct.
Okay. Now, regarding Jennifer Crumbley, there were 3 cell phones seized, is that right?
Correct.
Okay. So we have 2 from T-Mobile with the same identical phone number. Is that
Correct.
Right? Okay. a TCL A509DL, we refer to as a burner phone. What does that mean?
A burner phone is what we refer to. It's a phone that you can go to Walmart in the electronics section where they sell their TVs or any CBS or Rite Aid and just buy it in a packaging and activate it. The SIM card's in there, and there's really no account that's needed to get it up and going. You just activate the phone by putting money towards the account within it.
Okay. A Facebook account, jehn.crumbley.7, and we have includes the messenger functions. What do you mean by that?
So Facebook Messenger and Facebook, separates two separate platforms, but you can search warrant Facebook for Messenger.
Good afternoon, and thank you for joining us for CBS News Detroit. I'm Terrence Friday.
And I'm Meredith Bruckner.
We are watching now the trial for James Crumbley. We've got gavel-to-gavel coverage for you for that trial, the father of the Oxford school shooter.
Now let's continue to listen in. This is the second witness we're seeing now, Edward Rogrowski. He's a former detective with the Oakland County Sheriff's Office. He was with the department at the time of the shooting, and we do want to warn you, some of what you see and hear could be disturbing.
James R. Crumbley, one Facebook account, which included the messenger function, James R. Crumbley, and Yahoo, Gmail, Charter Communications email accounts?
Correct.
Okay, and then DoorDash search warrant for James Crumbley. So was the search warrant issued to DoorDash?
Yes, it was.
Okay, and was information received?
Yes, it was.
Okay, so we spoke about that very briefly early. A search warrant is when a judge or magistrate authorizes a document to a social media provider or a company, for example, and information is returned.
Correct.
Okay, and so what happens when you get that return?
Sometimes it's in an easy format. It's just a simple Excel spreadsheet. Other times it's multiple Excel spreadsheets that you have to compare different parts of that two spreadsheets to come up with the information.
Okay. Now, your role normally would be to talk about cell phones, computers, cell towers, things like that.
Correct.
Okay. So, with your permission, I'd like to talk to you about November the 30th, 2021. Do you remember that day?
Yes.
You were working for the sheriff's office?
Yes, I was.
Okay. And you were computer crimes?
Yes, I was.
Were you working that day?
Yes.
12:50, 12:51 in the afternoon on November the 30th. Do you remember where you were?
It's probably driving pretty fast.
Okay. And tell me why.
We got news from our captain that there was a shooting at the Oxford High School. Prior to that, our sergeant, who was off that day, reached out, texted one of the guys in the office, and said there was a shooting at the high school, and nobody believed it. Like, we believed it, but we're like, it's just somebody nearby at a house, fired off a rifle or something, and the police are going to go do their job. And then a couple minutes go by, and the captain comes in and he said there's been a shooting at the high school, and he said all hands on deck.
Okay. What did you take that to mean?
There's a shooting, like it was.
All hands on deck. You're not normally somebody who responds to active shooter situations, right?
No, it's over the nerds. When for the captain to come to the computer crimes office, it was all due respect to the guys in there and the gals in there. That's not their job to deal with that. The fact that he came in there it was a really big deal.
Okay. And you mentioned you were driving pretty fast. Tell me about that.
That had lights and siren in it. No one ever took it seriously. But I remember pulling out of the parking lot, and I looked to my left, and there's, it didn't seem real. It didn't seem like this. I'm thinking in my head like this is just blown out of proportion because I didn't have my radio on in the car. I couldn't hear the radio traffic at the time, and I looked to my left, and there's two patrol cars, not even from our agency, not even from the sheriff's office, coming around the far corner on this complex by the medical examiner's office and the animal control. And they turned that corner on two wheels on each side, on the back, coming around that corner, and their lights were shining. They were going fast. And I'm like, holy cow, this is real. So then I turned my lights on because I just thought we'd get there and do what computer crimes does, you know? We would do our thing. And I turned my lights on, and siren, and I started going north towards Walton. Telegraph runs up to Walton and it cuts over to M20, US 24. Telegraph cuts up to Walton and it goes over to M24. And I had no idea where the heck I was going. I've been to Oxford for a half a second driving through. And I thought, well, I remember thinking when I get there, I'll just follow the crowd because it's going to be big. And going north on 24, and I see one of our SWAT vehicles going across the bridge from 75 down to 24, and the light was red for me, and I thought, well, I'm gonna have to slow down. Like, there's cars coming down the ramp. And I remember getting closer and closer, thinking, how come nobody's going? Like, my light's red. This cross traffic should be going. Like, because as a police officer, obviously, when you run a red light, it's extremely dangerous. You don't do it haphazardly. And I'm approaching this light, thinking I'm gonna have to slow down. And as I get to the light, I look over and there's a patrol car just sitting. I don't know what agency they worked for. And so I go through that intersection, and then I see them join up behind me, and then I see two other patrol cars from another agency coming up behind me. I remember, I don't know if it was Brown Road or what the next major crossroad up the hill there. I remember that light was red and there were cars stopped in both lanes, and I thought to myself, I'm gonna have to go onto the shoulder. And so I'm looking at the shoulder thinking, I mean, it's part dirt. It's a small shoulder of asphalt and dirt, and my small tires on that minivan, it's not gonna handle well, but we're not gonna stop going, right? So I remember feeling the steering wheel shaking from the gravel, and I get around and keep driving north, crowd still following me. I look up in the mirror every once in a while, and there had to been, I couldn't count them, they were so far deep behind me, and the ambulances and the SWAT vehicle, and we get up into town, up into Oxford, I think we were, and as I'm approaching the light, it just changes red. So obviously cross traffic doesn't know what's going on there. You might just have somebody that just goes straight, and again, it's dangerous. It really is. And so with the lead car, I've always been told the lead car in a situation like that, you always hold that intersection for everybody else behind you because they're coming. And so as I inch into the intersection, I stop dead in the intersection with the lights and siren going. And I counted 16, at least 16 vehicles just go screaming past me. And we start getting into town, and northbound traffic's blocked. It's dead stopped. I remember going against oncoming traffic, and now you see cars coming at you, you know, and you're the whole way there, all I could hear on the radio was staging area on Ray Road and Meyer. That's what I kept on hearing. There was so much radio traffic. I heard bits and pieces of other things, but that like really stuck in my head. And so we're just driving north, and finally I just see a Meyer, and I'm like, okay, well, we got to be far enough north. This is where I got to go. And so I pull off onto Ray Road, and I meet up with other deputies in the area.
Okay. If you could describe to us what you saw when you arrived at that Meyer.
That was tough. That was really tough. I got a daughter who, she's 17, 18 years old, and, you know, 17-year-olds, you know, they wear those tight leggings and all that stuff and small shirts or whatever. I remember standing there on Ray Road, and I see these kids. One kid didn't even have a shoe on. He only had one shoe on. Walking through the snowbank, going down to the Meyer. And I see these girls dressed like my daughter. And it was cold that day. I had two coats on, and I was shaking. I was shivering. It was so cold. I remember offering one of our lieutenants at the time, he didn't have a coat. And I offered one of my coats because I was so cold, and he didn't take it. But you just saw these kids just coming down from where the school was. Like, it's hard to describe. They look like zombies. Like, they had no facial expression, nothing.
So there were kids there. Were their parents at the Meyer too?
Down by the garden center. The crowd was heading that way, and it was chaos. It really was. I really didn't know what to do once I got there. I didn't know where the school was, even though it was just up the street. So everybody was walking to the garden center, so I started going that way. We were told to start getting people to sign their name into notebooks. We were just grabbing them off the shelves in the mire and boxes of pens and stuff, and just write their names in the notebooks for whatever. I don't know why they needed that. So I'm trying to walk around and get this information from people, and then they start yelling. Someone starts yelling, get everybody inside, get everybody inside. So I go back outside to try to usher people in, and I remember just seeing like kids just standing there, and you put your arm on them. You don't want to, they just been through this, whatever happened up there, and I don't want to force them. I'm not going to grab them. I'm not going to make them do anything they don't want to do. So I sort of, like, if they didn't move, I just left them. They were okay. They weren't in harm's way. And I remember seeing parents just standing there, and because these school buses started arriving, and I remember thinking in my head, like, God, that is just crazy. Why in the heck are there school buses? I didn't know anything about the plan if something like this happened at the school. And so, and I just see the parents, like, you see them just almost praying in their head that their kid came off the bus.
After you helped with the names and the notebooks, did you go to the school?
Yes, I did.
Okay. And were you directed to go to school, or did you just know that's where you were needed?
No, one of the other detectives, Jeff Enger, he responded to the school, and he called me on my phone and said they were trying to get the video from the surveillance cameras in the school. And at the time, I was a little more versed in that side of the job. And so he just wanted a little help with it.
Okay. So tell me about, you arrived at the school. Where did you initially go?
I went to what would be the north side of the school. There's a big circle drive there, and it's the side that like the main office is on of the school. Again, there were patrol cars everywhere. There were everybody everywhere. I remember driving up over the sidewalk, thinking, the sidewalk. I remember like the stuff I remembered, like the sidewalk being so high. I thought it was gonna rip the muffler off my car. I don't know why I thought about that. And I go up over the sidewalk, and I just stopped my car because that's what seemed like everybody was doing. And I walk in the door, and one of our sergeants is standing there providing security just for that door, so people aren't coming in. They shouldn't be coming in or whatever. And I asked him where the security office was, because that's where Detective Enger told me he was, and pointed me to the office, and people eventually pointed me back to the security office.
Okay. And who did you encounter when you went there?
As I walked in, I remember seeing the security officer, Jim Rourke, was in there. Deputy Jason Lewert was there. I didn't know him at the time. ATF agent Brett Brandon was in the room.
Right here behind
Yep. And Lieutenant Marsban was in the room.
And you said at that point you were called over to help with the security footage.
That's correct.
Okay, so tell me what your role was at that point.
Well, obviously, the bosses are going to want to know what happened, where it started, all that information, and I wasn't given any direction. We weren't given direction, but we just had to figure out when it started, where it started, how it started, as much as we can, because they're going to want to know that information. And so we just started reviewing video footage.
At that point in time, was the high school still being cleared?
Yes, it was.
Okay. And when I say being cleared, we haven't had another officer testify yet. What does that mean?
To clear something, you're going to look for more bad guys. You're going to look for maybe bombs that might have been placed, someone hiding in a room because they know the police are there, so they're checking every room, every closet, everything in a high school, going door by door, checking it all.
So tell me how it is that you went about your job that you were called there to do that day.
Jim Rourke, like I said, he was the head of security, and they had a system where you didn't actually interact with the DVR system itself. You interacted through a portal, a web page, to access the server where the video was stored at. And thank goodness he was very well versed in that. So I immediately, I told him, I said, well, you got to help me figure this out because I don't know what's going on here. So Jim and I sat there, went to the hallway that started, and tried to determine at what time the shooter went in there.
So how many cameras approximately did Oxford High School have equipped for surveillance footage?
Well, they released 100 cameras.
Okay. And it was your responsibility to review that footage?
Yes, it was.
Okay. Judge, this might be time for a natural break.
Oh, all right. Well, the jury's lunch is here, so that would probably work. I'm not sure if I call you sergeant, detective, lieutenant, Mr., hey you, none of those? That's fine. Okay, all right. You should not discuss your testimony because you're still on the stand right now, so please don't discuss your testimony with anyone.
Yes, ma'am.
All right, so you can step down. If I give you till 1:15, is that okay? Okay, those who ordered lunches, your lunches are here, all right? Do not discuss the case with anyone, don't text anyone, right? Okay.
All rise for the jury.
All right, you can take it
Sorry.
Is the court prepared for ruling on exhibits 133, 153? They would be through this officer's will.
Okay, all right. I will take care of that. All right? I'm trying to I don't want to release the jury until he's...
Yes, Judge.
Other way.
Experts Rick Convertino and Arnold Reed to weigh in on the morning so far. Thanks so much for being here.
Thank you.
So Arnold, what's your take so far on how things are going today?
Well, when you compare it to the last trial, I think things are running a little bit more smoothly for the defense. The prosecution is doing what we have been talking about and anticipated that they would do. With the exception perhaps of this last witness here. I didn't understand the import of what he brought to this trial. It seems as if that he could have been a witness that, I don't know, maybe not bring him on the witness stand. I couldn't figure out what his purpose, was. So I'm anxious to see whether or not the defense will cross-examine this guy. What she's going to get out of him, I don't know. But in sum, I think the trial has been proceeding as we have been talking about. The prosecution is continuing to hammer their theme. The defense is a little bit back on the ropes, but I expect opportunities will arise for the defense to begin to attack, for lack of a better term, some of these witnesses.
Mm-hmm. Why do you think the prosecution called this witness again?
This witness, Rogowski, Special Agent Rogowski, is called. He was qualified as an expert witness in data retrievement from the cell phone and the computers Facebook, the cell phone data through the program that they call Celebrate, which downloads and extracts the information and then puts it in a readable form. But the purpose of his testimony here, as Arnold pointed out, is wholly irrelevant right now. How he got to the scene, his emotional testimony has nothing to do with his expertise. He is going to testify, as he did in the first trial, about his extraction of the video cameras inside the school. You remember in the first trial, he testified as an expert that he extracted the information, and that should be the conclusion of his testimony. The video speaks for itself, but he was allowed in the first trial to walk the jury through in a very emotional, intense testimonial way to tell the jurors what they were actually seeing for themselves, but his interpretation, which was, I believe, highly improper and shouldn't have been allowed. This is the type of witness that should have been objected to in a motion in limine. In limine is Latin for in the beginning or preliminarily. So this witness's testimony could have been greatly curtailed by the defense had they filed a motion in limine to say this is what they testified in the first trial. I don't want to make that objection during the course of the trial. I don't want to look like I'm trying to prevent evidence from coming out. I'm going to make it in this pretrial motion, and we want to curtail his testimony to just his expertise, and that wasn't done. So I'm anticipating the same testimony, the emotional testimony regarding his interpretation of the video, which certainly speaks for itself and is not necessary.
Yeah, there's a lot of things in these trials that seem to overlap with Jennifer and the shooter and now James, but the judge has been very, very strict on the fact that it needs to stick to how he is impacting what happened here. Do you think that we're kind of losing track a little bit with this first testimony?
Oh, with this witness, no question. I mean, he's sitting up here and he's telling the jury about how the muffler of his car almost fell off. I'm like, what is he talking about? The prosecution, though, probably put him up there to continue that imagery, what he saw when he got there, what people were doing, to keep that on the jurors' minds. That's the only thing I can think of. Otherwise, I agree 100% with Rick. File a motion, strike this guy's testimony, keep him limited to what he's there for, and that's to give us cell phone information and how we extracted it.
And we don't expect to see her with him very long, because we were saying with this witness in Jennifer's trial, the defense attorney stuck with him for a long time.
I don't anticipate that here. I think we have a counselor here, a defense counselor who's got a lot more experience in criminal law, and so I wouldn't be surprised if she didn't ask him any questions.
All right. Well, we do have to go on a short break. We'll be back soon.
Hey there, it's Elizabeth Werner, and this is Joe Cohen from Snow Joe, and we are so excited because you are going to tell us about your generator, and this is a complete game changer with all this crazy weather we're having.
Our customers love simplicity.
Yes.
They love no maintenance, but they also want power.
Yes.
And we understand that. So what we have here is a 4,100 watt generator.
Okay.
It runs off a propane tank. And why we like that is that you could store a propane tank for years in the garage safely without having to worry about your gas leaking or oil.
That's right.
You press a button and your fridge is powered, your air conditioner is powered or heater.
All of it. All right, so you just said press a button. Now, what I've known from generators, I had to do this thing to get it started. Very difficult for me.
It comes with, Elizabeth, inside your generator, a Sunjoe 24-volt battery.
Okay.
That's going to be replacing the pull start.
Ah, this is amazing. So, Joe, thank you so much. I have learned a lot today, and I know I need one of these. I'm going to tell everyone else where they can get one also. This is the Sunjoe portable generator. Head over to cbsdeals.com. Right now, this is 56% off. That's just $399.99.
one person who called the police that day to identify their kid as a suspected shooter. It was James Crumbley. This nightmare, these murders, were preventable by him, foreseeable by him.
But what the prosecution wants you to believe, the part that's not true, is that James Crumbley knew what his son was going to do and knew that he had a duty to protect other people from his son. Ladies and gentlemen, that's not true. He didn't know.
Opening statements began and wrapped this morning in the trial of James Crumbley, the father of the Oxford High School shooter.
He's charged with involuntary manslaughter for the November 2021 shooting committed by his son. We thank you for joining us here on CBS News Detroit. We will continue with that coverage once things pick up. We're told that they're going to be on break until at least 1:15. We'll have gavel-to-gavel coverage for you.
Lawsuits. This comes following the Alabama Supreme Court ruling last month that frozen embryos should be considered children, leading many clinics to stop IVF treatments. That decision prompted an outcry from groups across the country. All right, President Biden is set to deliver his third State of the Union address tonight, how he plans to address U.S. foreign policy. Plus, what if I told you you could own a share, not of Beyonce, but of some of her music and Taylor Swift's? We'll explain how a new startup works and whether you can make any money off of this. Oh yes, Stevie Wonder's on there too. You're streaming CBS News.
On our places, bright shiny faces.
When you wake up in the morning, we want to be your go-to team.
Nate has one of the quickest minds I've ever seen.
Tony has a way of making people feel comfortable.
Gail has this unbelievable knack to ask the question that you're asking at home.
I've been told I could talk to a tree, and that's pretty much true.
I don't go to work in the morning. I go for coffee with my two good friends, and we talk about the world.
Your morning routine just got better. CBS Mornings, weekdays at 7.
It didn't seem like anything could happen, because nothing ever happens in East Palestine, but it did.
Authorities released toxic fumes from 5 derailed train cars.
Resident, please evacuate.
Acute bronchitis due to chemical fumes.
Did you ever have these problems before the derailment?
No, ma'am.
This neighborhood's not safe no more.
We can assure the community that there's not vinyl chloride entering their communities.
Then why are there so many people feeling these various symptoms of bloody noses or difficulty breathing or bronchitis?
That's a hard question to answer.
We're talking about one of the most blatant releases of a mixture of some of the most toxic chemicals that we've seen in America.
I feel like now I have a duty to warn other communities. If my daughter has to watch me die of cancer, at least it saves someone else. This case.
It's like a screenplay, something straight out of Hollywood.
But it's not fiction. It's 48 hours.
Human remains found this week.
4 families shattered.
There's no physical evidence.
The mystery would haunt investigators for years.
There's some questions that have to be asked and need to be answered.
Like a John Grisham novel.
A gripping true crime original. 48 hours. Now streaming on the free CBS News app.
This is CBS.
Hello, everyone, and welcome to our Dragon capsule here in space.
Sightseers in space, the thrill of a lifetime.
Seeing the Earth from space, it was so exhilarating.
But the risks that come with the territory.
There have been 4 fatal accidents. That's a 1% fatal accident rate.
Might make you look before you launch.
If you had 1 out of 100 airplanes falling out of the sky, we'd have a public crisis.
Space tourism, now streaming on the free CBS News app.
And warm welcome back to CBS News. I'm glad you're still with us. I'm Errol Barnett. Here's a quick recap of the top stories we're tracking for you right now. Utility giant Xcel Energy says there is evidence that its power equipment was partially responsible for igniting a massive wildfire in Texas. However, the company pushed back against claims by some state officials that it failed to properly maintain its infrastructure. The fires have burned nearly 1,700 square miles and destroyed up to 500 homes and businesses. The U.S. ambassador to Israel says negotiations for a ceasefire in Gaza have not broken down. Hamas left Cairo today without an agreement being reached, but says talks will continue next week. The new development casts doubt on hopes of arranging a ceasefire before the start of the Muslim holy month of Ramadan Sunday. President Biden and his team are putting the final touches on tonight's State of the Union address. The president is expected to draw a link between former President Trump and far-right members of Congress, who the White House accuses of being unwilling to compromise on the big issues. Now, one of the key issues President Biden will be focusing in tonight's State of the Union address is the U.S.'s standing on the global stage. The Biden administration's foreign policy agenda has taken some hits, with Congress failing to pass a new funding package to support Ukraine at a crucial moment. It also faces an uphill battle in the Middle East, where the president is pushing for Israel and Hamas to agree to terms for a hostage release and a ceasefire. Let's bring in Sam Vinograd now. She's a CBS News contributor and a former Assistant Secretary for Counterterrorism, Threat Prevention and Law Enforcement Policy for the U.S. Department of Homeland Security. Sam, great to see you from our D.C. Bureau this afternoon. We are hearing now that President Biden is set to announce the construction of a port in Gaza. Why is this so crucial to his foreign policy agenda?
Well, this really does underscore that the drafting of the State of the Union really does come down to the midnight hour. We understand that President Biden is set to announce the build of a port in northern Gaza to get more aid to Palestinians. 5 months since Hamas's brutal terrorist attack against the state of Israel, we know that there is an urgent need to return Israeli hostages, and there is an urgent need to cease fighting so that more humanitarian aid can go through border crossings and reach Palestinians in need. At the same time, in the absence of a ceasefire, we also know that there are 570,000 people at risk of starvation in Gaza. I'm a board member at Save the Children, and they've advised me that 1 in 6 children in Gaza are at risk of starvation. And building a port, which will, I should note, take several weeks, is really indicative of the president and his administration and our allies using every means possible to alleviate humanitarian impacts of Israel's activities in Gaza. Now, we should note we don't know exactly how this port will be built. who will be responsible for security at the port itself once it is constructed, and who will be responsible ultimately for distributing supplies. We know that there was a horrific tragedy in Gaza just a few days ago when aid trucks when Palestinians came under fire trying to get food at aid trucks. So the details are going to be quite important here.
Right, Sam. So there's a little bit of dissonance in what you're saying. On one hand, there's starvation. There's an urgent need for aid. There was a recent aid effort that led to civilians being killed. And on the other hand, while building a port sounds great, those questions of how it will be built and who will be responsible for it are pretty crucial. As someone who's been in the White House and watched these decisions unfold, help us understand how we get to this point where it will be announced, but the details still seem scarce.
Well, typically, prior to a president making an announcement like this, let's look back to 2013 when I was in the White House and President Obama announced a further drawdown of U.S. troops in Afghanistan. Prior to an announcement like that or an announcement about building a port in Gaza, those operational plans have been presented to the president so that he isn't boxed in making an announcement at this scale in the middle of a State of the Union without the details being hammered out. So I would assume that there was a National Security Council meeting with the president in which operational plans were presented, the risks were presented, and detailed plans were presented to the president so that he understands how this would work, how it would impact the U.S. military, what kind of funding is needed. I believe a port like this would probably cost about $100 million to build, and so that he had a really good understanding of operationally how this would work and what kind of impact it would have. With 570,000 people at risk of starvation in Gaza, the need for adequate supplies is significant, and if the president has decided to use, let's say, an amphibious warship anchored off the coast of Gaza, that would be one way to get real mass quantities of supplies into the Gaza Strip.
I want to ask you about some of the expected or invited guests to the State of the Union. President Biden invited Ukraine's First Lady, also the widow of Alexei Navalny, the Russian dissident. They were unavailable. The Republican House Speaker Mike Johnson's guests include the parents of Evan Goskovich and an Israeli hostage released by Hamas after 54 days. What does that tell us about kind of the stagecraft of what we will witness tonight?
Well, I should note that this State of the Union is unique in the sense that the content of the speech is important, but perhaps what's equally, if not more important in the State of the Union is a president's delivery. So it's clear from the invited guests that Russia, Ukraine, and in addition, we know that there are guests that have been affected by IVF and other reproductive issues, that those issues are going to play a key role in the State of the Union. But separate and apart from the actual content, the eyes of the world are going to be on how the president actually delivers this speech. It is a lengthy speech that's going to hit a lot of topics. Having been involved in drafting, there is an attempt to avoid a Christmas tree effect in a laundry list of topics, but how the president delivers the content here is going to be key. We know that the Middle East, Russia and Ukraine and likely China will factor prominently into his remarks, and the guests really do underscore that.
All right, Sam Vinograd, great to chat with you about tonight's State of the Union address and other big topics. We appreciate it.
Thanks.
And a reminder for you all, be sure to stream our State of the Union coverage tonight. We'll have updates and analysis beginning at 5 p.m. Eastern right here on CBS News. Sweden is officially the 32nd member of NATO. That ends decades of Cold War neutrality after growing concerns over Russia's invasion of Ukraine. Secretary of State Antony Blinken joined Sweden's Prime Minister to make that announcement in Washington today. Sweden, along with Finland, moved to join NATO after Russia's invasion back in 2022 of Ukraine. That led to concerns over a wider aggression throughout Europe.
Swedes realized something very profound, that if Putin was willing to try to erase one neighbor from the map, then he might well not stop there. And if he was allowed to proceed with impunity, not only would his aggression potentially continue, but would-be aggressors everywhere would get the message that it was open season.
And another note for you, Sweden's Prime Minister will be in the First Lady's box as President Biden's guest for the State of the Union address this evening. All right, if you are scrolling on your phones right now, listen up. If you lose precious minutes, hours, you could say, of your life scrolling TikTok, you will want to pay attention to our next story. Lawmakers taking up a bill that could eventually ban this popular social media app. We'll look at if this legislation could even be enforced. You're streaming CBS News.
Washington is the seat of power. National security, foreign policy, global economics, every story comes through Washington in some way. We bring some of the most powerful voices in America to the table. We don't just ask the questions, you have to go deeper. We try to understand what's at the heart of the issue we're talking about, to then come forward with solutions.
Face the Nation on CBS.
The justices ruled that Harvard and the University of North Carolina violated the Constitution.
In the aftermath of the Supreme Court decision to end affirmative action in college admissions, uncertainty sets in for some students of color.
Affirmative action really gave us an equal opportunity.
CBS Reports explores the historic decision and what it means for those chasing an opportunity to change their lives.
I knew that college was the ticket to break this cycle.
The end of affirmative action, now streaming on the free CBS News app.
Okay, let's go. You guys good?
Hey.
All right, we good?
Keep going. The clock, it's ticking.
Off we go.
60 minutes. 60 minutes.
60 minutes.
It's time for 60 Minutes, Sundays on CBS.
An original documentary from CBS Reports.
AI is among the most world-changing technologies ever.
Curing diseases, scientific breakthroughs, making lives better.
They can help us with medical discoveries, scientific discoveries, doing better agriculture, having cures for things like Alzheimer's.
It's also going to really transform the way we work.
The uplifting potential of artificial intelligence is limitless.
It gives you a friend, somebody to chat with 24/7 that is non-judgmental. He makes me feel loved and desired.
And so are its downfalls.
The problem with all this AI is that it's unpredictable and uncontrollable.
The choices we make now will have lasting effects for decades, maybe even centuries.
The ChatGPT revolution, now streaming on the free CBS News app.
We are about to see American weapons in the hands of Mexican cartels.
A gun pipeline to Mexico.
We are arming the cartels.
100%, no doubt about it.
Happening right under our noses.
Who's doing something about this? Nobody.
A CBS Reports exclusive.
Most Americans have no idea that we are effectively arming the enemy next door.
This is the story the American people need to know.
Arming cartels, now streaming on the free CBS News app.
America Decides, taking you inside American democracy.
The most important stories on a day-to-day, hour-to-hour basis.
You're going to hear a lot of reporting.
It is clearly a pivotal moment.
Gun control, the economy, education.
Both sides of the political aisle fight it out for power.
Bringing you the analysis that you need.
Thoughtfully, with context.
Be part of the conversation.
On CBS News streaming.
Welcome to America Decides, Monday through Thursday at 5 p.m. Eastern.
We find the defendant, Hannah Gutierrez, guilty of involuntary manslaughter as charged in count 1. We find the defendant, Hannah Gutierrez, not guilty of tampering with evidence as charged in count 2.
There we have it. We watched her reaction to the verdict. The armorer involved in the fatal Rust film set shooting has been convicted of involuntary manslaughter. A New Mexico jury, as you heard there, announced the verdict shortly after closing arguments concluded yesterday. The prosecution argued that Hannah Gutierrez Reed loaded a live round in the prop gun actor Alec Baldwin was holding that went off and killed the film's cinematographer, Helena Hutchins. Gutierrez Reed was acquitted on an evidence tampering count, I should say, relating to possessing narcotics on the movie set. She now faces up to 18 months in prison. Baldwin's involuntary manslaughter trial is set for July. He denies pulling the trigger on the prop gun. Right now, lawmakers are reviewing a bipartisan House bill that could ban TikTok across the nation. The House Energy and Commerce Committee is holding a hearing on legislation that would require the popular video-sharing app to separate itself from its Chinese-based owner, ByteDance, or risk being prohibited from app stores in the U.S. Panel members say this hearing is happening in response to growing concerns the Chinese government could access TikTok users' personal information. A woman who uses TikTok to promote her company expressed fears about a potential ban.
it wouldn't kill us tomorrow, but TikTok as a platform has represented a very kind of meaningful and new way that we reach consumers.
TikTok has slammed the bill via social media. The company says if enacted, the measure would, quote, trample the First Amendment rights of 140 million Americans and hurt small businesses. Jessica Levinson joins us now to delve into this for us. As you all should know by now, she's a CBS News contributor and professor for Loyola Law School there in California. Jessica, this is a remarkable one. You know, TikTok says this bill kind of violates freedom of speech. How strong a claim is that?
I think at this point, it's a claim that the government could get over, because the question is actually whether or not the First Amendment is even implicated here, in the sense that the government is not required to say that when it comes to all of these different private companies and platforms, that they have to be allowed to operate. The First Amendment is really about protecting us from the government saying, don't criticize me, or the government telling us not to use certain forms of expression. This is a medium. And so if it is such a big medium, if it is such a big public forum, that shutting it down does give rise to First Amendment concerns, then we are within the First Amendment. But I would say that's just step one, right? Step two is, can we withstand that ban? Because as you and I know, the First Amendment is not absolute, and you can restrict speech for certain reasons.
What's also remarkable to me is take a look at what Meta collects on its users of Facebook and Instagram. Take a look at what Amazon collects for everybody who uses that to shop. There are plenty of US-based companies that do all of this data gathering. So on what type of legal grounds can the US demand TikTok make a massive change in separating itself from its parent company, ByteDance?
I think the question is, the way you phrase that is great, because the question really is what's different between Meta, that does collect data about us, and TikTok, which arguably also collects data about us. And the answer is national security concerns. So we might have privacy concerns when it comes to both companies. Now, I would offer that I think the privacy concerns are likely different, but the real difference here is the idea that because TikTok is owned, the allegation is, by basically the Chinese government, that it raises national security concerns. They could try, for instance, to influence the election.
Even if they ban this app, can that be enforced?
This is a devil's in the details. The legislation says that it would be shut down from the app stores and web-based hosting. We're not there yet, but that obviously would create huge practical hurdles.
Yeah, kids know how to use VPNs these days. Jessica Levinson, always great to see you. Thank you very much.
Thank you.
Buying an artist's music online, that's one thing, but how about owning a share of a song's royalties? We'll explain how a new startup works and which artists are involved. You're streaming CBS News.
Go to the ends of the earth.
Right now.
We got something crazy. And reach for the stars.
Here we are.
Time.
Yes, it's my comeback.
Hey, this is pretty fun.
But wait, there's more.
Experience thought-provoking.
Welcome to the idea of being a human being.
Innovative and truly original reporting.
Look through a telescope and go, wow.
Because there's always something new under the sun on CBS Sunday morning.
At this moment, terrorists could be plotting another attack.
9/11 triggered a counter-terrorist system that included a secret database.
This person needs a closer look.
A growing list of nearly 2 million people, including some Americans who say they're innocent.
For a 1-hour flight, I have to spend 6 hours to go and come back.
CBS Reports explores the system, the people responsible for it, and those pushing for change.
I'm not fighting against them. I'm fighting for them to do the right thing.
The Watch List, now streaming on the free CBS News app.
Don't miss true crime anytime you want, anywhere you go. With the 48 Hours podcast. Real crimes, real lives, real justice.
There's some questions that have to be asked and need to be answered.
Listen to 48 Hours on Apple Podcasts.
An original documentary from CBS Reports.
Imagine yourself in Manhattan with no police, no army, no mayor.
The people of Haiti stare down poverty, corruption, natural disasters, and violence.
90% of the guns that are used by gangs in Haiti are American guns.
But with an unbreakable spirit and eternal optimism.
There are days where I cry, but we can't be discouraged. We still believe in Haiti.
They're still able to look ahead with hope.
Haiti is on the brink of transformation, a radical shift. Haitians are coming together and saying things must change.
Fighting for Haiti, now streaming on the free CBS News app.
Everybody wakes up in the morning and they are pelted with alerts that frighten them, news that agitates them. With this show, we have the time to explain what's going on. These migrants, they've been released. Explain the status that allows them to be released, to slow things down a little bit. What are the big sets of questions for China and its ambitions? Hackers are stepping up their attacks to extort victims. Let's start with easy. Who's attacking? Here's a deeper understanding of what's happening.
Prime Time with John Dickerson. Stream on the free CBS News app.
When you wake up in the morning, we want to be your go-to team.
On our places, bright shiny faces.
I don't go to work in the morning. I go for coffee with my two good friends, and we talk about the world.
Your morning routine just got better. CBS Mornings.
In Germany, hundreds of flights and trains have been cancelled after two separate unions began a two-day walkout this morning. The labor action is an escalation of the ongoing demand from both airport ground workers and train drivers for higher wages and better working conditions. The strike is expected to last until Saturday.
I'm surrounded by your embrace. Baby, I can see your halo. You know you're my saving grace.
Who doesn't love that song, right? Well, we know that Beyoncé's 2008 hit Halo owns a spot on your playlist, but now you can actually own a piece of that song. The company Jukebox has opened a marketplace where you can buy securities backed by streaming royalties from music, similar to owning stocks. Let's bring in Alexander Osipovich now. He's a reporter at the Wall Street Journal. He's covering this topic. It's a fascinating new place we can spend money, Alex, but I just want to understand the concept at its most basic level. How does this work exactly?
So every time a song is played on a streaming platform, or if it's used in television or movies, it generates payments to the rights holder, whoever holds the rights to those songs. So it's an income stream. And essentially what Jukebox has done is it's created securities where by owning shares, you get a little slice of that income stream.
That's fascinating. So if you and I put our heads together and we wrote a hit song, we could basically sell our royalties where people could own a piece of this. And I looked through your article for the Wall Street Journal, and as you note, returns for this type of security is about 3%, which isn't bad, but that is lower than the 4 to 5% you would get putting the same amount of money in a high-yield savings account, for example. So who is this type of investment really designed for?
Well, it's debatable whether it's a good investment, because right now I can get 5% yield just from putting money in a conventional money market fund.
Right.
But it might be of interest to fans who just want to hold shares of songs that they like. And there's also a bit of a speculative aspect to it, because potentially, let's say an old song gets used in a hit movie or TV show, or just has a big revival. Then those payments could suddenly increase significantly. To be clear, the 3 to 4% is a trailing average, so it's based on the performance over the past year or so, and it could change in the future, for better or worse.
Okay, so it's highly speculative, but we're showing our viewers just some of the artists' tracks that you could effectively own. We mentioned Taylor Swift, One Republic, Stevie Wonder, Adele. And as far as this being a questionable investment, there is some precedent for artists creating investment vehicles from their music. David Bowie, for example, you write about in your article, kind of paved the way for something like this back in the 80s and 90s. What did he do, and how did it change things?
Yes, David Bowie, besides being a pioneer of rock, was also a financial pioneer. In 1997, he sold the rights to his future earnings from a catalog of songs for over $50 million. People called it Bowie bonds. And that set off a precedent in which periodically artists or producers have sold off catalogs of songs, the rights to those songs, to big investors. Sort of large private equity firms very often do this. And so this market has existed for decades, but it's been sort of a big institutional market. You know, big slugs of hundreds of millions of dollars are spent on these catalogs. Jukebox is trying to make it more of a retail market.
Well, it's a fascinating side of the financial world, and as you write about, it's basically bonds for beats. Alexander Osipovich with the Wall Street Journal, thanks for joining us today.
Thank you for having me.
All right, coming up in our next hour, a look at what's at stake as President Biden puts the final touches on tonight's State of the Union address. We'll also bring you the latest from Gaza, where hopes for a ceasefire between Hamas and Israel begin to fade. And severe weather could be on the way for millions of you as major storms begin to develop in the south. We'll have an updated look at your forecast. All this and more next, right here on CBS News.
Okay, so let's just start at the beginning.
Well, let me start with this. What is at stake here?
What is the answer then?
Do you know why?
You want me to just keep going?
Is that a good thing or a bad thing?
Were there death threats?
How is this possible?
What's wrong with that argument?
Are you saying they lied?
Have you told the government that? Why won't you say the word crisis?
You're not answering my question.
This really
Is that scary?
Does that make sense?
What do you mean?
What does that mean in
Did any of that make sense?
What's your response?
What happened?
Why?
It's time for the CBS News Original 60 Minutes, Sunday on CBS and streaming on Paramount+.
There is no more room in our city.
New York City is receiving record numbers of migrants.
Today, we're going to have more than 500 adults and children come through that door.
Tensions rise as shelters reach max capacity.
We don't have to take care of them.
CBS Reports goes inside a crisis cities and families are facing as they fight to survive.
The United States still has that glimmer of hope for people to come here.
Fighting for a future. Now streaming on the free CBS News app.
On Face the Nation, the way to learn is to listen.
We may have a recession.
Listening to how someone explains themselves is so key to understanding their perspective.
An original documentary from CBS Reports.
Since you started La Soup in 2014, do you have any sense as to how much food you've rescued from the landfill?
We've rescued 4.5 million pounds.
I can't even fathom how much food that is.
And that's one little person in one little city in America. We're going to call this chicken piccata. We did 450 of these meals today.
This is the exact dish
Yep,
you and I are going to have.
Yep.
Oh, really good.
Is it good?
Mm-hmm.
Having a plan of how to keep people fed should be in every single city.
So if we eliminated food waste, could we eliminate
hunger? Yes.
Eating Trash, now streaming on the free CBS News app.
America Decides, taking you inside American democracy.
The most important stories on a day-to-day, hour-to-hour basis.
You're going to hear a lot of reporting.
It is clearly a pivotal moment.
Gun control, the economy, education.
Both sides of the political aisle fight it out for power.
Bringing you the analysis that you need.
Thoughtfully, with context.
Be part of the conversation.
On CBS News streaming.
Welcome to America Decides.
This is CBS.
The State of the Union live team coverage tonight starting at 9 on CBS.
At the CBS Evening News, we focus on solutions, finding solutions to healthcare problems, how much money we can spend on groceries, finding solutions to help people understand what are the right choices to make for you and your family.
Hey there, everyone. I hope you're making the most of your Thursday. Thanks for spending some of it with us here on CBS News. I'm Errol Barnett. Here's a quick look at the top stories we're tracking for you right now. It is a busy day at the White House, where President Biden is preparing for one of the most closely watched State of the Union speeches in years. The House sends a funding package to the Senate with just one day remaining before a partial government shutdown. And hopes for a ceasefire in Gaza by the weekend have faded, but Hamas says a new round of talks are on the table for next week. And later this hour for you all, shock and anger in Philadelphia, where 8 teenagers were shot near a bus stop. The search for the shooters and the efforts to improve safety on the city's mass transit. And the future of TikTok, right now, it hangs in the balance as a bill banning the social media giant starts making its way through Congress. We'll break down the legislation and look at whether it could hold up in court. Tonight, President Biden will be on Capitol Hill to deliver his third State of the Union address. This is a massive opportunity for the president as he prepares to lay out his agenda in what is the middle of a fierce election year. Reproductive rights and the economy are expected to be major topics. CBS News Chief White House Correspondent Ed O'Keefe joins us at the White House with more. Ed, what can you tell us about tonight's address?
Errol, good to see you. We know final preparations are being made by the president. And to answer your question, we actually have some help from somebody who works in the building. Olivia Dalton is the Principal Deputy White House Press Secretary. Good to see you.
Good to see you too, Ed.
So, final preparations here. What is the goal for tonight? What's the president hoping to convey?
Well, this is one of the biggest speeches the president gives all year. More eyes are on him than all year. For the first time, we're also putting this speech on Instagram Live and encourage anybody out there to go to Instagram or to whitehouse.gov, and they can actually interact with the speech this year for the first time. So big opportunity, big audience. The president is going to lay out a clear contrast and compelling vision for the path forward for our country. He'll talk about his core values, from defending democracy rather than diminishing it, to defending our most fundamental freedoms rather than ripping them away, to continuing the progress that we need to make as we try to keep our foot on the gas of this economic recovery. His policies showing that building the economy from the middle up and the bottom out has proven to be effective, as the United States has led the world in terms of a post-pandemic recovery.
How do you, part of the reason why I like talking to you about the president is because you've been around him for so long. You were with him earlier this century when he first ran for president, in the Senate office when he was vice president. You traveled back with him from Camp David earlier this week. The prep for this is pretty intense, isn't it? He really dives into this quite deeply.
You know this too, Ed, as you alluded to. I think we have some fond memories driving around the snowdrifts of Iowa in 2007 together in less glamorous times. But, you know, the president is somebody who knows the power and the importance of communicating with the American people. He puts a lot of time and effort into speeches because he really values, he thinks it's one of the most important things he does as commander-in-chief is communicate to the American people. So he spends a lot of time on it. He spent time over the weekend in Camp David with senior advisors and speechwriters putting the final touches on this. And this will be a message that communicates his most fundamental values and who he is as a leader, his optimism in America and who we are as a country, that we can do anything if we do it together. And he'll talk about the road ahead and how we rise to meet the challenges of the coming years.
So I heard you say defending democracy, protecting rights, which is White House speak for issues like women's reproductive rights, right?
Women's reproductive rights, voting rights, standing up for civil rights. You know, and you know, we've seen against the backdrop of all of the what's gone on in Alabama, the abortion bans across the country, reproductive rights are at stake. And, you know, the president will talk about the importance of codifying Roe. That remains an enormous priority for this administration in the wake of the Supreme Court's decision a couple of years ago. And what did we see from the other side tonight? They are going to double down on their extremism in a rebuttal that is designed to highlight their work to take us backwards by 50 years.
You're talking about Katie Britt, the
Exactly.
Republican senator from Alabama, who will be the GOP responder, yeah.
That's exactly right. And what happened in Alabama is a direct consequence of all of the legislation that has flown out of Roe, the repeal of Roe. And really, it represents a taking us backward 50 years, while Joe Biden will talk about how he takes us forward.
So then he gives a speech. How do you sell it on the road in the coming days afterward?
Well, as you alluded to, the president's going to hit the ground in Philadelphia, the Philadelphia area tomorrow. He'll be in Atlanta on Saturday. The vice president is headed out to Nevada and Arizona, and the members of the cabinet are going to fan out across the country. The president is also going to launch next week, stay tuned, a very rigorous travel schedule in the weeks ahead to continue taking this message on the road directly to Americans.
Yeah, we're preparing for that. One thing we're preparing for, too, is your imminent departure from here. We appreciate all the help you've given us in the last few years. Good luck with whatever's next.
Thank you so much, Ed. It's been a real honor.
Yeah, well, and we'll see how tonight goes. Errol, that gives you a sense of what to expect. The president expected to leave the White House tonight around 8:25 or so, head over for the 9 p.m. Eastern speech. She suggests Instagram. We, of course, suggest watching it here on CBS News. But we'll have updates throughout the day.
We'll be showing it in stereo and in full screen, so it's probably better than on your device. Ed, thanks to you and Olivia, your Iowa snowdrift buddy. We appreciate the update.
Take care.
Police in Philadelphia are giving an update right now on the case of 8 teenagers who were shot near a bus stop yesterday. Let's watch them.
Just to go over quickly what we know now, approximately 3 p.m. yesterday, Philadelphia police responded to 7300 Rising Sun Avenue for a report of multiple people shot. When the officers arrived, they found 8 juveniles shot at that location. All the juveniles were taken to various hospitals. Now I can tell you that at least 3 went over to Einstein Medical. Jeans Hospital took 1, and Jefferson Tarsdale took 4 individuals to the hospital. Moving through that, we had 1 17-year-old male, 4 16-year-old males, 1 16-year-old female, and 2 15-year-old males. All of those victims were students at Northeast High School. One of the individuals shot, the male who was, I believe, 17 years of age, was shot 9 times. He went to Jefferson Tarsdale in critical. He's still in critical. We checked on him today. I am told that the doctors are optimistic. We have to get through today, but they're looking to hopefully upgrade him at some point. So right now he's in the hospital, and he needs people to keep him in their prayers to move along. So the investigation last night, we did a lot of interviews. We pulled video from various locations. Some of it we got out to use very quickly. You've seen in the video, there's a blue vehicle that it appears the 3 individuals responsible for this, after they perpetrate the crime, they retreat back to the car and it pulls away. So we now know, because that car wasn't driving itself, that there's a 4th individual in the car. I don't have much of a description of that individual. Last night at approximately 10:31 p.m., Highway Patrol officers working did recover a 2018 blue Hyundai Sonata. That was up in the 400 block of West Fern Street. We do believe, through our investigation, this is the car involved and the car that you see on the video. So that car was towed to our facility where we process vehicles. Because of the weather yesterday, we had to take that vehicle inside, and we're going to do everything we can today to get our forensic evidence and other evidence from that vehicle, but we had to let it sit and dry out. So give you a little background on that car. That car was stolen from the 7th District, a location up in the 7th District. When officers went to take the report on that stolen car back on the 2nd of March, they found another stolen car parked there. Okay, so based on our investigation, and that was a Kia, it was a gray Kia Sportage. Based on our investigation, right, that car was taken to that location, and the individuals exited that car and then stole the Hyundai. So that car, we believe, is involved with the car you've seen yesterday. So that was also recovered. We are also looking to pull as much forensic data out of that car that we possibly can during the course of this investigation. That had been previously towed to a lot. It was still there, so we're going to use that to help in this case. And we did several interviews in the area of that theft. People did see things. We had some video we were able to recover there and some other places. So things are starting to come together based on the video that you put out yesterday. We have received numerous tips, and we are working on them tips. We encourage people to continue that because some of those tips are corroborating information we have that I can't talk about yet. But we are moving towards knowing more about what happened yesterday and who we may be looking for. All right?
Is it safe to say that you think that this is two groups, one
All right, we've been listening there to police give an update on the shooting of 8 teenagers near a bus stop in Philadelphia yesterday. All of those who were shot are students. Right now, a 17-year-old male who was shot 9 times remains in critical condition. Police there also giving an update on a blue vehicle they find as really the escape vehicle, which is central forensic data still being analyzed from that. But of course, this has shaken Philadelphia and has many concerned as violence there and incidents like this continue to happen in the past few weeks. So they're still looking into tips as well, if anyone out there knows anything about what happened yesterday afternoon. All right, the Senate is expected to soon vote on a major funding package that would avert a partial government shutdown this weekend. The House overwhelmingly approved the $460 billion measure yesterday. It provides funding for the Departments of Agriculture, Commerce, Justice, and several other agencies and federal programs through September. Now, if the bill doesn't pass, a partial shutdown would begin after midnight tomorrow. The full government shutdown deadline is 2 weeks later. CBS News Congressional correspondent Nicole Killian has been following all of this from Capitol Hill. Joins us now with an update. Nicole, I mean, this was a major passage in the House. I think the vote was 339 to 85 yesterday. I'm wondering if we can expect that same type of bipartisan support in the Senate.
I think you will. I mean, obviously in the House, in order to get this across the finish line, it really needed Democrats to do some of the heavy lifting, since a number of House Republicans opposed the package and opposed the way that Speaker Johnson approached this particular agreement in terms of lumping about 6 of these appropriations bills together. That being said, while there are some Republicans in the Senate that are also opposed, at the end of the day, this will likely clear with pretty overwhelming support. And nobody wants to shut the government down. You know, congressional leaders from Leader Schumer to McConnell, Johnson, Jeffries have all made that clear. So that's why this package is moving forward with relative speed, although it kind of took a while to get here.
Boy, did it take a while to get here. You know, in just the last few weeks, Congress has really only been able to pass these CRs, these continuing resolutions. In layman's terms, they're just short-term funding patches to temporarily avoid a shutdown. So what's different this time around?
Well, this was the end game. You know, at the end of the day, Congress is required to pass appropriations bills. There are 12 of them that they have to pass every year to fund the government in its entirety through a fiscal year. Well, that hasn't happened for some time. That's why we continue to have these threats of government shutdowns constantly hanging over us here on Capitol Hill, because there have been several, as you mentioned, of these temporary funding patches. I believe there have been up to 4 this cycle alone to try to get through fiscal year 24. So basically, this was work that Congress has been working on, trying to get agreement around some of these appropriations bills. Again, in this tranche of funding, you have 6 appropriations bills that are moving forward to fund various agencies, as you alluded to, like the Department of Agriculture, Housing, Transportation, Justice, Commerce. And then we will see Congress take up another tranche of funding for the remaining 6 agencies before that funding runs out. March 22nd.
And one of the sticking points that you've shared with us so many weeks is the foreign aid bill. The House still hasn't held a vote on that $95 billion aid package. It's for Ukraine, it's for Israel, it's for Palestinians in Gaza. What is the latest on that? And I'm wondering if the president's speech tonight might be aimed somewhat to help move that ball across.
Well, it's likely that we will hear the president kind of reiterate the importance for this package. As you may recall, he had congressional leaders over to the White House a couple of weeks ago to drill that point home. So he will likely continue that drumbeat tonight. Whether or not it moves the needle in the House remains to be seen, because up until now, Speaker Johnson has not been committal about bringing that bill to the floor. He still insists that there has to be some kind of border security component to that. But as you know, that was part of this package originally when it started in the Senate, and it was Republicans who opposed that, and as a result, those border provisions were stripped out. So there is an alternative bipartisan proposal that's starting to circulate in the House. Whether or not that advances remains to be seen, but you know, the White House continues to warn, particularly for Ukraine, that funding is running short, equipment, military supplies are running short, and so that funding needs to be approved as soon as possible.
All right, Nicole Killian, thank you very much. European leaders are condemning Russia's deadly attack on the southern Ukrainian port city of Odessa. That's where President Zelensky was meeting with the Greek Prime Minister. Now, Ukrainian officials say no one in the political convoy was injured, but 5 people elsewhere in the city, they were killed during that strike. Russian media says Moscow was targeting a sea drone facility. Retired U.S. Army Major and military analyst Mike Lyons joins us now to speak about what this all really means. Major, we know that Greece is an EU and NATO member. I'm wondering what the concerns are about this specific attack, considering the message Moscow might be trying to send by conducting a strike at that location at that time.
I'll take them on face value and say it was a military target they were going after, and it was a ballistic missile, so it wasn't necessarily targeted in that, you know, a guided missile could have made it a lot more accurate. But they came very close to a NATO 5 issue or a Article 5 issue if you decide to take out a Greek leader or decide to try to assassinate the leader of Ukraine. So you bring all those factors into this. It was an unfortunate situation from Ukraine's perspective, but they're going to go after Odessa. That's the last major supply chain that exists for any kind of traffic into the Black Sea there. And I think that that's a military target from Russia's perspective, and just unlucky that they were in the same location.
Now, I want to talk to you about this Lithuanian intelligence report. It's warning, in effect, that Russia, in fact, has enough resources to keep fighting in Ukraine for at least 2 more years. And we know that Ukraine continues to desperately plead for more aid, not just from European nations, but from the U.S. as well. That's held up in Congress. And Zelensky appointed a new head of the military recently. Can Ukraine realistically keep up the fight for 2 more years?
Errol, I think that's right. 2 years is likely at least what Russia could do. They've got industrial capability that Ukraine doesn't have. They outgun artillery, Ukraine artillery, at least 6 to 1. I believe anywhere from 120 to at least 180 days, the Ukraine military runs out of artillery ammunition. We saw a report today that there will be more artillery coming from, I believe it was Denmark and Norway are signing an agreement in order to send more artillery. But you know, they're using about 100,000 rounds a month. The United States supplies about 45,000 of that, but the supply chain is running out. So no, I don't believe without the $60 billion aid package coming from the United States that Ukraine will be able to hold on. The definition of that is at least the lines that currently exist. You know, Russia still occupies most of that area that they had since 2014. But what does the rest of that look like? Do they move on Kyiv? Do they move on further areas there? And that just remains to be seen.
Well, Ukraine says it's planning more counteroffensive actions against Russia. Why is this moment so crucial?
Yeah, I saw that report. I'm a little bit concerned about that. I think that's probably more of a political statement than it is a military statement. They don't have the capacity to do that right now. The F-16s would have to come from the U.S. and other aircraft. You know, they would have to have much more offensive capability. They've been on a counteroffensive since June of last year. That wasn't effective, and Russia ends up taking a few towns back. We see Russia continuing to move forward certain areas 5 and 10 kilometers at a time. But I think that, again, that's more for the edification of the Ukrainian population, is to try to say it's always better to be on the offensive. No question about that. But from a straight capacity perspective, I'm not sure where they would attack. The only way they get Russia's attention is if they can possibly threaten Crimea, and those would be a focus of efforts in the south. But once they do that, if they move troops down there, then they leave themselves weak in the east, and that's where they're very vulnerable.
And that grueling war continues. Major Mike Lyons, thanks for your insight today.
Thanks for having me.
All right, coming up for you all, the father of a school shooter is on trial in Michigan. We'll look at opening statements and how his wife's conviction could impact that case. And Alabama moves to protect IVF treatments. We'll look at the new law going into effect after a state Supreme Court ruling led providers to stop offering that type of care. You're streaming CBS News.
Mr. President, there's a lot to talk about.
A lot to talk about.
If China invades Taiwan, what will the U.S. Navy do?
Here in Tel Aviv, second siren in about 10 minutes. This Humvee just pulled up and said, it's time to leave.
The CBS Evening News with Nora O'Donnell.
I had progressively fallen deeper into the world of online sports betting.
The risk is the rush.
What do you think is driving the spike in popularity?
I think it's legality.
If it's legal, I'm going to use it. There are ways to bet when you are 18.
We've created an epidemic of child gambling.
You can't walk into a male dormitory in a college campus without sports betting happening.
It's America's most neglected problem.
I used sports betting as a way to escape, when in reality, I'm choosing self-destruction. Whatever I had left, it was gone.
The purpose of the industry is to get you to play to extinction. And that means until all your money is gone.
Stories start with the who, what, when, and where. But it's why it's important to you that matters most. Knowing what to ask is how you open the door to a deeper understanding. See you on Prime Time, streaming free everywhere.
An original documentary from CBS Reports.
That desired farm is a wonderful place to raise children, and it still is.
Promises broken.
Black Americans have been the target of racism and discrimination pretty much from the time they acquired ownership in the land.
Costing black farmers hundreds of billions in generational wealth.
They did everything to make sure we were run off that land.
What happened inside that school was truly a nightmare come to life. But it didn't have to. That nightmare was preventable. There are 3 people in this world who are criminally responsible for the deaths of Hannah, Madison, Tate, and Justin. The shooter who committed murder, no doubt he's responsible. But so are his parents. But not for murder. They're responsible for their gross negligence, for involuntary manslaughter. Because that nightmare was preventable and it was foreseeable. The shooter's case is done. The shooter's mother, Jennifer Crumbley, her case is done. You're here to decide the level of gross negligence of James Crumbley. And you will learn throughout this trial that he was the adult out of anyone in the world in the best position to prevent these kids' deaths. Those kids would still be alive today had James Crumbley seized any one of the tragically small and easy opportunities given to him to prevent his son from committing murder. Any one of them. These were opportunities that were literally given to him, yet he disregarded. All right, we just heard a portion of the opening statements in James Crumbley's trial.
The prosecution argues that he failed to exhibit reasonable or even ordinary care to prevent his son from carrying out an attack against his classmates.
Lawyers Richard Convertino and Arnold Reed join us now as we continue our gavel-to-gavel coverage for analysis of the father of the Oxford school shooter's trial as it continues. Gentlemen, thank you both for being here.
Thank you.
Thank you. Rick, we'll start with you. What are your thoughts on what we've seen play out so far today?
Well, it's was
opening statements on by both parties were clear, concise, I think straightforward and effective. Unlike the last trial, I think that James Crumbley's attorney is doing a fairly good job right now, and the prosecution is too. There was something that occurred pre-trial when we first got here this morning that I think is important to go back through, and that is the exclusion of evidence regarding the text messages that were sent between between Ethan, the son, and Jennifer, the mother. And those text messages were excluded today by the judge. She ruled that there was no evidence that James Crumbley was aware of the conversation that occurred. And the importance of the exclusion of that evidence was that those were text messages, in part, that discussed the son's hallucinations. If you recall from the first trial, the shooter had hallucinations that there were people in the house, kind of that he was beginning on this entropic, slippery slope downhill, that his mental well-being was sliding into despair, and those are going to be excluded in this trial. So that's a key piece of evidence that's not going to be heard in this second case. I think that's important to recognize.
And we do have that moment. Let's listen in.
989 FH.
Thank you, Marquise, on behalf of people.
Karen McDonald on behalf of.
All right, we do understand the court is resuming now after a lengthy lunch break. Let's have a listen in.
About numerous exhibits. A number of exhibits were allowed in, some were excluded this morning. There was a question remaining about People's Proposed Exhibit 133 and People's Proposed Exhibit 153. People's Proposed Exhibit 153, we heard argument about, it's the court's ruling that this exhibit does not qualify under any hearsay exception. It's the same ruling and for the same reason that Exhibit 118 was excluded. And then as it pertains to Exhibit 133, I broke this exhibit down into two parts. The first one is the Tuesday 10 a.m. I have to go to my kid's school. Counselor just called, and this is what I'm dealing with. I'll be back by 11:30 to 12, the latest, with a picture of the math homework. And that was a text between co-defendant Miss Jennifer Crumbley and her friend. And I don't find this text relevant to the case of James Crumbley. So I'm going to exclude it, except the prosecutor may raise it if it's necessary for some reason, an impeachment such as chronology or a knowledge issue. So if it's necessary to impeach some other evidence that's admitted, I'd reconsider that issue. With regard to the bottom part of this exhibit, again, plaintiff's exhibit 133, on Tuesday at 1:23 p.m. As an offer of proof, the prosecutors indicated they'd be able to demonstrate that there was an active shooter alert, and that subsequent to that, the defendant is calling his wife, Mrs. Crumbley, from their home, and that while Mrs. Crumbley is on the phone with her husband, she is texting her friend, presumably under the influence of the startling event, that there's an active shooter in the school, that Mr. Crumbley is at the home. She's on the phone with Mr. Crumbley, and contemporaneous with her conversation with Mr. Crumbley, she texts, "The gun is gone, and so are the bullets, and OMG, Andy, he's going to kill himself, and he must be the shooter." So I'll be allowing those text messages in pursuant to 803.2. Right?
Thank you, Judge.
Thank you, Your Honor.
All right. So, are you ready for the jury?
Yes, Judge. talking about when you arrived at Oxford High School on November the 30th and you went to the security office.
Yes, sir.
Okay. And tell us again, what was your primary responsibility at that point in time?
Was to try to secure the video of what had happened in the hallway where the shooting started.
And you said that there were a number of cameras operational at Oxford High School?
Yes, yes there was.
Okay. So, in securing the video, what specifically were you asked to do?
We weren't really asked to do anything. I assumed what the bosses, the sheriff and the undersheriff, all of them would want to know is where it started. We knew it started in the 200 hallway, and we saw as the shooter came out, but we were trying to figure out when he went into the bathroom.
So what did you do to accomplish this goal?
The shooter came out of the bathroom with a black coat on. We kept on rewinding 5 minutes, 10 minutes, 15 minutes, and watched it all the way through, looking for him to go into the bathroom. And we didn't know the shooter's name at the time. Then we could never find somebody going into the bathroom wearing what the shooter had when he came out. And somebody told us what his name was. And so we knew that he was in the counselor's office earlier in the day. So we went all the way back to the time he was coming out of the counselor's office to determine what he was wearing before he went to the bathroom. That's how we were able to figure out when he did go in.
Okay, so you were able to eventually identify the shooter?
Yes.
Now, are you the person who actually synced together the camera footage for other investigators?
Yes, I was.
Okay, and tell me, how is it that you were able to do that?
With over 100, at least 100 cameras in the school, you just take clips of each one, and as they move from one camera, you go to the next camera and save that section, and then there's software that I use to just thread them all together.
And then you testified earlier that you were aware that the shooter was at his counselor's office. Were you also aware that James and Jennifer Crumbley were at Oxford High School that day?
At that time, yes, I was. Yes, I'm sorry.
And eventually, were you requested to obtain as much surveillance video footage from that point in time as you could?
Yes.
Your Honor, I'm going to object to leading.
It's just foundational stuff.
All right, sustain.
Now, in the immediate days after the shooting, what was your primary responsibility with regard to the video?
Different things came up. There was a rumor going around that the shooter had actually tried opening doors, and identifying himself as the police. Well, that was actually the police, but I had to go up there and get more video footage just to determine how far he went completely down the hallway before he turned around, and then what had happened in the surrounding hallways and such like that.
And as the investigator who had to sync together the video, did you have to watch the video of the shooting itself?
Yes, sir.
All told, how many hours of video do you think you've watched to put this together?
Too many.
How many different angles did you have to see this from?
Every angle, every camera. There's some cameras that pointed back in one direction from where it started to, I don't know, 7 different angles maybe at different times.
In part of putting that footage together, were you aiding in the identification of the victims?
Yes.
Tell us what you saw in the video.
Started at 12:51. The shooter came out of the bathroom. I'll never forget it. He came out of that bathroom like what I've referred to before in my life, like a proud chest, like his shoulders were back. And he comes out of the bathroom, and there's Phoebe and her boyfriend just standing right there. And he takes the gun as he comes out of the bathroom, and he turns and levels the gun and fires at Phoebe and hits her in the shoulder and fires at her boyfriend, hitting him in his hand as he raised his hand from seeing the gun, I would imagine. Then to his right, immediately, right there, was Hannah St. Juliana and Kylie and Riley. And he started shooting at them. and they fell on top of each other. And in the distance in the camera, you can see the far end of the angle. You see what I found out to be was Madison Baldwin, and she crouched down, like, I don't know why she did it, but it was in the fetal position, and the shooter ran right up to her, and he put the gun right on her head. She just fell over. He rounds the corner into the longer part of the 200 hallway. Prior to running towards Madison, he had just fired down the hallway, just trying to hit anybody that was running out of there. He rounds the corner and starts shooting. You see a whole bunch of kids, and you see a whole bunch of teachers standing at doors, just grabbing kids as they ran by and just throwing them into a room. And then there's two girls. One, you see, she runs up to a door and tries pulling it open, but the people inside had already put the safety latch at the bottom of the door, and she couldn't get it open. Meanwhile, the shooter's still walking towards, and another girl comes from the right side of the frame and grabs the other one by the arm and just tears off down the hallway. Meanwhile, the shooter is shooting at them. The shooter keeps walking down the hallway past 200, I think it was a 400 T intersection, I think is what that was. And he levels the gun. And he fires 2 rounds, and at first I didn't know what he was shooting at. And when you go to the section of video of that time is when Tate Muir just comes in, and unknowing to him, he had no idea what was happening. And the shooter leveled the gun, and just as Tate turned the corner, the shooter fired a round. And Tate fell instantly. The shooter took a couple steps and then leveled the gun again, and just to shoot Tate again, laying there, shot him. And you see Tate's body flinch. He then walks over Tate. At the top of the frame, you see his feet stop, the shooter's feet, and he turns towards a room that, looking at the frame, would be on the left, or would have been his left. And come to find later on, he had fired into a classroom where a teacher was. He continues on down the hallway, almost hunting for more victims or whatever, and he gets past a certain point, and there's no one else to shoot at because everybody had ran out of the school. Every door, every possibility, every door locked, whatever. And you see him turn around, and he stops at a classroom that, based on where the door is, you can't see deep into the room. It's like the room goes that way, but he can only see straight in. Well, as he's walking back this way, he can see the kids, I'm imagining, hiding in that corner, because he stops and fires off a few rounds through the glass. He then comes back, walking towards where Tate was lying. At this time, an assistant principal was laying there, or standing there next to Tate, and the shooter just walks past her with the gun in his hand, and she said something to him. I'm not sure what she said, but you could tell, like, he turned his head, like, almost didn't even look at her, turned his head like in shame, I don't know. And then he keeps on walking down the hallway to the bathroom where the other victim, Justin Schilling, was. And he just, as he gets to the bathroom, he just stops and turns right and just goes right to the bathroom.
Did the shooter eventually exit the bathroom?
Yes, he did.
Before he did somebody else exit the bathroom?
Yes, another student.
Tell me what you saw there.
That student, he was, I don't know how else to say it, but I've never seen somebody actually run for their life. And that kid was running for his life.
Now, did the shooter eventually exit the bathroom himself?
Yes, he does.
Tell me about that.
He comes out of the bathroom and he looks around a little bit to see what's going on. Turns around and the bathroom, the doors sit back in like a cubby type area, so they're off the hallway. The main hallway you really can't see, but he turns back around. And eventually now the two first responding deputies had gotten to Jason Lewert and Jens were coming down the hallway. And Lewert was a little bit faster than Jens was just because he was trying to come more ground. You can see Tate laying on the ground. And Jens is walking a little bit slower. As he's walking up to him, the shooter just puts his hands up in the air and then goes down to his knees. As he's doing that, Jens realizes he sees something, and he yelled gun, from what he told me. And the shooter then lays down on his stomach, and Jason Lewert come back, and that's where they take him into custody right there.
Based upon your video review, and you said you've had to watch hours of this?
Yes, sir.
Is it fair to say that the entire incident was about 9 minutes long?
Yes, sir. Yeah. He was taken into custody at 1300.
That's
1 o'clock. I'm sorry. Started at 12:51. He was taken into custody at 1 p.m.
Thank you, sir. I'm going to go through some of the evidence that you recovered in your forensic investigation. We talked about different information that you were able to draw upon from James Crumbley's phone, Jennifer Crumbley's phone, and the shooter's phone, as well as their social media accounts and emails.
Yes, that's correct.
So you've seen all of the bits of every exhibit in this case you've seen, is that right?
That's correct.
Okay. And you've seen the demonstrative portions of those exhibits in this PowerPoint before too?
Correct.
Okay. So you're aware, and everyone's aware, we have a citation with the evidence number on that slide, as well as a citation to where from these sources of electronic information was pulled from.
Correct.
Okay.
Yes.
Now, from what you reviewed of the exhibits, do they fairly and accurately depict the information that you extracted from the social media accounts and from devices themselves?
Yes, it does. They do.
So we'll start in late winter or early spring of 2021.
Mr. Keys, can I just ask you, this source of electronic information, which exhibit is this specifically?
This is not an exhibit, this is just a demonstrative aid for,
okay.
for the witness.
Right.
Thank you. So we'll start with March 8th of 2021. Before we get into that, a little bit of background. You were able to obtain a Facebook Messenger chat between James and Jennifer Crumbley?
That's correct.
And tell me how you were able to obtain that.
Like we talked earlier, you can send search warrants off after authorization from a judge to obtain information on someone's social media accounts or phone numbers.
Okay. And did that happen in this case?
Yes, it did.
So I'm going to show you what's been admitted as, this is People's 44. Sir, what are we looking at here?
That's a Facebook chat between James and Jennifer, and the green would be James Crumbley and the blue would be Jennifer's account.
We won't do this with every slide, but just so we are on the same page here. It says from Facebook 691473442 JC Rumbley. What does that mean?
The numbers is the ID account that is signed by Facebook, and then the JC Rumbley is the screen name that was chosen by the user.
Okay. And then we have, in the bottom of the text bubble, we have the date. So this is March 8, 2021. The time, 3:09:50 p.m. And then it says UTC-5. What is that?
It's just to tell you that it's been adjusted So the normal information is captured in UTC time, -0. And all time starts in the point in Greenwich. It used to be called Greenwich Mean Time, GMT. Well, now it's UTC, Universal, like whatever it means. Anyways, all time starts there, and depending on which way you go from that point on the globe is whether it's plus hours or minus hours. And we're 5 hours away from where all time starts.
So let's go through this conversation. Blue from Jennifer, Ethan going to bowling. What's in green is James.
Correct.
What's the response there?
IDK, or I don't know.
Okay. Jennifer, what do you mean? I don't know. And what was James' response?
James says, I don't know, period. Exactly what I said, period. We'll know after he gets home.
Okay. And Jennifer's response, 3:12 p.m. Does he have his phone? Again, 3:12 p.m. Why isn't he home yet? 3:12 p.m. He should be home by now.
Correct.
Okay. And then Jennifer at 3:12 p.m. and 56 seconds says freaking out. What was James' response?
He does not get home till 3:16.
Okay, so March 8, 2021, that was a weekday. From the combination of the digital evidence that you reviewed, location history, are you able to tell where James was when he was sending this message?
Yes.
Where's that?
He was at home.
And Jennifer's response, I told you to pick him up because he's upset and I don't want him to do anything stupid, goddammit.
Correct.
That's March 8th at 3:13 p.m.?
Correct.
Okay, and James's response?
Dude, period, chill, period. He is fine, period. And I'm trying to fucking work. Excuse me.
I'm going to move on to, again, March 8th, 3:13 p.m. What does Jennifer say?
Jennifer replies with, does he have his phone? Question mark, question mark, question mark.
And James's response?
Yes, but he won't answer while he is walking. I will let you know the minute he walks in.
Okay. And Jennifer at 3:14 p.m. says what?
I'm serious freaking out. Then she says, is he home yet? And that was 3 minutes later.
That's March 8th, 2021. It was a Monday. It was 3:17 p.m.
Yes, correct.
Okay. I'm going to move on to Exhibit 61. Again, James and Jennifer Facebook messages. Blue will always be Jennifer, is that right?
Correct, yes.
Okay. March 19th, 9:37 a.m. Tell us what Jennifer writes, please.
Jennifer writes, Ethan awake.
Okay, James' response?
Yeah.
Jennifer?
Replies with, how is he?
And what does James say?
James then says, he woke up looking like he had way, in all caps, too much to drink last night, complaining about a headache.
That's March 19th, 2021, 9:40 a.m. And what does Jennifer write?
She replies with, well, he was really worked up and out of control, so I can see why. She continues on with, all I know is he needs to eat, go to work hard, and not complain, and he can get his stuff back. And that was at 9:41 a.m.
Okay. And 10:15?
Jennifer says, you respond, I didn't get a call. I didn't get it.
Okay. And James's response?
He responds back with, one text says Jesus, another one says yes.
Okay.
He said, let me ask you a question. Why am I in your guy's room? LOL.
And that was at March 19, 21, 10:17 a.m.?
Correct.
And Jennifer's response?
OMG. Oh my God.
What did James write?
James responds, I totally thought you were giving him a Xanax last night.
Jennifer's response?
She responded with, does he seem better? And then a second response, no melatonin.
Okay. And what did James say?
He responds back with, I know.
Jennifer's response at 10:18 a.m., please?
Jennifer said, but he hasn't had one before, should have only given him half.
And what did James say?
He is just doing his school, says his head hurts, he took Tylenol.
Okay. And Jennifer wrote, is he okay to work?
Correct, she did. And then James responds back with, yeah.
Okay. And what did Jennifer write at March 19th, 21, 11:38 a.m.?
Does he remember what he did?
And what did James say?
James responds back with, dude, I am working on a demo right now. I have not talked to him, and he is doing school.
Okay. Jennifer's response?
She responds back with, okay then, geesh.
Now, you've reviewed the entire phone seized from the shooter.
Correct.
Okay. Did one text message conversation stand out to you compared to the rest?
Yes.
Okay, and tell me, why did it stand out?
Just the volume of text messages back and forth, the amount that was in just one chat.
Okay, now without telling us the person with whom the shooter was texting with that volume, can you tell us if you came to learn that the person who was texting was the same age?
Yes,
Okay.
he was.
And he went to school with him?
Correct.
All right. Tell us about the approximate number of text messages between the shooter and his friend.
There was over 20,000 text messages between the two from January to the middle end of October.
Okay. So that sounds like a lot to me, but I'm not an expert in computer forensics. Give us an idea of what that scope is.
20,000. I mean, that printed is over 5,000 pages of text. I've examined phones that someone's entire chat conversation with everybody they have is less than 20,000. So it's just a large volume.
To put it in comparison between, let's say, James and Jennifer's Facebook conversation thread, what's the scope and the difference in size there, if any?
I believe James and Jennifer was 10,000 text messages back and forth for that same time frame.
So same time frame, we have double the amount of text message communication between the shooter and his friend as James and Jennifer.
Correct.
Okay.
You said January to October. Is that both 2021?
Yes, ma'am. I'm sorry.
Thank you, Judge. Yes, 2021?
Yes.
No, there were also, without going into detail, video shared as well?
Yes, there was.
Okay. And were some of the content of the conversation of a highly personal nature?
Yes, it was.
Now, in comparison to any other conversation on the shooter's phone, what's the difference in size between that particular text thread with everybody else's on the shooter's phone?
He had over 20,000 text messages with his one friend, and in comparison, there was between anybody else, there was a combined, I want to say, less than 1,000 between anybody else that he had chatted with.
So combined, less than 1,000.
Yes.
And then that one friend was over 20,000.
Correct.
Okay. Now, I'm going to show you just a very small portion of that, specifically April the 4th and April the 5th of 2021, which would be right about 2 weeks after the messages that we just saw between James and Jennifer Crumbley. This has been admitted as Exhibit 67. Names are redacted, obviously. Green is the shooter?
Correct.
Okay. Tell us what the shooter wrote April 4th, 2021, 11:56 at night.
He types, like I hear people talking to me and see someone in the distance, and then he appears to try to correct the spelling of the word distance.
Okay. And April 4th, 2021, 11:56 and 50 seconds, what does he write?
I actually asked my dad to take me to the doctor yesterday, but he just gave me some pills and told me to suck it up.
And 11:57 p.m., what did he write?
He continues on with, like it's at the point that I'm asking to go to the doctor. And then he says, my mom laughed when I told her.
That was again 11:57 in the evening, April the 4th, 21.
Correct.
April 5th, 2021, this is just after midnight. What does he write?
He tells his friend, but I am having bad insomnia right now, RN, and paranoia.
Okay. And then what does he write?
I need help.
That's at 12:11 a.m.?
Correct.
And then at 12:12 a.m., what does he write?
I was thinking I calling 911 too so I could go to the hospital.
And continuing on, April 5th, 12:12 a.m., what does he write?
But then my parents would be really pissed.
And finally, 12:38 a.m., what does he write?
He says, I'm going to ask my parents to go to the doctor's tomorrow or Tuesday again. Then he continues with, but this time I'm going to tell them about the voices.
And finally, he writes at 12:39, 20 seconds, what?
Like I am mentally and physically dying.
Now, you discovered, we just mentioned, some videos on this text message thread between the shooter and that friend. Is that right?
That's correct.
Okay. So I'm going to now direct you to August the 19th of 2021. First of all, did some of those images that he shared depict firearms?
Yes, they did.
So this is Exhibit 70 and 71. 70 is the text message itself. What are we looking at here?
That's showing a video was sent to his friend.
Okay. So this is the same friend we're referring to at all times?
Correct, yes,
okay.
yes.
August 19th, 2021, 9:31 p.m. And the video is 71. I'm going to play that now. That's August 19th, 2021. Do you know what he was handling in his hand?
That was a handgun.
This is Exhibit 72 and 73. They've both been admitted. This is 8:20 a.m. at 12:30 in the morning, so we're carrying over past midnight from the last video. 72 is this text bubble. So what are we seeing here?
Again, it's a text to his friend that he's been communicating with of another video of the gun.
Okay. And this indicates that video was sent to his friend?
Correct.
I'm going to play 73 now. Now, sir, do we see a round in that chamber?
Yes, there is.
Okay, when I say round in the chamber, what does that mean?
A bullet and a shell.
And that was August the 20th. Now, were you able to tell if the defendant or Jennifer Crumbley were actually inside the home when the video was taken?
Yes.
Okay. I'm going to go through. We talked earlier about how you're able to find certain location history.
Correct.
Okay. So, is it fair to say that you were able to do that for this specific date?
That's correct, yes.
So this is Exhibit 74. Green, and so we're aware, green will always be James Crumbley's location. Purple will be Jennifer Crumbley.
Okay.
What are we looking at here in Exhibit 74?
That's a GPS location that was captured by Google. Is the Gmail account, jamescrumbly8@gmail.com, in the upper right corner, and on August 19th at 9:21 p.m.
Okay, so that's on East Street. Did you come to learn that the Crumbley family lived at 112 East in Oxford?
Yes, I did.
Okay. So that indicates at least that his device is at the location approximately the time the first video on August 19th was taken.
Correct.
Okay. So this is Exhibit 75. This is purple again, so this would be Jennifer Crumbley?
Correct.
Tell us, please, what you see here.
Again, it's using the same Gmail account that they had. Her GPS location from Google was at 9:29 p.m. on August 19th.
Okay. And again, that's the first video that we saw.
Correct.
Okay. This is Exhibit 76, specifically August the 20th, 2021, 12:32 a.m. What do we see here?
Again, another green circle indicating the location of James's device.
Okay. And this is approximately the same time the video of the loaded gun was sent.
Correct.
There's 77. What are we looking at here?
That's the purple, which is Jennifer's, on August 20th, and that's at 12:21 a.m.
Now this is Exhibit 72. This is part of that same conversation between the shooter and his friend?
Yes.
Okay. And this was August 20th, 21 at 12:32 a.m.?
Correct.
Okay, so would that be right after that video was sent?
That's correct.
All right, what does the shooter write?
My dad left it out, so I thought, why not? LOL.
Now, during the course of your investigation, did you come to learn that this friend that the shooter was communicating with abruptly left the state of Michigan?
Yes.
Okay. And did you learn if that was done without notice to the shooter?
Correct, it was not.
Okay, what do you base that belief on?
James had reached out to the father of the shooter's friend, asking if everything was okay, and then the father of the friend told what was going on.
I'm going to show you Exhibit 79. This is a text message from, you recovered off of James Crumbley's phone?
Correct.
Okay, and again, names are redacted here.
Correct.
Did you come to learn that this is the father of the shooter's friend?
Yes.
Okay. And what's the date here?
This is on October 30th, 2021.
Okay, at 9:52 p.m., what did he write?
He wrote, "Hey Mark, sorry for the late text. Hope the family is well. Just wanted to check in and make sure everything is okay with the shooter's friend. Ethan's been trying to get a hold of him for a few days. Did not know if his phone was taken away, maybe, but just checking in. Ethan wanted to be with his friend for Halloween if he is okay."
Now, we have this in the same conversation for context. This is October 30th, 21, 11:01 p.m. This was in response to that text?
Correct.
Okay. And what does he say?
He says, "Hey James, thanks for checking in on him. Unfortunately, his friend is in a bad place with the OCD, unable to go to school most of this week. We are taking him out to Wisconsin tomorrow to put him in residential treatment. He'll be gone for 60 to 90 days. By far the hardest decision we've had to make. So he probably doesn't know how to approach it with Ethan or what to say. I think he is probably embarrassed about the situation and is the reason he is not answering. Let me talk to a friend. I wasn't aware that he wasn't talking to anyone."
Okay. And then there was another text after?
Yes. He responds, "Sorry for the delayed response."
Okay. And 10:30:21 at 11:03 p.m.?
The father of the friend says, "Let me talk to him and see how he wants to approach it with Ethan."
Okay. And then what is James' response?
James responds with, "Mark, please let me know if there's any way at all we can help. He is a great kid and always great over here and very welcome at all times. Please let me know if we can help."
So that's October 30th, 2021, 11:10 p.m.
Correct.
Now, I want to talk to, moving to November of 2021. Did you find any information regarding James Crumbley's employment status?
Yes.
Okay. And tell us specifically regarding November of 21, what did you find?
That he had lost his job on the 1st of the month.
Okay. And did he subsequently find another job?
Yes, he did.
And do you recall when that was?
Shortly thereafter, he started door dashing.
Okay. This is exhibit, I'm sorry, we're still on page exhibit 79. The response to James Crumbley's text was what?
Always, the dad of the friend says, "Thank you, he loves you guys. Hopefully we can get him better, and Ethan can spend some time over here too. He has to voluntarily go, so there's a chance he may not be admitted. If you don't mind for now, if Ethan asks, tell him he had to go out of town unexpectedly. If he gets admitted, then we can give him full disclosure. Is that all right?"
So here's exhibit 81. This is the, you mentioned he was door dashing?
Correct.
Okay. And you executed, well, you were part of the investigators who obtained information from DoorDash via search warrant?
Yes.
Okay. And with DoorDash, if you are a driver for DoorDash, you install an application on your phone?
Correct.
And did James Crumbley have that on his phone?
Yes, he did. Right there.
So what is this in 81?
That's just from one of the things that is pulled out when we extract data, pull data off the phone. It's installed applications, and it just tells us that that app was installed, the Dasher app was installed on his phone on November 9th.
Okay. So that's when he would have put the application on the phone to start receiving orders to be a DoorDash driver?
Correct.
So this is November 9th, 2021 at 8:35 p.m.
Correct.
All right. Now, did you come to learn that he also received messages when he logged in and began picking up orders?
Yes.
Did you find any evidence that suggests that he worked anywhere else but DoorDash in the month of November of 2021?
No, I did not.
And based upon his location history and other information you obtained from his phone, did you come to learn if when he did work beforehand, he was away from the house or in the home?
He was in the home.
Now, what about the shooter's digital footprint in the month of November 2021 after his friend left? When you reviewed the phone, the shooter's phone, for that month in particular, did you find any evidence of the shooter being in contact with anybody else, any other peer?
No, he did not communicate with hardly anybody at all.
Any evidence, either GPS pings, pictures, social media posts, text messages, anything to suggest that he met up with anybody outside of school?
No, if I remember correctly, there was, for the whole month of November, there was only 48 total text messages from the 1st to the 30th.
Okay. And what did those text messages include?
Combined 6 of them were to James and Jennifer, and then the rest were, I remember seeing he was accessing some app, maybe doing homework or something, trying to find, you know, it appeared like you would text it, maybe a math problem or something, it would send you the answer. I'm not entirely certain, but that's what it looked like.
But no evidence of plans to meet with a friend outside of school or,
no.
Or anything
Objection,
like
Your
that?
Honor, asked and answered.
I don't think I asked that one.
Keep going.
Okay. Now, sir, when I talk about cached data, what does that term mean?
Cache data is data that's stored in a temporary file for your device, whether it's a phone or a computer, to pull that information back up again quickly. Whether it's recently viewed or something you look at a lot, the computer can do it quicker because it knows it has to go to this one folder instead of re-downloading it.
Okay, so I understand it. Does that mean if it's, does every phone have a certain area of storage of cached data?
Yes, and every app, just depending on what the app is, it would have its own folder of cache data, yes.
Okay. So if there's something, for example, an image in cache data, what does that indicate to you as a forensic examiner?
It would imply that someone had to, it would have to have been on their phone, they would have to have seen it.
Okay. Now, what does it mean if two people have the same cache data on their phone for an image?
One either would have sent it to the other one or they randomly looked at the same picture.
When examining the phone of the shooter and examining the phone of James Crumbley, did you find any images in common in cache data?
Yes.
Now I want to specifically take you to exhibits 82 and 83. This is the extraction report and a screenshot. So first of all, 82 is the extraction report. This is a snippet of that, please. Tell me what that means.
On 82?
Yes.
Where the file info is and stuff? That shows the name of the image when either you take a screenshot of something, it's going to name it real quickly, or if you receive it, it'll name it real quickly so it can track it within your device. And then where it says path, that's the file path that often tells you what happened, how something got on a computer, on a phone, is by reading the file path.
So let's talk about file path for a second. Now, anytime you, as an expert in computer forensics and cell phone forensics, you're looking to find how a piece of data got on the phone, is that right?
That's correct, yes.
Okay, and so how does the file path aid you in that?
It just tells, that right there, it tells us what they, like this one for example on the screen, it says Android messaging. I know this was done using the Android messaging app.
Okay, so this is from the shooter's phone, and the file path you said had Android messaging?
Correct. At the second line from the top, it says tar archive and then data / and then com Android messaging /.
Okay. Now, if something is found in cache data as opposed to just scrolling through the phone to find the image, what does that mean to you?
That they would have seen it on their phone before.
Okay. But why wouldn't you be able to find it just in messages?
Probably, if it was deleted.
Okay. So this is on the shooter's phone, and we have I guess the forensic footprint of this image.
Correct.
And the image itself in Exhibit 83.
Correct.
Okay, so what is the exhibit itself in 83?
That tells you right there, that's a screenshot, because at the top of it, you can see the top part of your phone. Usually it has a time up there and the battery life and the antenna strength that you have, and you can see it on the top of that image.
Okay. So the screenshot here is 1239.
Correct.
And we have the extraction report on 82 to verify. It's Monday, the 8th of November, 2021, 12:39 p.m. So that matches the screenshot?
Correct, it does.
And because Exhibit 82 has the actual time and date stamp with the UTC -5, that matches the screenshot, what does that mean to you?
That image, that's the image that was sent with that.
Okay. And this was on the shooter's phone?
Correct.
All right, so this is... this also has the file path here at 12:40 p.m. Tell me what we're looking at here.
This one, so this file path is a little different. Again, starting where you see the word path on the screen there, and then going over, second line from under tar archive, it's the tct.cs.rcs, and the RCS tells me that is rich content, and that's Android's way of being able to either share large files, to know. A lot of people have an Apple phone. You can tell when someone's texting you back. That RCS feature allows Android phones to do the same thing.
Okay. So, as a forensic examiner, you can tell us that that screenshot was sent by the defendant's phone based upon, by the shooter's phone based upon the file path?
Absolutely, yes.
Okay. Now here's exhibits 85 and 86. This is from James Crumbley's phone. What are we looking at here?
On the right side is, I'm sorry, the left side, I apologize, is the extraction information that was given, the name that was given in the file path, and then the screenshot again on the right side.
Okay, exhibit 85, the extraction report here. It has the date and time. It's November the 8th, 2021, but this is 12:40 p.m., so that's later in time than what was found on the shooter's phone.
Correct.
Is that right?
Correct, about 1 minute.
But it's the same screenshot?
Correct, it is.
Now, did you find either screenshot of the 9mm, so price $299.99, used Smith & Wesson SD9VE in very good condition, comes with 2 16-round magazines and cleaning kit with an image of a firearm, is that right?
Correct.
Okay, did you find that screenshot in either messaging from James Crumbley or the shooter?
From James Crumbley?
Yes.
No.
Okay. But did you find it anywhere else in the phone other than the cache data?
No, I did not.
Okay. Have you seen reference to SD9VE 9mm elsewhere in this case?
Yes.
Where?
In the shooter's journal.
And again, because it's found in cache data and nowhere else, what does that mean to you?
That it would have had one time been on the phone. As you're opening the text message, your phone's going to say, I got to save that image so I can look at it if they want to open it up. So the fact that it's in the cache data tells me that they had opened it up to see it.
Now, is it possible to recover deleted content from a phone?
Potentially.
Tell me why.
Each Android phones are different, so depending on the manufacturer of the phone, whether you have either a high-end phone or a simple throwaway phone that you buy at Walmart, the Android operating system can be changed to suit the manufacturer's or the reseller's specifications. So if you want to sell a cheaper-end phone that doesn't have all the functionalities of a higher-end phone, usually doesn't have the features to be able to store longer content or retrieve deleted content.
Okay. So it's nothing to do with your forensic tools per se, it's just on the manufacturer?
Correct.
Is it more likely to recover deleted messages after both users delete the message?
No, is it more difficult?
Yeah.
Correct, yes.
Okay. So the fact that this was found in cache data and nowhere else, that's significant to you?
Yes.
Why?
That it was on the phone at one time and now it's not there.
Did all the Crumbleys have Androids?
Yes, they did.
I'm going to direct your attention now to the days before the shooting. We'll start with November the 26th of 2021.
Okay.
Now, sir, given the tools available at your disposal and the information you're able to pull from, I'm going to ask you to build as best you can a digital footprint of the Crumbleys from the 26th to the 30th.
Okay.
Are you familiar with the firearm purchase of the 6-hour 9mm on November the 26th, 2021?
Yes.
Okay. Now, based upon data locations and other information that you were able to retrieve in your investigation, are you able to tell us approximately when that purchase occurred?
Yes.
When?
It was between 1 and 2 p.m.
Okay, well, I'm going to show you Exhibit 87 here. This is data location from 12:08 p.m. on 11/26/21. So what are we looking at right here?
I apologize. It was between 12 and 1 p.m. They were at the gun range there, or the gun store there.
Okay. So this location here verifies that James Crumbley's device was at that firearm store where the 6-hour was purchased that day?
Correct, yes.
Okay. And this is Exhibit 88. This is 12:57 p.m. And you can see East Street as far as where we're oriented towards the map. What are we looking at here?
That shows James Crumbley's location relative to his house at 112 East Street.
Okay. So what can you surmise from these data points?
That this one in particular, the larger the circle is, the more, I don't want to say less accurate, the larger the range where the device could be. This one in particular is 62 meters from that point. So he could be anywhere within 62 meters of that point there near his house.
Okay. So because we have a more narrow point with Exhibit 87, we can be reasonably assured that the device was at the firearm store from 12:08, and then at 12:57 he was getting within 62 meters of his house?
Correct.
Okay. Now, to the extent possible, I'd like us to go through what the Crumbley family did after the purchase of that firearm on November the 26th. Tell us what you saw on their phones, what they did after the gun was purchased.
They went Christmas tree shopping. There are pictures of it.
Sir, when someone takes a picture of something, is there a way to tell where and when that picture was taken?
Usually, yes.
Tell me why.
So a picture that you take with your phone or even a camera that you might have, a Canon camera, captures what's called metadata. You usually tell your phone to do it. And metadata is data within data. So the main information here that you see on the screen is of a map. Well, embedded in that could be how that map was made by the camera that took the picture, maybe the computer that took the picture, how even the screenshot was made. That's information that you don't see. That's the metadata.
So we're looking at exhibits 89 and 90 here. So 89 is the metadata, 90 is the photograph itself. Tell us what we're looking at here.
That's was taken from the shooter's phone, and he's holding the handgun that was purchased on the 26th.
And the handgun on the grip there says 6 hour?
Correct, it is.
Okay. And so when and where was this picture taken?
This was taken at the Crumbley home on November 26th.
And what time?
At 1:03 p.m.
Okay, so we saw from the location history that James Crumbley was almost at his house at 12:57 p.m. And this photograph was taken 6 minutes later?
Correct.
Now, did the shooter post anything on Instagram with regards to this firearm?
He posted pictures of him holding the gun, and then telling people, ask questions, he'll answer.
So here's exhibit 95. What do we see here?
That's the Instagram post where the shooter wrote, "Just got my new beauty today, heart eye emojis, 6 hour 9mm. Ask questions, I will answer."
And when was this post made?
In the bottom left corner, you can see it was November 26th, 2021, and it says 1806, which is 606 UTC, and that's what I was talking about. We're -5 or 4 hours. So in November, we're -5 hours, so it's taken at 3:06.
All right. Here is also exhibit 95. What do we see here?
106. I apologize. It was 106 that was taken.
106.
I -5 from the 18.
Math,
Yes, I apologize. A picture of him holding it in his hand, and that one was taken shortly after at 1:06 p.m. on the 26th.
Same caption of the post, different photograph?
Correct.
All right. And here is, again, same time, same caption?
Yes, just looking down the sights of the gun.
Okay. We see 3 dots at the top of the firearm. What is that?
Those are the sights of the gun. The two on the outside, in the front post. If you don't know, you line those up. It's called your sight picture. You get those 3 dots in a line. If you have equal light on either side, that's where your rounds are going to go. And he's just practicing lining up the sights.
And that's lined up in a way where it would fire the way you would want it to. Would that be right?
It put a round right below it, yeah.
Okay. And same caption, just get my new beauty today, 6 hour 9mm. Media accounts as well.
Yes.
Okay. Here's exhibit 93. What are we looking at?
Another screenshot of an extraction report.
Okay. What does this indicate to you?
It shows that JC Rum following on Instagram.
Okay. Username JEHNC78.
Correct.
And this is exhibit 94. What does this show?
That shows in the contact column JC Crumbley, friend on Facebook.
Okay. So we saw from the location data James arriving home approximately 12:57 p.m., released in the proximity of the home. And then these photographs taken at 1:03 p.m. And then these posts made shortly thereafter. Is that right? Okay, you said they went Christmas tree shopping after that?
Yes.
Okay, were you able to tell from location history when that occurred?
Yeah, on the, I'm sorry, the evening of the 26th.
Okay. Now, did you find any other pictures or videos of the murder weapon after they returned home from Christmas shopping?
There was one more.
And this is Exhibit 96. This is 6:39 p.m. on November the 26th, 2021. This was found on the defendant's phone, is that right?
Yes.
Okay. I'm sorry, the defendant's son's phone, thank you.
This is on the
The shooter's phone. Based upon your investigation, that was the 6-hour 9mm?
Yes, it was.
Did you also find a picture on Jennifer's phone of the 9mm and another firearm owned by James Crumbley?
Yes.
This is Exhibit 97. What are we looking at here?
That's the 6-hour at the bottom part of the screen, and on top is the Caltech firearm, and then the magazines and a gun lock.
So, are you aware of what was provided to James Crumbley when he purchased the weapon on November the 26th?
A gun lock was provided in the magazines for the gun.
As well as that ATF pamphlet underneath it?
Correct.
Now, the video that we saw, that was taken at 6:39 p.m., that's the video on the shooter's phone.
Correct.
Okay. Now, I'm going to show you Exhibit 98 here. This is at 6:27 p.m., November the 26th. James Crumbley location. Are you able to tell where he was at that time?
He was, the device shows near his house, at his house.
I think that move on to the next day, November the 27th, 2021. Could you get an idea of what the defendant, his wife, and their son were doing that day?
Yes.
Okay. Now, what of significance to you?
Jennifer and the shooter went to the gun range that day.
All right. And were there any social media posts made after the trip to the gun range?
Yes.
Is that both by the shooter as well as Jennifer Crumbley?
Yes, it was.
Objection, Your Honor, leading.
Foundation, I'll look. We'll go one by one. Here is, first of all, for a timeline, Exhibit 99, what are we looking at here?
That the purple is Jennifer and at the house at 1:58 p.m. on the 27th.
And here is Exhibit 100. What do we see here?
That's the target that was used at the shooting range, posted by the shooter. Took my new SIG out to the range today. Definitely need to get used to the new sights. LOL.
And date and time when this was posted?
That was at 19:02 or 2:02 p.m.
Okay. And that's November 27th, 21, correct?
Correct.
Now, this is Exhibit 101. This is Jennifer Crumbley's Instagram post. What do we see here?
She posted the target that she had shot and posted with it, Mom and Sunday testing out his new Xmas present. My first time shooting a 9mm, I hit the bullseye.
So that is how close in time in relation to what her son posted?
Within 1 minute.
Now this is another photograph here, same post?
Yes.
Same time?
Yes, it is.
And finally, what do we see here?
That's the 6-hour handgun right there with the magazines and the pamphlet.
So because all three indicate Mom and Sunday testing out his new Xmas present, my first time shooting a 9mm, I hit the bullseye. Does that indicate those three pictures were posted together?
Yes, they were.
So here's Exhibit 102 here. This is 2:03 p.m. What do we see here?
This is Jennifer at her house at 9:27 at 2:03
So that's probably
p.m.
the same time. So that's probably the same time. Those photographs, those posts were those images were posted.
Correct.
So the fact that they were posted on her device or her social media accounts through her device, and we have a device location here. What does that mean to you?
That she was at her house when she made that post.
Okay. And were you able to tell if James Crumbley saw these images?
Yes.
Here's Exhibit 103. What are we looking at here?
This is data information from the cell phone extraction. And again, back to the file path that I talked about, you can see the third line down in the second column. You see com.facebook.katana/cache, indicating that it's in the cache folder.
Okay. So like the screenshot of a Smith & Wesson 9mm sent by his son to him, these images were also found in the cache folder?
Correct.
Now, were you able to obtain data locations from James Crumbley's Gmail account for November the 27th, 2021?
Yes.
Okay, did that help you identify where he was that day?
Yes.
Okay. So I'll go through exhibits 104 through 107. Here's 104. What do we see here?
It shows James' location. It's near the gas station of the Meyer at Ray Road in 24.
Okay, and we already talked about at this point in time he was working for DoorDash.
Correct.
And we already identified the fact that when there was an order ready, he would receive a text message from the DoorDash app?
Correct.
Okay, so were you able to tell what he was doing that day?
Yes.
What was he doing?
He was DoorDashing, delivering.
So 9:37 a.m. indicates one position where he's at, and looks like he's back home at 5:32 p.m.
Correct.
And here's exhibit 106. It's about 6:03 p.m. He's out of the house then?
Correct.
Okay. And 6:33 back home.
Correct.
Now, what about Jennifer's locations from that day? Were you able to obtain any idea where she was that day?
Yes.
Okay. This is exhibit 108. What do we see here?
It's the purple dots indicating Jennifer's locations.
Okay. So we have 2:29 p.m. to 3:32 p.m. in locations outside of the home that would indicate what to you?
She was not home. She was out and about.
Okay, just to make sure I'm clear, on the 27th, we see James Crumbley leaving home about 9:37 a.m., returning at 5:32 p.m., leaving again at 6:03 p.m., home again at 6:33 p.m.
Correct.
And the same day, Jennifer's gone from about 2:30 p.m. to 3:30 p.m.
Correct.
Now Sunday, November the 28th. This is exhibit 109. Tell us what we're looking at here.
That is GPS location for Jennifer on November 28th at 12 p.m.
So she's obviously away from her home. Do you know what's at this location?
Yeah, that's where the horse farm is.
Okay. Now, you say horse farm. You went through all of the digital evidence in this case.
Correct.
Okay, including the Facebook messages between James and Jennifer?
Correct.
And messages from James to anyone else or Jennifer to anybody else?
Correct.
Okay. Are you aware of James and Jennifer spending time at the horse farm?
Yes, sir.
Okay, and tell me how you're aware of that.
Your Honor, I'm going to object to relevance.
We addressed this, Judge. You addressed it in your earlier opinion as well.
I think you did. I'm going to allow it. I think your objection was to weight, not admissibility.
Thank you, Judge. How are you able to know that, Judge?
By how many times they talked about whether I'm going to the barn to do this or work on this horse or take care of that horse, yes.
Okay. Give us an idea of how many times they were talking about it.
They talked, it was mentioned within their chats 86 times of going to the barn.
Oh, I'm sorry, what period of time?
That was from January to November.
From that conversation, were you able to tell if they would go together or if they had a plan together?
Both. They would go take care, one would go take care of a horse, or they'd meet up there together.
Here is Exhibit 110. This is Sunday the 28th at 2:07 p.m. This is at the Crumbley family home?
Correct.
Okay. So these last two pieces of the exhibit indicate that Jennifer Crumbley was at the horse barn from approximately noon to whenever she left, arriving home at 2:07.
Correct.
Okay. And that's the Sunday after that firearm, the 9mm, is purchased.
Correct.
Now let's talk about James' data location points. Here's Exhibit 111. What do we have here?
It shows his location at the Meyer gas station again.
Okay, and tell us what he was doing that day from your review of the digital evidence.
That day he was DoorDashing again.
So this is a data point at 8:56 a.m. Exhibit 112 is 12:45 p.m. Here's he's back at the house.
Correct.
Does he leave again?
Yes, he does.
Okay, here's 113. Exhibit 113 at 12:52 p.m. What do we see here?
It shows him going away from the house.
Okay. And exhibit 114, what do we have here?
At 5:13 p.m. he's back at the house.
Okay. So all this tells you that James left at 8:56 a.m., returned at 12:45 p.m. He left again 7 minutes later and returned 5:33 p.m.
That's correct.
Okay. Now I want to move on to Monday, the next day, Monday, November the 29th. I want to talk about a Facebook conversation between James and Jennifer Crumbley from that day. So this is Exhibit 115. Jennifer Crumbley at 8:23 a.m. on Monday, November the 29th. Are you at the barn? And then follow up with just a question mark at 9:02 a.m. Is that right?
Correct.
Okay. So again, blue is Jennifer, green would be James.
James. Yes, sir.
Okay. When you mentioned like those 86 times you talked about the barn, is this what you were referring to?
Yes, it was.
Or at least a portion of what you were referring to?
Correct.
James' response was what at 9:05 a.m.?
Working on Billy.
Okay. And did you come? Who's Billy? Did you,
it was one of the horses.
all right. This is also part of 115. What did James send to Jennifer?
He sent a photo. It's the horse's legs.
Okay. And Jennifer's response?
Do the fronts too.
So that's 9:21 a.m. on Monday, November the 29th. What did Jennifer write to James after that?
She asked him, did you call the vet yet? And then tells him, make sure you get back in between his heel bulbs.
And James's response was, I did, at 9:34, then fronts too, right after?
Correct.
And James wrote what at 9:35?
He says, what exactly should I tell the vet? Type out for me, leaving the barn now.
Okay. And Jennifer's response was what?
Billy looks to have scratches / mud fever. He's starting to stock up on all fours and concerned about infection. He's not lame, sensitive to the touch, and they go down when he moves. Is there an antibiotic I can get him on? We just put Desitin, an antibacterial, on his legs today.
Okay. And then she wrote what?
She asked, was he stocked up this morning?
Okay, so that was 9:41 a.m.
Correct.
And James's response at 9:43?
He responds back with, he was stocked up more in the back than in the front. In fact, the front didn't really look stocked up at all, so I launched them for a few minutes before. I put the stuff on it, and it took the swelling down a little bit, but I got that cream all over, you know, in between his heel bulbs and stuff like that. I'll call the vet here in a minute.
Okay, and then you wrote, talk to text FYI, so I have no idea what it really just said.
Yes.
Jennifer, it made sense, LOL, at 9:58, and then James's response at 9:59?
James responds with, I just talked to the vet, Carrie. Said she's going to talk to the vet once one of them get back in, and she will give me a call back. I explained everything exactly how you wrote it down. Good thing you wrote it down like that, LOL, for me.
Okay, and her response was, okay, good, LOL?
Correct.
Okay, so this conversation regarding the barn and the vet started at 8:23 a.m. and it went until 10:15 a.m.
Correct.
Okay. Did you come to learn if a message was left for Jennifer Crumbley while this conversation was going on between James and Jennifer?
Yes, there was.
Okay. This is Exhibit 116. Ms. Williams, do we have the volume?
Hi, Ms. Crumbley. My name is Pam Fine. I'm calling from Oxford High School, and I'm here with Mr. Hopkins, who's Ethan's counselor. I was just calling to let you know that we just spoke with Ethan, had a really nice conversation. One of his teachers had sent an email to the office just that she was concerned because Ethan, when she was walking around the room checking assignments, that he was on his phone looking at bullets and that sort of thing. So she just wanted us to have a conversation. We did. He said he had been to the shooting range with you this weekend, and we were like, yep, guns are a hobby for a lot of people, and shooting ranges, and that's perfectly normal. And that we just wanted to make sure I had a conversation with him about the things he searches at school, and things versus searching at home, like Mr. Hopkins gave a good example of like if a teacher makes fear at home, perfectly normal and healthy, but can't be using searches for making beer at school. So we had a conversation. He was great. He was like, yep, I get it. So I just wanted to let you know that we did have that conversation with him, and I don't know, about 5 minutes, and he went back to class. All right, if you have any questions, you can give me a call. Otherwise, it'll be a great holiday. Thanks. Bye-bye.
Okay, so that was November the 29th, 2021. Did you find evidence that Jennifer Crumbley accessed that voicemail?
Yes, she did.
Is that depicted here in People's Exhibit 117?
Yes.
Could you find from the messages between James and Jennifer who picked their son up from school that day?
Ethan did. I apologize. James did, the father.
Here's Exhibit 120. This is Jennifer Crumbley, you still working, 2:44 p.m. James says no, waiting for their son, 2:47.
Correct.
Okay. And 119, this is later on. What does Jennifer write to James?
She asked you, did Ethan tell you what happened today?
Okay. And that's the same afternoon that the voicemail was left?
Correct.
Okay. And James's response?
Was yeah.
Now we're going to move on to November the 30th. And we'll go step by step from what you were able to discern from all of the evidence that you had to review at your disposal. So in the morning, November 30th, were you able to tell what time the shooter was dropped off at school?
After 7:30 p.m. or a.m.
So were you able to pull surveillance video for that?
Yes.
This is Exhibit 122. 7:46 a.m. on the 30th?
Correct.
Tell us when you recognize him, please.
He got out of the car a second ago. He's the last one walking up.
Right there?
Yes.
And he was dropped off by his father?
Correct.
Exhibit 123, tell us where James Crumbley went after that.
At 8:04 a.m. he was at home.
Okay. And then Exhibit 124, where was he?
At the horse farm again.
Okay, so 9:04 a.m. So 7:46 a.m. he dropped off his son. He was home at 8:04 a.m. He's at the horse barn by 9:04?
Correct.
Okay. Do you know what time that Jennifer Crumbley got to work?
About the same time, 9:04.
So this is what we're looking at here.
That's Jennifer walking into her place of employment.
This is Exhibit 125?
Yes.
Okay. And this is November 30, 2021 at 9:04 a.m.?
Correct.
Now, do you know if she received a phone call shortly after arriving?
Yes, she did.
So Exhibit 126, what do we have here?
That's from the call log obtained from her phone from the school.
Okay, so we have a missed call at 9:24 a.m. on November the 30th,
Correct.
and then we have a return call at what time?
9:27 a.m.
And how long is that phone call?
That's 5 minutes, almost 6 minutes.
So is that 5:43? That's 5 minutes and 43 seconds?
Yes, it is.
Now, next in the timeline, 9:31 a.m. What are we looking at here?
That's the screenshot or a picture of a math sheet homework that the shooter had.
Okay. So this was sent to whom?
To Jennifer.
To Jennifer Crumbley?
Yes.
Okay. Exhibit 128, what's this?
That's the full-size image of it, of the math sheet.
So did you come to learn there were actually two different math worksheets?
Yes.
Okay. And this would be referred to as the altered one?
Correct, it is.
So this was sent to Jennifer Crumbley at 9:31?
Correct.
Right, that's Exhibit 128. Exhibit 129 is what?
That appears to be an email of the math worksheet.
Here's Exhibit 30. This is what contained in the email?
Yes, that's the original.
So this was emailed to Jennifer Crumbley at 9:32 a.m. Is that right?
Correct.
And the scratched out version was texted to her at 9:31 a.m.
Correct.
Okay. Now this is Exhibit 131. This is at 9:33 a.m., so this is 1 minute after that original drawing was sent to Jennifer Crumbley. What are we looking at?
Jennifer telling James, call now, emergency.
Okay.
And then she says again, emergency, 2 minutes later.
And then at 9:38 a.m., what does she send?
She sends the picture, the two pictures of the math worksheet.
Okay. So the one that's scratched out in the original, the
Correct.
ones that were sent to Jennifer?
Yes.
Okay. And James's response at 9:44 a.m.
James responds with, my God, WTF.
And then what?
Vet not here yet. It's McElmurray for Kira's horse, still waiting on vet.
Okay. So we saw earlier that his location indicated he was at the barn by at least 9:04 a.m.?
Correct.
Okay. And this was at 9:45 a.m.?
Correct.
And what did Jennifer write?
Responds back with, he said he was distraught about last night.
James?
James says, we talked about it this morning. Then he asked, you talked to him, question mark.
And what did Jennifer respond?
Responds with, can you call?
That's 9:57 a.m.?
Correct.
Okay. And what does Jennifer write at 10:04 a.m.?
She says, heading to a school, I'm very concerned.
And that's at 10:04 a.m. on November the 30th, 2021.
Correct.
Did you learn that they both arrived at Oxford High School?
Yes, they did.
And did you learn approximately the time they arrived there?
Yes.
What time is that?
It's about 10:30, 10:36.
This is Exhibit 132. 9:36 a.m. We see James' location history that's still at the barn.
Correct.
Okay. And 1:34. This is the same surveillance footage that we saw Jennifer Crumbley arriving at work at 9:04 a.m. This is at 10:06 a.m.
Correct.
Okay. And this is consistent with what we just saw in his Facebook messages when she wrote heading to school.
Correct.
Okay. This is Exhibit 126. What do we see here?
It's a call to the school, to the counselor from Jennifer.
Okay, so she left at 10:04, then at 10:07, she called the same counselor who called her.
Correct.
And Exhibit 131, headed to a school at 10:12. So that
Correct.
would be the timeline for that period of the day.
Correct.
So do we have an idea of, you said about after 10:30 a.m. that meeting occurred?
Correct.
Okay, and so is this what you base that opinion on?
Correct, yes.
All right, so what do we see here at Exhibit 135?
Well, you see at the top of it is the horse barn, and then he takes a path down Gardner Road and then heads to the high school.
Okay. So if I'm correct, what we just saw, Jennifer arrived at work. Well, first of all, the shooter was dropped off at school at 7:46 a.m. by his father.
Correct.
He went to the horse barn at 9:04.
Correct.
Jennifer arrived at her place of employment about the same time, 9:04.
Yes, sir.
Okay. And she received the phone call at 9:24.
Correct.
Then we saw the messages sent from her counselor, and the phone call from her counselor, and the messages thereafter with those two drawings.
Yes, sir.
And then the Facebook messages directly after to James with those two drawings.
Correct.
Okay. And this shows when he left the horse barn and about the time he arrived at Oxford High School.
Correct.
Now, did he stop by his house before he went to the meeting?
No.
Jennifer stopped by the house before she went to the meeting.
No, sir.
Did they go in one car or separate cars?
They were in separate cars.
Okay. Now, we had discussed this particular aspect of the case in a separate hearing some time ago, and there was an original belief that they arrived in one car.
Correct.
Okay, you came to learn that they arrived in two different cars.
That's correct.
Again, it's just foundation, sir. Tell me what happened.
When I originally was watching the video, the system that the school has, it's not continually recording. It only records when there's enough movement in the frame. So if they're too far of a distance away, it's not going to record, even though there might be somebody walking across the parking lot. The sensors don't pick it up. And it didn't, once I saw the second car, what I thought was the first car, pull into a parking spot, the next thing I saw was just two people standing in front of it. So I assumed that they'd come out of that car together.
keeping with our timeline here, 10:29 a.m. We have a call log of, what do we see here?
James calling Jennifer.
Okay, and how long was that phone call?
7 minutes and 16 seconds.
And based upon what you found on the video and the messages and data locations, this is before they arrived at school?
Yes.
Okay. Now, you were able to pull the surveillance footage of both vehicles arriving and their movements while inside the Oxford High School, at least that were contained on surveillance video, is that right?
Correct.
Okay, so this is Exhibit 137. I'm going to play this. And just so we know, at the bottom of the screen here, we have a description of the camera, what it's looking at with the time.
Correct.
So this is 10:36 a.m. on November the 30th, 2021.
Correct.
Okay. And this, what are we looking at right here?
That's the parking lot of the school on the north side of the school.
Sir, whatever you're able to, give us some context of what we're looking at.
I come to find out that that's Jennifer pulling up right there in that car.
Okay.
And then there's James and Jennifer walking up to the school.
Right here?
Yes.
Sir, this is James and Jennifer Crumbley in the Oxford High School that day?
Yes,
Okay.
that's in the office there, and they're being directed around to counseling.
At the bottom of the screen there, it's 10:39 a.m.?
Correct.
So it just might actually be a good time for a short break if the court is inclined to take one.
You want to break this thing up?
That's fine, Your Honor.
All right, so I'm going to let you sit down, but you can't discuss your testimony with anybody, all right? So just about a 10-minute break, okay?
All rise for the jury.
I'm going to catch that because I'm that crazy hot. He leaves. All right, so by about 3 o'clock, we're going to go home.
Thank you, Judge.
Thank you, Your Honor.
All right, court is going to break now, still on that second witness of day one of the James Crumbley trial. So let's break down a bit of the this evidence we've been going through. It really feels as you watch through it, Rick, that they're really being nitpicky and showing every little detail. What's the purpose of this?
To admit the evidence, the individual pieces of evidence through the expert who's going to authenticate the evidence under the rules of evidence, the Michigan rules of evidence. That has to be done. It seems like it's kind of boring and perfunctory, but it's essential in order to get the evidence admitted into the trial. One of the things about this witness that I was really interested in seeing is if he was going to testify in the same manner that he did in the first trial. You recall that when he first sat on the witness stand, he was qualified as an expert in data extraction, cell phone extraction of information, and the Facebook information, the data, the metadata, and the path files. So all of that is fair game under Rule 702 of the Michigan Rules of Evidence for an expert to testify to. But then he switched into this fact witness, which is improper testimony, which was not objected to in the first case, and again was not objected to in this trial. We talked about a motion in limine that would have been proper to be filed to exclude all that, because it was the information that he's testifying to now and the evidence that he's admitting through his expert testimony is, like you said, dry and perfunctory, and it's, you know, it's this text message, it's this metadata, it's this path file, pretty straightforward. But what he did with when he testified about downloading the files in the school was he provided commentary, which was devastating, and it was personal. He wasn't even there. He's providing testimony that you or I could provide, looking at a video file and giving his own personal take on it. He said things like, I'm imagining that the shooter looked into a classroom because he saw kids hiding there. That was his testimony. I'm imagining that that's what he did. He said that that he was hunting for other victims. He said it was devastating to see, to watch. He watched this film many more times than he cared to have seen, and he was very emotional about it. So he was testifying about, and then he testified about what other officers told him, which was rank hearsay, none of which was objected to. We heard some objections, objection leading, which is, you know, at this point, the evidence that came in that probably shouldn't be allowed in, came rolling in without objection. But the petty objections, I think, to leading and to speculation at one point were feckless and essentially ineffective. But this major piece of commentary evidence about how this officer, or this special agent, viewed the testimony was devastating.
Yeah, not really working in his favor at all. Moving forward, what do you think is going to take as far as the defense to try to one up what we just heard?
Well, they're going to have their work cut out for them. Here's why. At the beginning, before the jury was brought in, you may remember there was some question about whether or not Mr. Crumbley's statement, "Oh my God, he must be the shooter," whether that was coming in. And you heard the judge make a ruling that it was. So she ruled under 803.2. That's an exception to our hearsay rules and the rules of evidence, which means that can come in because he was excited. It's called an excited utterance. And so when that comes in, that's going to add more credibility. That's going to make it a lot more tough for the defense. I think what the defense has to do here at this particular point is make some objections. I mean, in theory, this should have been taken care of before trial, but she didn't say anything when this officer's testifying to things like Jennifer Crumbley's whereabouts. What does that have to do with this case? I'm sitting here saying to myself, say something. That is not relevant. They're backdooring a lot of editorial evidence, as Rick has pointed out, that's damning. So the defense is kind of getting behind here a bit, and they better try to step it up with some objections, filing motions, or whatever they have to do at this particular juncture, because it's coming under 803.2 that, oh my God, he must be the shooter. And it's nothing she can do to stop that.
Yeah, explain, if you would, why that's an exception, why that's inherently credible. An excited utterance, you know, that's an interesting exception to the hearsay rule.
It's an exception because in theory, when you are under pressure, you're going to say things that presumably are truthful. You're going to say things that are credible when you're under pressure. And so that's what that rule kind of carves out an exception. Normally, if you say something to the effect, oh, he said X, Y, and Z, that's hearsay. But if you're in a situation where someone has a gun to you and you say, oh my God, John had the gun to me, well, that's an exception to the hearsay rule because you're under pressure and it's presumed that you're telling the truth and it's presumed that you're credible. So under that exception, and you heard the judge rule, that evidence is coming in and it's nothing that the defense can do about it. I hope that she's prepared some kind of strategy for that.
All right, well, thank you both so much. We are going to a short break. We'll be back soon.
The jury in the trial for the father of the Oxford High School shooter is underway. First round of witnesses began testifying. CBS News Detroit's Andres Gutierrez is at the Oakland County Courthouse with a recap.
So going into this trial, we were anticipating a number of similarities to his wife's trial, so it's no surprise that the first witness the prosecution called was the exact same one from Jennifer Crumbley's case, and that is Molly Darnell, the teacher who was wounded on that fateful day. By calling her, the prosecution essentially taking the jury back to that fateful day and laying out a timeline. The morning began with the jury getting sworn in, being given instructions, including an explanation of the different theories of gross negligence that the prosecution must prove if they want a conviction in this case, and that is James Crumbley should have known his son was in the throes of mental health, but despite that went out on Black Friday and bought him a 9mm handgun that his son used to kill 4 of his classmates. During his opening statement, Oakland County Assistant Prosecutor Mark Keith said James Crumbley had several opportunities to prevent the mass killing, including 3.5 hours before the shooting when he and his wife were called to the school but failed to inform administrators about the fact that he had bought him a gun days before and failed to act because they didn't take him home to get help. But Crumbley's defense attorney in her opening statement told the jury that her client didn't take any action because he was unaware of any imminent danger and he didn't do anything differently. Here's a snippet of those statements.
And you will learn throughout this trial that he was the adult out of anyone in the world in the best position to prevent these kids' deaths. You're going to learn that those kids would still be alive today had James Crumbley seized any one of the tragically small and easy opportunities given to him to prevent his son from committing murder. Any one of them. These were opportunities that were literally given to him, yet he disregarded.
Ladies and gentlemen, James Crumbley did not know what his son was going to do. He did not know that his son could potentially harm other people. He did not know what his son was planning. He did not purchase that gun with the knowledge that his son may use it against other people. You will not hear that he did that. The prosecution told you that.
And during those opening statements, the prosecution said they may call between 15 to 20 witnesses in this trial. Reporting in Pontiac, Andres Gutierrez, CBS News, Detroit.
And lawyers Richard Convertino and Arnold Reed join us for our Gavel to Gavel coverage for analysis of what is happening in this trial. Thank you so much again for being here throughout this day. So we've seen these same 2 witnesses from the Miller hearing, the shooter's Miller hearing, and from Jennifer's trial. So is the prosecution just kind of holding steady at this point, taking the same approach they always have?
Somewhat, yes. They are taking the same approaches, but at the same time, we're seeing a couple different twists. And as I've indicated previously, the prosecution put on a good case that first time. Nothing is broke, so why fix it? They're coming out with their central theme about recklessness, negligence. They're letting witnesses talk about how the parents, or at least portraying them as neglectful, portraying them as parents who've checked out, were inattentive. And so I think what they're doing here is similar to what they did the first time, but just a little bit different. I think we have the defense that's coming out that is markedly better at this point. She's got an uphill battle, but she's markedly better. One of the things that I'm impressed with is she's not asking questions to witnesses when she knows she shouldn't. She sits down and she's quiet when she should be, and when it's time for her to take her stance or to try to get, one up, so to speak, she does. So I think that's very important at this juncture, and I expect down the road as this trial progresses, she will have opportunities to show us what evidence she thinks does not support the prosecution's case.
We haven't heard a whole lot from her yet, but what we have heard is a lot of he didn't know. He didn't know. Do you think that's going to be a strong argument, Rick?
I think it's the strongest argument. I don't think it's particularly going to be effective if that's all it is he didn't know. He had his head in the sand or had no reason to believe that there were any issues here. I think the evidence so far even is pretty consistent that if he didn't know, he certainly should have been aware. There's some interesting evidence that was admitted regarding some of the text messages in the path file. In the path file that of the metadata that was admitted in the Facebook and the text messages, the images in particular, the prosecution admitted those path files, and the witness said that they were deleted. and that would have been the evidence of the image of the gun itself and the image of the shooter holding the gun. All of those were deleted from James Crumwell's phone, which is consciousness of guilt. Why delete those if there's no issue with them, if they're just photos? So, hundreds of other photos were not deleted on his phone, photos of the horses, etc., but these in particular were deleted, and that evidence came out through this special agent.
Were they deleted following the shooting?
He couldn't tell when they were deleted.
Okay.
Yeah, couldn't tell.
Interesting.
Couldn't say exactly when they were deleted, just that they were.
And another piece of evidence that we were talking about on the break, which is the first time we're seeing this, is a conversation between James and the father of this friend, this lone friend that the shooter had, who disappeared from his life a month before the shooting.
Yes.
So why do you think this is interesting, and why they're looking at this?
We were talking about that at the break, the four of us, and my estimation is that it was purposefully admitted by the prosecution in order to show that here is a parent who recognized a mental health issue and immediately took action on it. Now that's someone that had communicated with the shooter 20,000 times in text messages, and 10,000 within the last month before he was moved to a facility for his OCD, the friend of the shooter. And so I'm thinking that that was purposefully admitted to show the discrepancy between this is what a reasonable parent would do, someone who has a duty and obligation to care for their child under Michigan law, and this is what James Crumbley did, knowing that his son was in constant communication with this person who had a troubled past. So Arnold has a good twist on how that might be used.
On the other hand, I mean, the messages also show Mr. Crumbley offering an olive branch or extending, you know, do you need help? You know, if you need anything, let us know. We're here to help you. I think that can kind of cut against the prosecution because it shows a parent who's concerned. It shows a man who has empathy, right? And so that would bolster the defense's argument that, hey, you know, he just was not aware of what was going on, but my client is good-hearted, he's good-natured, he tried to help his son's best friend, right? So I think it can kind of cut both ways. It just depends on how the prosecution massages it in front of the jury and how the defense responds to it.
Yeah, you just want to, and I would just juxtapose that to rebut that with the texts between the shooter and James, where James tells his son, you know, suck it up. Or they're talking to James and Jennifer are talking about they're aware of a problem, well, give him a Valium, and that's how they decided to handle it.
I wanted to ask you something, Rick, and this kind of goes back to the beginning of the trial, right? Obviously, this is a high publicity case. I mean, everybody, unless you've been living under a rock, right, you know about this case. Why do you suppose that the defense didn't write a motion to seal the verdict being read in the first case until this case, right? And I say that because years ago we had a seriously high-profile case. It involved the shooting at the Rib Rack in Southfield. And so we filed a motion to seal the verdict. It was 3 defendants. We all had separate trials. We wrote a motion to seal the verdict in the defendant's case until our defendant had his verdict read. And I think it really helped us in terms of when you get in front of that jury, at least here, they know that the first trial, you know, wound up in a conviction. And I think that that was very helpful to us, sealing that verdict so that we could ensure a fair trial for our client. What do you think about that?
Well, that's fascinating. I've been practicing law, almost exclusively criminal law, since 1989. And I have never heard of a jury verdict being sealed until a future defendant had his or her verdict announced. So I had never heard of that. What in the case that you did that in, were the trials separated by a period of time, or were they concurrent? Were the trials going on at the same time in different?
They were almost contemporaneous, maybe a week or 2 behind, so it wasn't a long period of time. But we felt that if our client was found guilty, that there was no way that a jury would not see that and take that into account in their deliberations. And so we were strategizing, sitting around, and you know, I said, let's float a motion out there. We float a motion out there, and the verdict was sealed.
Yeah, that's creative. I've never heard of that. And you know, in contravention to that, in this case, the prosecution in its opening statement said that the mother was convicted.
Yeah.
You know, that case was handled. The son's case was handled. And that, you know, as we talked about earlier, I mentioned that I thought that that was extremely prejudicial because in this case, you have a jury that now knows that 2 of the 3, and the 3rd is being tried before us, have been convicted, including the mother, who's being tried on the same nucleus of operative facts as the father in this case.
Right.
And therefore, you know, maybe predetermined toward conviction. But I had never heard of that type of motion before. I didn't think it would. If you asked me about it, I would say that's not a viable motion. But in your case, it was successfully filed and argued. So
yeah, especially in a case like this. But I mean, you have to consider too, it puts an enormous amount of pressure on a judge, especially in a high-profile case like this. You have these families wanting answers, right? And so that's a tough thing when you want a family having answers, right? And you got another trial going on. And so it takes a very, very strong personality in terms of a judge to say, well, wait a minute, what if the defendant is found, you know, not guilty? That could impact your trial. So it's a strategy that we use. But
were you in that case, were both trials going on at the same time, one lagged behind the other, or they were both jurors were sworn?
This was all 15 years ago. I believe we had finished, we had finished ours first, and they were kind of contemporaneous with one another, where the other one had started too. So we had 2 of them going at the same time.
I see.
And so we didn't want the first one to come back and impact us.
I see.
So that's why we did it.
I would expect, if I were a judge, I would say, well, the jurors are sworn, double jeopardy attaches, and I'm not going to seal a verdict because the jurors are charged with not communicating with each other, not researching whether or not there had already been a previous verdict. I think in this case, because you had a month or so between the verdict and the charging of the jury, in this case, the swearing of oath, I think a motion would be typically denied. But have you ever heard I mean, I'm really interested in that strategy. Have you ever heard prior to filing your motion, a successful motion like yours being filed in another case?
Never. I'd never heard of it. We have gotten many other motions to seal granted, of course, in other contexts when minors are involved, things of that nature.
Yeah.
But we just thought that in this particular case that it was vitally important that our client have, you know, their constitutional rights protected. And part of that protection definitely was if a verdict comes out in this other case, then that's going to spill over into our case. You got the Oakland County Courthouse, same courthouse.
Oh.
The defendants are being tried 1 or 2 floors above each other.
I see.
So it just, you know, jurors are intermixing. And so it had all the elements we felt that, you know, the judge should have allowed us to do that, and it happened.
But didn't the judge say, well, the jurors are sworn not to communicate, not to research, not to have these extrajudicial conversations regarding
No,
the case?
that really didn't come up. I mean, I think the judge keenly understood people are human. And we all know when you tell jurors that, you know, they're going to go home and talk about it. They're going to read about things in the newspaper. And they're not going to listen to the degree that they should. And so I think that was kind of unspoken. He knew that and wanted a fair trial. But in a case like this, it's really tough when you're talking about doing something like that, when the public, they want answers. I mean, there's just sentiments running high here. But if I was the defense lawyer in this case, I probably would have tried it anyway.
Yeah, it's interesting, creative.
Yeah.
You know, kudos to you.
Sometimes it works, man. Sometimes when your back is against the wall.
Did it work 15 years ago?
It worked.
It works.
Yeah, but sometimes when your back is against the wall, listen, you know that a change of venue is not going to happen, right?
Yep.
I mean, you got a better chance of getting struck by lightning 3 times than winning the Powerball. But there are other ways that you have to think about when you're representing somebody in a criminal case to ensure the fairness of our system. Because those jurors are going to be talking, they're going to be reading the newspaper, as we said, and there's nothing you're going to be able to do about that, right? And so you have to strategize and think about other ways to protect your client's rights.
Mm-hmm.
And one element, once Jennifer was found guilty of involuntary manslaughter on 4 counts, many people were saying, why doesn't James take a plea deal? Was that an option?
It depends. I would anticipate in a case like this that if they had investigated whether a plea was optional that they might want to consider, that the prosecution in this case would say you can plead to the full indictment or complaint, because how would a prosecutor in this case say there were 4 counts of involuntary manslaughter, 1 for each victim who was murdered by this shooter? How could you plead to only 2 or only 3 or 1 for that matter? And so I would anticipate that if the defense went to the prosecution in this case, they'd say, yeah, you can plead to all counts that you're charged with, and we'll go to the judge and you can ask for consideration for a timely plea, saving judicial resources, saving witnesses emotional damages and testifying, but you're going to have to plead to all 4 counts.
But there's another aspect of that too. The victims have a say-so in this, right? And a lot of things happen behind the scenes that we don't see as the public. It could be a situation where the victims, no, we want justice, we want a verdict. You never know what could have happened, in terms of what we don't see. But that makes perfect sense, what Rick just said. But there are other things sometimes that come into play that prevent plea bargains in the case like this.
But you cannot prevent a defendant from pleading guilty to the indictment. You can't say,
right.
No, we don't want you to plead to that.
Exactly.
All right, well, court is resuming. Let's have a listen in.
21. This is 10:39 in the morning. You identified both James and Jennifer Crumbley in Oxford High School.
Correct.
Okay. So this was a surveillance video pulled from that day and that time?
That's correct.
Okay. Now the clock there that says 12:42, that's incorrect.
Correct. It never changes.
Okay.
Correct.
So the actual time is in the yellow at the bottom of the video. It just turned 10:40 in the morning?
That's correct, yes.
Okay, thank you. Did you come to learn who this person was that greeted James and Jennifer Crumbley?
Yeah, it's a school counselor.
It just skipped now from 10:41 to 10:52 a.m. Same view, same exhibit. Who do we see leaving the office?
That's the shooter.
And that's 10:52 a.m.?
Correct.
This is 10:53 a.m. Who do we see?
It's James and Jennifer Crumbley leaving.
Okay. This is James and Jennifer Crumbley?
Yes.
And they're walking out of the counselor's office?
Correct. Back towards the front office.
point in time, James Crumbley was holding a white piece of paper. Now it appears Jennifer Crumbley's holding that. Is that right?
That's correct, yes.
Okay. And he just took it back from her?
Correct, he did.
So they leave the building 10:54 a.m. on November the 30th.
Correct.
So this is 10:57 in the morning.
Correct.
And let me know when you see James Crumbley's vehicle leaving.
Here it starts right there.
Okay.
And turns to its left.
Okay, did James Crumbley stop by his house after that meeting?
No, he did not.
I'm going to move on to, we'll go to Exhibit 140. This is a location data at 11 a.m. Where at?
At Meyer.
Okay. That's November 30th, 11 a.m., and that Meyer is where?
To the west of the school, just down the street.
Is that the Meyer you told us about earlier
Yes, it is.
today? Okay,
That is
so
it.
that's the Meyer you went to on that same day?
Correct, yes.
Okay. And do you know what he does there?
I know he sits there for a while, for a little bit. I think he starts door dashing.
Did he log on to DoorDash yet at that point?
Yes.
Okay. Here's 141. This is 11:24 a.m. And this is that same surveillance footage of Jennifer Crumbley's employer?
Correct, coming back to work.
So she's back to work at 11:24 now.
Correct.
Okay, so this is Exhibit 142. I'm going to go to a Zoom version here. This is November the 30th. This is the DoorDash search warrant return?
Correct.
Okay, so
Part of
you
it.
can, I'm sorry?
Part of it, I'm sorry, yes.
Okay, and so this is just depicting the November the 30th date?
Correct, yes.
Okay. And so he logged on to DoorDash at what time?
11.
Okay, so
a.m.
that's the time he actually logged on.
Correct.
Correct? Okay. So going back to this version on Exhibit 142, there are no logons prior to 11 a.m. that day.
That's correct.
Okay. All right. And in fact, we see his first message was 11 a.m.
Correct.
Right. Exhibit 80, Exhibit 143. Now, the time here at the top corner, that's 11 a.m. to 11:19 a.m. And this is a map that's been created that depicts DoorDash pickups. Is that right?
Correct.
Pickup and delivery?
The route he took, yes.
Okay. And if you would refer back to that DoorDash search warrant return, Exhibit 142, you were able to tell that he had 4 different orders that morning until the shooting?
That's correct.
Okay. So this location history depicts what?
Again, that's the path from the Google search warrant return we used to follow the path down to where he picked it up to where he dropped it off.
Okay. And at any point, did he stop by his house?
No, he did not.
This is 11:19. That's when he got his second delivery?
Correct.
Okay. And Exhibit 44, 11:19 to 11:46. What do you see here?
It shows where his first drop off was to where the second pickup was,
Okay.
and then where he dropped it off.
Did he stop by his house then?
No, he did not.
Next DoorDash order is 11:58 a.m.
Correct.
Exhibit 145 here. This is the GPS locations.
Yes, it is from Google, yes.
What do we see here?
His second drop-off in the bottom part of the picture to where he went back up to the mire at the top side of the picture and dropped it off.
Did he ever stop by his house?
No, he did not.
This is 12:51 for a DoorDash order, November the 30th. 12:51, that's what you told us was when the shooting started.
Yes.
Exhibit 146, what do we see?
Where his third drop-off was at the bottom of the picture in the pickup end of the fourth trip to the drop-off of the fourth trip.
Okay. Did he ever stop by his house?
No, he did not.
Now, what's the first relevant event in either James or Jennifer's devices after the shooting occurred at 12:51?
An email was sent out.
Okay, this is Exhibit 141, or a portion of it. This is what?
That's the email header from the Oxford Community Schools at 1:09 p.m.
Your Honor, I believe this is Exhibit 147.
Oh, what did I say? I'm sorry.
Yeah, that's at 147.
Thank you, 147. So this email was found from a search warrant return on James Crumbley's email?
Correct.
Okay. And it was sent from Oxford Community Schools to james_Crumbley@yahoo.com?
That's correct.
Subject line was active emergency at OHS?
Correct.
Okay. And this was at 1:09 and 52 seconds in the afternoon?
Correct.
Okay. Now, were you able to tell from his data locations where he was when he received the email?
He was he was going to the mire, yes.
Okay, so this is 1:11 p.m. So 1:11:38 seconds, about a minute and a half later, his GPS pinged at that same mire that you went to?
Correct.
Okay. That's Exhibit 148. Now, after that email was received at about 1:09, 1:10 p.m., who did he call?
He called Ethan.
Okay. He called the shooter?
Yes, the shooter.
And that was at 1:13 p.m.?
Correct.
And at 1:17 p.m. he tried to call him again?
Correct, he did.
Okay. Neither phone call went through, is that right?
That's correct.
It's Exhibit 136. Does he leave the Meijer parking lot?
He does for a little bit, yes.
Okay. So at 1:17 p.m., we see a lot of different green dots here. Is this the first data location that shows that he left the Meijer parking lot?
Yes, it is.
So that was after he received the email and after he called his son twice?
Correct.
Okay. That's Exhibit 149. And does he call anybody else at that point in time?
Yes, he tries calling Jennifer.
Okay. That's Exhibit 136. And do we know Jennifer left her work that day?
That's correct, she did.
Okay. I'm just going to show a clip here. This is Exhibit 150 at 1:18 p.m. So this is after he had that 57-second phone call with Jennifer.
Correct.
Okay, we saw that James left the Meijer parking lot at 1:17. Did he go home then?
Yes, he did.
Now, first, did he receive a phone call from Jennifer?
Yes, he did.
Okay, so this is 1:19 p.m. and how long was this phone call?
10 minutes and 19 seconds.
Exhibit 151 is GPS location from 1:20 in the afternoon, November the 30th?
Correct.
Okay, so that's right after he received that phone call from Jennifer Crumbley?
That's correct.
Okay, and this indicates that he was at the home.
On East Street, yes.
Now, at this time, do we know if Jennifer was on the move?
Yes, she was.
Okay, but she wasn't home yet?
She wasn't home yet? No, she was not.
All right, so this is Exhibit 152. Where is she at from 1:18 to 1:20 p.m.?
That's her employer. She Square Lake and Telegraph, south of here.
Now, while she was on that phone call with the defendant, with James Crumbley, did she send any text messages?
Yes, she did.
This is Exhibit 133. What did Jennifer Crumbley write to Andrew Smith? Well, first of all, did you learn who Andrew Smith was?
Yes, I did.
Who's that?
That was her boss at work.
So this is at 1:23 p.m. According to the records that you reviewed. Was she still on the phone with James Crumbley?
Yes, she was.
What did she write her boss?
She said, the gun is gone and so are the bullets. He replies with, I'm praying everything is okay. She says, OMG, oh my God, Andy, he's going to kill himself. He must be the shooter.
Okay. And that was 1:23 in the afternoon on November 30th.
Correct.
Now, did the defendant receive another phone call from his wife after they hung up from that 10-minute phone call?
Yes.
Okay. Going back to the phone log. This is at 1:30 in the afternoon. It looks like a 3-minute phone call between the two.
Correct.
Now, this was at 1:30 p.m. with a 3-minute phone call, so it lasted about 1:33 in the afternoon.
Correct.
What did James Crumbley do after he hung up with his wife?
He called 911.
This is Exhibit 154.
What's the location of your emergency?
Okay, I'm not really sure. I'm at my house. There's an active shooter situation going on at the high school. My son goes to the high school. I have a missing gun at my house. I need an officer to come to my house right away, please.
Okay, I'm not going to be able to send anybody to your house right now. So they're on the active shooter situation right now.
I understand that. There's a million guns here. I have a missing gun, and my son is at the school, and we had to go meet with the counselor this morning because of something that he wrote on a test paper, and then I was in town, and I saw a whole bunch of cops going somewhere, and I made sure that I wanted to get to the high school, see someone going to the high school, and then somebody told me that there was an active shooter, and then I raced home just to go find out. And I think my son took the gun. I don't know if it's him. I don't know what's going on. I'm really freaking out. My son's name is Ethan Crumbley. C-R-U-M-B-L-E-Y.
C-R-U-M-B-L-E-Y. All right, sir, I'm going to put you on hold for just 1 second, okay? Mr. Dr. Cookman, come in and see if I can do anything for you, okay? We'll put you on hold.
Thank you.
Okay, Mr. Crumbley? All right, I'm going to get your name and phone number, and I'm going to have my lieutenant that's out there dealing with the situation. He's going to contact you, okay? What's your first name?
My first name is James.
And what's the name, Crumbley?
Yes.
Okay. And what's that phone number for you?
248-760-6483.
Okay, do you know what your son was wearing when he left the house this morning?
He had on a pair of sweatpants and like a gray shirt. A gray, like, sweatshirt.
Okay. All right. All right, somebody's going to give you a call, okay? I can't give you a time frame because they're right in the middle of all of this. I can't give you a time frame, but we're going to give you a call as soon as possible, okay?
Okay.
All right, thank you. Bye-bye.
That call was made at 1:34 in the afternoon on November the 30th.
That's correct.
And sir, if you know, that was before the name of the shooter was made public.
That's correct.
Now, at some point, was James Crumbley contacted by law enforcement?
Yes, he was.
Okay. Do you know if both James and Jennifer Crumbley went to the Oakland County Sheriff's Office, Oxford substation?
That's correct, they did.
Okay. This is exhibits 155 and then 156. These are location points. 1:58 p.m. for James Crumbley. Where is he at?
That's the location of the substation.
Okay. So he made the phone call from his house at 1:34, and he's at the police station at 1:58?
Correct.
All right. And this is Jennifer Crumbley. She was there at 1:59?
Correct.
Now, sir, we talked in the beginning of your testimony about the multiple phones that were recovered and that you conducted analysis on. Do you have a chance to review the forensic downloads of the other phones as well?
Yes.
Okay. Now, during the course of your forensic investigation, did you find that on a phone associated with Jennifer Crumbley, what we refer to as a burner phone, and an alarm set for December the 4th, 2021?
Correct, it was.
Okay. That's 157. Oh, they're back home at 2:30 in the afternoon at 157. Exhibit 157, is that right?
That's correct, yes.
Okay, so Jennifer Crumbley, 2:30, James Crumbley, 2:30 afternoon.
Correct.
Okay, so now moving ahead to December the 4th. This is exhibits 159 and 160. What are we looking at here?
That's the screenshot on the left side, and then showing the alarm set on the right side.
Okay. Now, from your review of all of the forensic evidence that you had, did it appear that Jennifer Crumbley would leave her phones on throughout the night?
That's correct, she would.
Okay. Now, we talked a little bit about how the cache images were found of that 9mm handgun, but the message wasn't found, and how you have an ability to occasionally obtain deleted content.
That's correct.
All right. Were you able to obtain a Facebook thread between Jennifer Crumbley and somebody named Brian Blash?
Yes, that's correct.
Were you able to obtain any particular messages that were deleted?
Yes.
I'm going to show you Exhibit 161 and 162. These have been admitted. 161, what are we looking at here?
The first box indicates that the message was unsent. And the second one from Jennifer Crumbley is, "We're on the run again. Helicopters not sure where to. I'll message you," on December 2nd at 1:31.
When you say unsent, why is this significant to you?
It says she recalled the message back.
And this is from a Facebook message?
Yes.
Okay, so this is after the shooting. This is Thursday, December the 2nd, 2021. And she wrote, "We're on the run again. Helicopters not sure where I'll message you."
Correct.
Okay. Exhibit 162, later on Thursday, December the 2nd, 2021. Did you find another deleted message?
Yes.
And tell us what that is, please.
The original message was, "We're fucked," and then that was also unsent.
And because it says you unsent a message in the red X, does that indicate to you that it was deleted?
Correct.
Now, sir, you reviewed all of the defendant's phone call history. Is that correct?
Correct.
At any point from the time that James Crumbley left for that piece of paper on November the 30th, 2021, to the time the shooting occurred, at any point in time did he call any doctor, hospital, or medical provider?
There was no indication of that, no.
Now, you reviewed his entire web history as well, James
Correct.
Crumbley's. At any point did you see him researching 9mm handguns?
No.
So the screenshot that was on his phone that was deleted, that was sent from his son to him on November the 8th.
That's correct.
Now, earlier, you described the video that you put together of the shooting.
Yes.
And you spent, I asked you earlier, and I think your response was too many as far as hours. Could
Yes,
you,
sir.
for context though, to lay a foundation for the jury, could you give us an idea of how much time you actually devoted to this?
To that particular video?
Yes.
Oh,
Your Honor, I'm gonna
40 to
object
50
relevance.
hours.
I'm sorry, I'm going to object to relevance.
Judge, the jury's going to see the actual video in a few days. This witness was the individual to put over 100 camera angles together. To do that, he had to watch an awful lot of footage, and he also had to parse out certain activities of students before, during, and after the shooting. The video itself is synced together. There's portions where it skips, and we have to explain why. There's no sound in the video.
Okay, well, you can ask him that then. You can definitely ask him that. Why, it's not one complete video going from beginning to end.
No,
Like,
it was
it's not,
a series of different camera angles.
okay.
Okay. So it follows the shooter's movements?
From the different cameras, correct.
Okay. But you also had to aid in the identification of the victims?
Yes, I did.
Okay. But how is it that you did that?
By where they were standing
I'm
and...
going to object to this as well. I don't know how this is relevant either.
Judge, this is a homicide case.
Well, it is a homicide case. I'm going to allow it.
Thank you. Go ahead.
By where they were standing, I was asked what they were doing just prior to the shooting, the victims were.
So how are you to put that together, though?
I don't understand. What do you mean?
How is it that you used that information to help identify the other investigators who was who? Let me ask you, did you learn what certain individuals were doing directly before the shooting?
Yes.
Okay.
Yes.
And the group of students you identified as Hannah, Kylie, and Riley, did you know what they were doing?
Yeah, they were just standing there dancing and laughing, it appeared, and joking.
necessary.
Cross. Can we approach her? Sure. Microphone here.
Yeah, could you guys turn your mic off?
All right, it appears as though we lost audio there, but we know that the second witness of the day is still on the stand several hours now. But Rick, you said it's because you really need to go over every single bit of evidence in the case.
Yeah, they have to go through the evidence that will be seemingly disinterested at this point, but it's admitted and be argued later in closing or used with another witness, but it's being admitted at this point in time now. But what I caught right before we broke and the direct examination ended was there were some objections to the relevance of some of the testimony that was not objected to in sum and substance initially when it all came in with the commentary of the videotape where the victims were laying and one of the victims was shot, and then the shooter came over and put the gun down to the victim, Tate, and shot him again. His body twitched. One of the victims fell in a fetal position. The shooter was testified to. The shooter went up, placed the gun on his head. All of these things, I think, should have been objected to, should not have been admitted through this witness, because the evidence that was admitted is the videotape, which speaks for itself, and a commentary about editorializing about what was going on was totally irrelevant and should not have been admitted. But you see here right before the break, right before the direct examination ended, there were two objections, one to relevance, where the victims were standing. The others were objection to relevance, what the victims were doing before they were shot. But that all was testified to previously, so, you know, seemingly purposeless.
Okay, we appear to have audio back. Let's listen back into the courtroom.
Standards, they could give you incorrect or misleading information that might unfairly favor one side. So to be fair to both sides, you must follow this instruction. Do not go on social media, do not post, don't do research, don't discuss the case with anyone. We're going to start up at 9 o'clock tomorrow morning. Does anybody have any questions about the schedule or anything in general?
What time do you need us here?
Well, we'll start at 9, 5 to 9. I'll
Not 8:30.
be here. No, but we'll start at 9. So you guys are really good today about coming on time. I appreciate that. So you know, sometimes they want to set their camera up, and there's always, you know, I'm here, but we're moving a lot of people around. All right. So and the court, and we have to go through security. There's all those things. So it takes some time. So we'll go all day tomorrow. We're making really good time, I can tell you that. Anybody have any other questions about the schedule? Any other questions about the schedule? Oh, I forgot to order you to stay healthy, right? All right. And we'll start up again tomorrow at 9 o'clock, all right?
All rise for the jury.
Okay, so court has ended for the day, as we understand. Does this mean, Arnold, that direct examination has ended for this witness, and they're just calling it quits for the day?
Well, we are not sure whether the prosecution is done with their direct or not. We officially will know when the prosecution turns the witness over to the defense. But going back off of what Rick was saying before the break, this testimony has been largely editorial. One of the hallmark of our rules says you can't testify without a foundation. What is your foundation for giving testimony to certain things? Half the stuff this witness has testified to, he doesn't have the personal knowledge, doesn't have the foundation in which to even testify. And so I'm surprised that the defense has not made some kind of motion to strike this testimony or not even let it come in. She's standing up now trying to do it. I mean, that's Johnny-come-lately at his finest. All this evidence is coming out. He has no foundation for a lot of it. It's helping the prosecution, though. So we'll know tomorrow whether or not the prosecution is rested. I got a feeling, or is done with this witness. I got a feeling they're not, because as long as they're getting this juicy, salacious testimony, they're going to keep riding this train.
With no objections.
With no objections, they're on the gravy train. They're going to ride it till the wheels fall off.
All right, yeah, we'll see tomorrow morning where this picks up. So it's interesting, you know, Arnold, you made a point earlier how the defense attorney is staying quiet, sitting back, which does create this interesting suspense. It's almost like we're waiting to hear from her now, and that's probably how the jury's feeling as well.
Exactly. I mean, they're sitting there wondering what's going to happen when the defense gets up and finally starts to put on their case. I would hope that when the defense starts to put on their case, for example, they have exhibits, they have use of the courtroom monitors, the big screens, and can actually try to refute some of the things that the prosecution has gotten out in front of them on. We didn't see that in the first trial, right? You've got to come in and you've got to, you know, give the jury a reason to believe your client didn't know, you know, that his son was going to do something like this. So I'm hopeful that that's what we'll see. Right now, from a tactical perspective, I think the defense is doing the right thing, not jumping in, asking needless questions, making her look bad, making her client look bad. You don't have to ask a witness every question. So right now, she's showing to me that she's a seasoned attorney. She knows that she's in the battle, but it's a long haul. This is not 1 or 2 rounds. This is a heavyweight fight. This is going 15 rounds. Right now, we're in the early rounds and the prosecution is out in front, but it doesn't mean that the defense won't come back, score points in the end, and get enough to acquit her client.
Mm-hmm. And Rick, you know, if you were in the defense's seat right now, what would your approach be in the cross-examination of this individual who you've said has taken things way too far?
Absolutely. The initial testimony of this witness and the purpose of his testimony was as an expert in data downloading of the videos, of the cell phone, and of the Facebook materials. And so anything that went beyond that, I think, is irrelevant and should be excluded as, at the very least, as Arnold said, editorialization. If you have a photograph of a murder victim, and you have a witness who downloaded that photograph or took the photograph, they have to authenticate it and it has to be admitted into evidence, the photograph. So you would ask the witness, is this a fair, how did you take the picture, where were you? Is this a fair and accurate depiction of the scene at the time you took the photograph? Yes, it is. Then the photograph itself is admitted into evidence. The editorialization by the witness who took the photograph is this was a witness, this was the victim who was shot by the defendant. The defendant snuck around the corner and shot while the victim wasn't looking. You know, all of that is inadmissible, and that's what we had here. We had the videotape, which speaks for itself. It was downloaded by this individual, this special agent. The same testimony in the first trial. So the defense attorney in this case had a roadmap of the mistakes made by the defense attorney in the first case. And she should have filed a motion in limine to preclude and prevent all of this editorialization or witness testimony. He wasn't even there at the shooting. He you know, and whether he had to run red lights to get there, and whether or not his muffler hit the curb, and all of these extraneous things, wholly irrelevant and inadmissible in this trial. And so that's a huge mistake, I think, that was made. And unfortunately, it's too late to object, as she did in the end of the testimony. I do think this witness is through with direct examination. I think the defense attorney asked for more time, didn't want to be interrupted, start her testimony, her cross-examination and be interrupted. And so I think that was a tactic in order to get some more time to prepare tonight. I think tomorrow we'll see cross-examination first thing in the morning.
All right, well, thank you so much. We are going to go to a break.